Behind every crime lies a story waiting to be uncovered, from chilling mysteries to untold truth. This is where the darkness comes to light.
Green buzz lights up the air, faces tense as stories tear, truth and lies like a tangled dance. Justice here takes no chance. Gavel strikes, hearts beat fast. Witness takes, then shadows cast. Whispers loud like wildfire spread. In this game, none's ahead.
Hello, good morning, everybody. Hi, hello. I am so sorry. I fell asleep. I was taking a nap here before before I started stream because all in a rush. I was like, oh, I'm gonna like shut my eyes a little bit and I will sleep. Good morning, Willow. Good morning, Lois. Hi, Paula. And I was like, oh, okay, like I will sleep. I did ask Garden Bot to wake me up, and for one like quarter to wake me up, because obviously so I could be on time and I could be doing things. No, he did not wake me up, and then I just wake up, and I'm like, okay, it must be almost time to go live. Well, I think it's about 10 minutes. And I was like, oh no, but then the feed is already up. Oh, good morning, Jet. Hello. Welcome in, Jed. Nice to see you. I didn't even finish getting myself ready, and now I am absolutely freezing now. So give me just a second to put the sweatshirt. How is everybody in? Good morning. Today is Tuesday. I went back to work today, and I did not want to. I was like, the alarm went off at 4 o'clock in the morning, and I was like, I don't want to, please, no. I just was absolutely so hard to get up. So did not like that. Was not looking for that. Oh, good morning, journeys. Welcome in. Good morning. I will be on camera in a second. I just need to kiss. Oh, I am so glad that my weeks now ends on a Wednesday. I am absolutely so happy about that. It is cold, and also today, guys, it's a very busy day on True Crime World. So we have our trial now. The Jason Levesque a trial that we are following that is really literally finishing. And then there's a new trial that starts today. That's gonna be possibly our next new trial. The Nicole Nicole Rice, the roommate and Aliving trial. That should be probably our next trial. There's our friend, our friend, I use that word loosely. Our friend Lori Vallo has a hearing today. It should be her final hearing before the trial. Ooh, Journey. I've been following that. Is that the new trial for Moksha? I think it is. The young man Nikita Grasp. I think he's from that area. I was listening to a podcast the other day about that case, and I am so invested in it now. So Karen Rita has a hearing as well today, before her trial starts. So there is a lot of movement today for sure. And I am cold now because all the sudden I woke up. That nap, it was only like a 10-minute nap, but that nap gave me the strength and gave me, I think, the motivation to the rest of the day. I feel rested actually. It was only like a 10-minute nap. Oh, we are not live. There we go. So absolutely, it's gonna be a great day. A great day for true war crime. There's a lot happening. There's other trials starting, but I don't know if those ones are gonna like have a feed or not. So it's just yay, England represent, journeys. um it is it has been already a very intense, and it's very sunny in England today. Literally, it is cold. I'm trying to see in Fahrenheit what it is. It is 47 degrees today, which is still not cold, but in the morning was way colder. But it is very sunny today. So it is a beautiful day to spend it inside. So which is good. So there is a big a lot um a lot of happening. I want to cover the motions for obviously Lori Vallow, because that's gonna be our next trial. Because when Lori Vallow starts, we are gonna be covering that one. Um, Oh, no worries. Thank you very much, Jed. I really appreciate your help on harding work for the channel. I really appreciate that. So Jed is my other half, for those that doesn't know, but he keeps using the wrong account anyway. Um, oh wow. And the next day was snow. Wow. It's like the thing is here, it's been very quite nice, very mild, but then all of a sudden it went down again. Good morning, Stephanie. Hello, hon. We are early today. It's the one day for the first time ever that this court has been, well, it's supposed to start early. I am still setting up things because me just having woken up from my nap, I'm still adding things. So, oh wow, 5 inches of snow. That's, well, to me that's a lot. Sorry, excuse me. But yeah, so it's a lot of happening. Now, when we need to figure out when we're gonna get the Lori Vallow hearing, because the thing is, it starts at 10. I think it's 10:15 Eastern. I think. Hang on, let me, no, 11:15 Eastern. I think the hearing. So, I was thinking that if it is about an hour long, the hearing, we probably can cover it on lunch break, and then we can see it there, because although tomorrow, because they are supposed, in this trial, they are supposed to do, I think, closings and verdict, closings and everything tomorrow, and then we'll be on verdict watch tomorrow for this, when we can start a new trial when on deliberations, and then we'll be up to date. But otherwise, I don't know when to watch the Lori Vallow hearing, because obviously we need to know, because just to make sure that, I know it is like, this trial was not supposed to be this long. The judge already wanted to be finished, but because in between of them starting at 10 a.m. Every day, finish at 4 o'clock, Friday finished early. Yesterday did even had a day of testimony. True, was not because of nothing the attorneys did, but still that puts behind. So the judge already, like, this trial was already not gonna be supposed to be on day 5 like we are. It's not the saying that he was unhappy, but is that the case that he was not very happy about the fact that it's prolonging, because he wants this case done. Hey, good morning, Pickles. Good morning, my friend. Hello. So don't forget as well, by the way, people, to start playing the verdict game. I have already. Oh, I am still thinking about about the price for this game, because of the short time. I'm still haven't thought about it, but I will think about something. Willow, you know what? I am waiting for that, because I don't know if you guys, but there's a Reddit group community thing that I follow. The girl normally comes and hangs out with us in the channel. It's our cases we follow, and from one of the posts that is there about this trial, right? Apparently, and I'm quoting, apparently the victim Jason Kyle has posted something on there. But the thing is, I don't know if it is actually him or not. Um, well, yeah, because they got definitely hacked on Friday morning, so it is crazy. Hopefully they have. So apparently there's a post on one of the days that I've been posting about this case that someone says I am the victim in this case, but it's not like. But the thing is that is making me doubt is he spells his own name wrong, uh, and then, oh, oh, really? Oh, I know. I've seen that one, Journeys. I've seen that one. The about the Menendez brothers. Yes. I have seen that one. It. I would be interested if it comes to for sure to trial. That's definitely it is keep an eye on that one for sure. But yeah, so like I was saying, that person posted on a Reddit subgroup saying that is the victim in this case, and he wants to talk about this case. But yet, then it goes to the prosecution saying that it's too PTSD to testify, but he goes to a Reddit subgroup to talk about the case. But I don't think it is the victim. I have my doubts. Because, first of all, spells the name incorrectly. I know I spell my name incorrectly, but that's me. Because I'm crazy. And it doesn't give anything new about the case. It only gives all the facts about the. Oh, I need to send you the link, Pickles. Let me grab it and I'll send it to you, and then you can tell me what you think about that. Because I would love. Let me grab the link and do that now before I forget. Be because otherwise I will forget, and you know how I am. I keep forgetting things. Half of the time. There you go. I sent you the link, my friend. So absolutely, I doubt it. I doubt that it is the person, not just because of the fact that he spells the name wrong. Yes, yes, Pickles. But I've already DM'd you. Yeah, I've already DM'd you on Discord about it. So I'm doubting that it is the victim. First of all, if he's too PTSD to testify, I don't think he's gonna go on a Reddit subgroup or group or whatever and talk about the case there. And also, it's the fact that prosecution and defense attorneys could see that, and then he could get even in more trouble. I don't know, because he says now that he's not gonna testify because of PTSD and everything, which plausible, which is very true and very possible to happen, but just not that now he goes on a social media thing and talk it. But this was the beginning of the trial, so just very doubtful. I don't know. It is very interesting, but it doesn't give anything new. He only talks about what we already know and anyone can know about the trial and out. So, oh, Stephanie, I'm so sorry. Well, like, don't send snow over here because I don't want snow. But I definitely, well, I do want a little bit more warmth, because I am done with the cold too. In fact of thinking, don't send anything over. I'm fine. Um, yeah, true. Oh, I think the cameraman is having fun with the camera today. Was like that's true, but I don't think if he would be that bad to come into court, I don't think he would be, um, yeah, testifying. Yeah, I don't think either, Pickles. I agree with you, my friend. So it's just, yeah, it is. Um, maybe, yeah, but then that could be very, very, like, if he's trying to get justice for his accident and for what happened to him, posting on social media during the trial, I don't think that would be the best choice of movement to do, in my opinion, because that could well, not hinder the justice, because the jury probably not seen, but people on Reddit cannot do any justice. The best place for him to get justice is in a court of law. But that's just my opinion. I don't know, what do you guys think? What do you think so far about the case as well? Because I don't know. I don't think I am on the not guilty side. I'm sure he is guilty and he was not self-defense. But the fact that Kyle is not testifying, it could be a little bit more difficult. Yes. Yes, he did. Yeah, Pickles. That person that posted. Yes, someone's only created that account on the 15th, and that was the only comment. And there's no other interaction of that account with any other posts or any other comments anywhere else. So, yeah, that's the thing, isn't it? Because I think there is a very high possibility that we're gonna get a not guilty. I don't like, in a way, I don't know, because do you think Jason is gonna testify? Because if Jason testifies, Kyle doesn't, I think he's gonna get a not guilty. Yeah. Yeah, definitely. Yeah. It's I agree, but then the thing is, if Kyle doesn't say his side, and I know PTSD is a very big thing that can in the how you like move and how you function and everything, literally affects every single aspect of your life. But then again, it's the not testifying that it is makes his case worse. But then if Jason testifies, I think it could be bad, and I think we can have a not guilty here. I know. I think it is. I think, and I'm finding that as well. I only have so far two answers of all of for the verdict game. So I mean, is the good thing that you. Yeah. Oh no. Yeah. Absolutely, Lois. I absolutely understand that, because I know that is a case that you really like and you want to follow it. Absolutely, my friend. I really appreciate your help. Thank you very, very much, my friend. Yes, absolutely. Yeah, that's true. Oh, I am on the TV. Hello. No, I'm joking. Sorry, this was just for Paula on the TV. For Paula, followers. Yeah, I think I agree. I think I haven't given my answer either. I haven't. Well, I play. If I will never win, but I still play for the fun of it, because I want to to play, to be part of it. The thing is, I might still keep an eye on Karen Reed, but stream it now. We are definitely gonna be doing.
You all may be seated. We on the record? All right, so this is the State of New Hampshire versus Jason Levesque. This is 2024 CR 273. Before we begin, I want to deal with a few preliminary matters based upon our hearing yesterday. First, as you've seen, I provided the parties with my order denying the motion for a mistrial. As you can see, I have applied the standard that a mistrial is appropriate when the circumstances indicate that justice may not be done if the trial continues to a verdict. And I think to constitute a mistrial, the conditions complained of must constitute an irreparable injustice that couldn't be cured by a jury instruction. I think when you apply that standard, as I've outlined in my in my written order. I don't think that the circumstances currently before the court rise to that level of prejudice that would constitute the need for a mistrial. Obviously, defense, if you want to put anything on the record at any point, expanding on your motion or your argument, I'd be happy to allow you to make that record when you feel the need. But
Thank you.
you're welcome. All right, so moving forward, in terms of the motion to dismiss, I think it's most appropriate that we simply defer that and take it up at the standard time for a motion to dismiss at the end of the state's case, which we will do when the defense presumably makes their argument at the half. So I'm going to defer ruling on that. In terms of the request for the missing witness instruction, I have reviewed the case law in New Hampshire on that matter. I've reviewed some federal case law on that. I have looked at, particularly at Massachusetts case law, which I find particularly instructive. And having reviewed all of that case law, I am not inclined to grant a missing witness instruction in this case at this time. And I'm going to explain why. I mean, I think when you read all that case law together, it is pretty clear that the complaining witness in this case is in the state's control, as that term is normally used, meaning that the complaining witness is most closely aligned with the state, would be most likely expected to testify on behalf of the state, that the state has better access to the complaining witness than the defense does. And so even though, and the case law makes clear that the question of availability is more limited to the question of can you locate the witness and bring them to court. And I think in those terms, I think the witness is available. But I do think this witness is in the state's control, as that term is used. But I think the reason I'm not inclined to grant the missing witness instruction is when you read the Massachusetts case law, and in particular, I'm most struck by looking at Commonwealth versus Salatino, which is 449 Massachusetts 657. That's a 2007 case out of Massachusetts. And Commonwealth versus Figueroa, 413 Massachusetts 193. That's a 1992 case. Both of those cases make clear that the missing witness instruction is most appropriate in circumstances where a witness who is in the control of one party, who has material evidence and would be expected to testify, is not called without explanation. And that, I think, that factor or that element wasn't really discussed at the hearing yesterday. Salatino makes clear it's when the witness is not called without explanation. And in this case, the state has offered an explanation as to why it does not intend to call Mr. Violette in this case. Particularly, the state discussed the witness's unwillingness to testify, the emotional stress that the witness was under, the fact that the state, having prepared this witness, made the decision that it did not think it could put this witness on. The mere fact that that's partly a strategic or tactical decision does not take it outside of that analysis. And if you read Salatino, and I also point out, Salatino makes clear that a missing witness instruction should only be given in clear cases and with caution, because it is such a potentially devastating instruction to give the jury. So, but Salatino says the missing witness instruction is appropriate when a party has knowledge of a person who can be located and brought forward, who is friendly to, or at least not hostilely disposed toward the party, and who can be expected to give testimony of distinct importance to the case, and the party, without explanation, fails to call the person as a witness. And in Salatino, the court goes on to say that the instruction should not be given where the Commonwealth has a legitimate tactical reason for not calling the witness. And if the circumstances considered by ordinary logic and experience suggest a plausible reason for the non-production of the witness, the jury should not be advised of the inference. And I think that is the case here. There is a plausible reason, a legitimate reason why the state has chosen not to call this witness. And in that circumstance, I don't think that the adverse inference would be warranted. And so I don't think it would be appropriate to give the instruction to the jury that they can draw that adverse inference. I'll also point out that the law in New Hampshire is clear, as well as in Massachusetts, that the missing witness instruction is discretionary. The court has discretion to grant it. Neither party can demand it as a matter of right. And that I think the denial of the request for the missing witness instruction, I don't think rises to a constitutional level of a due process violation. So for all those reasons, the court is not inclined to grant the missing witness instruction in this case. And so that's where we are at this point. All right. And obviously, again, defense, if you wish to make any further record on that point, you're welcome to, and we'll give you an opportunity when you would like to. Thank you. All right. So with that, I think we've resolved those preliminary matters, and my plan was to go ahead and have the state call its next witness, which was the police detective, and then we would move forward.
We have an issue on for the court concerning the scope of that testimony, Your Honor.
Okay.
Next witness is, we're all aware, is Detective Garson, who did, among other things, the interview of the defendant on the night immediately after these events. There is a body cam image of it, and there's also a full transcript of it. The state intends to proceed by transcript for reasons of efficiency and also notions of redaction. That it is easier to proceed with the transcript because it's the state's position that certain aspects of the statement are not admissible. But a brief conversation with the defense concerning that. In fact, I brought it up before trial, but we've revisited it now and continue to have a disagreement on it. And it's this. The defendant in this case, when he was explaining the events of that night, also made reference to a prior event from approximately 2 months preceding this event, where Mr. Levesque claimed there was a verbal altercation between the defendant and the victim, where he alleged that the victim called him, quote, a rat for calling the police on him, and again threatened him and, quote, his family. He didn't do anything as a consequence of that in terms of like calling the police or anything. He said he had no intervening contact with the defendant and couldn't pick him out of a lineup. Saw him maybe between those previous 2 months act and this event, saw him maybe take out the trash. Wasn't even sure if he lived there. And yet now, apparently, they intend to seek the admission of that to advance the self-defense claim. The state's position is it's not admissible. I reviewed State versus Newell. Unfortunately, we are still at a loss, technologically speaking, and I don't have a copy of the case. But nevertheless, I'm familiar with the holding and the principles of it, which is that, and by the way, it's cited in the notes to 404 and 405. It comes down to this, that the defense, in my view, if they wanted to introduce this, should have filed a 404B motion just on the threshold of relevance for another issue besides propensity, even concerning a victim. Had the court even ruled as a second step that it was admissible, it's constrained by the admissibility requirements of 405. 405A deals with relevant traits, and 405B deals with relevant elements that would be subject to evidence concerning peacefulness or aggression. In this instance, we're talking about traits, so it's limited to opinion testimony, and only the opposing party can cross-examine then on issues of specific instances. If it were an essential element, the proponent of the evidence could introduce specific instances, but in State versus Newell, our Supreme Court concluded that peacefulness or aggression is not an essential element of self-defense. It may be a relevant trait, but that would then be constrained by 405A. Again, this all presupposes that there was an appropriate 404B motion to actually tease out, to examine for the court to assess the actual evidence concerning the claim. We haven't gotten there, but even to the extent you're able to take a look at the transcript, the state's position is it's not admissible under 405B.
Attorney Sisti?
Thank you, Your Honor. And I appreciate getting this vetted right now. A couple months prior to this event, Jason did have contact with the alleged victim in this case. The reason we know that is because the police asked him about whether or not he had had prior contact with this individual to see what their relationship would have been and what was going through Jason's mind at the time of the shooting. Let me tell you what went on 2 months before this. He had had contact with Kyle, and Jason's recollection was, he said, that meaning Jason, when this first contact with Kyle took place, I don't know what to tell you, I don't know who you are. And then Jason would say, and he kept just kind of giving me a hard time about it. So I just walked in the house. He must have gone inside. Then, like I said, I didn't see him. After a while, I was in the driveway and he walked by. But he did have another person with him, a friend with him or something. He began, called me a rat, told me he was going to fucking kill me, kill my family. And then his friend said, come on, let's go. And he moved him along. That was a contact that was given to Officer Garson in this statement. And there's reference to it more than one occasion because the officer wants to know whether or not, obviously, whether Jason did anything to get this guy angry at him. And he actually asked Jason what that interaction was all about and what it resulted in. And Jason's recollection was that he was enraged, that meaning Kyle. He seemed as though he was paranoid, claiming that Jason had done something that he had not done. He described him as mentally ill. In fact, I think he described him as psychotic. It was gratuitous. He did nothing to take on that kind of anger from Violette. And he went into some detail with the officer because that was the foundation of how he knew Kyle Violette. And it was surprisingly similar to what took place on April 4th, 2024, when gratuitously, in Jason's mind anyhow, he was approached again by the same individual acting out of control and enraged and threatening to kill him and his family. Almost the same type of pattern. Additionally, I can tell you that this actually scared him and his daughter to the point, and this goes into the statement as well, that when his daughter would come home from work at night, she would call from her car to Jason so that he could go down and bring her into the house, escort her into the house. So there's some history between the two. It's not a wonderful history, and it's not a lengthy history, but it's a significant history. It's a history that concerned him about the specific alleged victim in this case, and was concerning because his life and the life of his family was threatened before by the same individual that he had contact with on April 4th in the evening. So, again, it's in the transcript that was developed by police inquiry on the subject of what was going through Jason Levesque's mind when he came upon Violette. Part of what was going through his mind was being placed in the same situation, a similar situation that he was placed in 2 months before, and that it was an enraged individual that had no basis for coming up with the statements that he came up. 2 months before, Jason had done nothing to cause that kind of a reaction. And on April 4th in the evening, he had done nothing to cause a death threat on the part of Violette. So, it is part and parcel of a police interrogation while he was being questioned by the police at the Rochester Police Department. It certainly does touch on very important issues with regard to this case. And you know, the state's talking about me having to file a 404B motion or a motion to limit. If they wanted to cut out and redact a defendant's statement, one would have thought they would have brought that to the attention of the court prior to right before placing the officer on the stand that actually questioned Jason about the very subject they're trying to eliminate. It's relevant. It goes through his state of mind. It goes on how they're going to keep this out. I mean, it's part and parcel of the totality of the statement.
Well, is the argument, I guess I'm confused a bit because there's sort of different levels of argument that have to be teased out. First is the hearsay issue, right?
No, it's an admission by
but that's not, I mean...
Mr. Levesque is giving a statement to the police. It's admissible. They're putting it in.
Well, they're putting in the admission, they're putting in admissions from that statement.
Well,
are you arguing that the whole thing has to come in under the doctrine of complete? I mean, the state's not required necessarily to put in
well, I think if they
the self-serving, the statements that they believe are self-serving or that don't fall under the exception to hearsay, do they? Because they're not.
I think in the doctrine of completeness, Your Honor, that yes, the statement does go in. And if you want the complete picture for the jury, it goes in. Now, if they want to carve out some crazy irrelevant thing, that's fine. But this isn't crazy irrelevant. This was the subject matter brought up by the police on the night of the shooting. Right? The contact that he had with the alleged victim in the past. This is hardly some remote, strange subject matter. It's what anybody would be asking anyone in that kind of situation. Did you know this guy? How did you know him? Why would you have been afraid of him? Here's why. I mean,
so 801's exclusion says, hearsay doesn't apply to a statement that is offered against an opposing party and was made by that party.
Right.
Hold on 1 second. Well, what's your position on that, State? What's your position on the hearsay issue, and what portions of this statement do you believe are excluded from the hearsay rule under 801?
Yeah, if you could bear with me and just go one step further back to this defendant's statement that, hey, look, we don't need to file the 404B motion because the state's introducing aspects of this transcript. Let me be clear, we're not the proponent of the prior bad acts on 2 months before this incident.
Right.
So that analysis, I think, is entirely misplaced. In terms of the completeness doctrine, then, there is no bearing on the description the defendant provides concerning the relevant material acts here, which is the defendant's statements and his movements during the course of this particular night on the 4th, and the events from 2 months earlier. This just creates this classic sideshow of a trial within a trial. And on that point, Judge, had the defense litigated this issue, we would have had the opportunity to, for example, bring Kira in here to assess and weigh the actual scope of it between two witnesses. I just heard him say that Kira would make phone calls to get picked up from the car when she came home from the, in the driveway or something. And I read her statement, and there is no reference to that happening. She says, I don't have any personal knowledge of it, but my dad claims that there was an incident some time ago, and he'd come out and get me. He came out and get me. It's referred to in the singular. And she revisits that later in her interview and says, can you talk about any, fear for this guy? No, I wasn't in fear because my dad was there. We've gone through that. I've had a few times I've seen him and he gives me a weird vibe. That's hardly a lunatic next door that they're trying to make this claim. And the fact that, like, out of random, when my dad had to come get me out of my car, that was there was nothing to provoke it. And also, I just don't trust people. And so the gap between Kira's assessment of it and the defendant's claims just now are significant as a point to merit a 404B hearing. But that aside, the completeness analysis would require the state to introduce a statement or a portion of the statement that was somehow unfair and would be recast by the excluded, redacted section. I can tell you, I suppose we can take it as it comes, but I certainly don't have any plan to, broadly declare you have no prior history with this individual. Oh, that's not quite accurate according to his statement, but I'm not going there.
So let me clarify. So there's how long? The transcript's like 100 and something pages, you said, right?
Yes, about 156 pages.
And how many pages of the 156 does the state intend to put in as evidence?
Quite a few.
Sorry?
Quite a few.
And what do those sections that you're putting in relate to?
So they relate to the defendant's initial description of the events that are frankly not in dispute. Confirming that he was able to speak accurately, willing to speak accurately about preliminary innocuous events. Then it goes into the area of his claims about why he drew the firearm and the effect of brandishing it. He makes essentially two sections of claims. The initial section is before Garston has seen any video and before the defendant has consented to any video. He doesn't consent till about page 66 of the transcript. And prior to that, he's committed to this. I pulled out the firearm. What was the Kyle's reaction? He became enraged and charged me. That's demonstrably false and at odds with the video. He charged me, and I had no choice. I think he was coming at me to attack me. He was coming at me to take the gun. I could tell by, the look in his eye. And so what did you do? I fired. What happened then? And by the way, Garston hadn't seen the video. He didn't seem fazed by it. He didn't flinch. He continued towards me, attacking me. All of that is coming in to show that the defendant was creating, manufacturing a self-defense claim until the jig is up. Then we've heard a lot about, he consented to video, but not yet. And he goes on to say, by the way, that, why did you fire the next 5 rounds? Oh, I fired those because he was continuing to come at me. Did he go to the ground after the first shot? No, he doesn't seem to be affected by it. He got more angry, and so, did you move towards him? No, I stood still, and he was coming at me, and I fired 5 more rounds just to stop him. And did these hit him? Yeah, I think they hit him because he walked away holding his abdomen.
Okay, but I'm just trying to get clear. Thank you, but I'm just trying to get a sense of the section you're putting in.
Yep.
Is it all sort of one continuous part of this interview, say like 40 pages of it all continuous, or are you selectively cutting out little bits? Are you seeking to put in a contiguous or continuous section of the entire video?
So the short answer is no, but it's not to play sharp with the facts. It's, you know, the detective, like most, are trained in the read analysis, as you may know. That sometimes includes looping. In other words, they will have a defendant make a statement. It's kind of open. Defendant puts it out there. They'll go on to other areas. Then they'll loop back and, hey, I want to revisit this issue of actually brandishing the firearm. And so I am following along the fundamental narrative of brandishing the firearm, the first shot, and the second rounds of shots of 5. Those are repeatedly, you know, restated, but again have no bearing on, you know, at the time. I'm thinking about 2 months ago.
And is that part of the interview, the part about the 2 months ago incident, is that...
That's embedded.
Is that an entirely separate part of the interview, or is it all sort of embedded in part of the interview?
I can't quite say that. So at the beginning of the interview, when he, for instance, talks about, you know, I was out plowing, I came home, I did one swipe, I was changing. For whatever reason, the Garson asked, well, how do you know the guy? Oh, you know, I don't really know him. I think he's my neighbor. But 2 months ago, he was walking by and said, you're a rat. I'm going to kill you and your family is the claim. We haven't vetted that through any process, but that's the type of interspersement, but it doesn't have anything to do with. And so why did you brandish the firearm? Because he was coming at me, not because I have some historical reference or fear to him. Those are completely divorced in the transcript and in the conversation. You know, one does not modify the other.
Because as I look at this issue, in the first instance, I'm trying to grapple with the completeness question, right?
Yeah.
Whether it's fundamentally unfair to the defendant to pick and choose sections, and whether it would be misleading to the jury and unfair to the defendant to sort of carve out little bits of the narrative if they're part of his narrative. I understand the issue of that prior statements of the defendant don't get to come in through the defendant because they're hearsay. The state can put them in because they're admissions. But there's a question of fairness under the completeness doctrine.
I agree.
Which is separate from the 404B analysis, which is a whole separate issue.
Yeah, I agree. You know, an opponent of this could create misleading impressions, and you know, if I'm having a really bad day, I suppose I could do that, but it's certainly not. I'm aware of the issue. I can tell you that the transcript standing alone doesn't suggest anything close to an innate unfairness or completeness doctrine. It's not baked into the narrative of what happened that night. These are background questions that the detective asked concerning, as you would expect, you know, what's your history? But that didn't have anything to do with, was he coming forward or not? Did he stay on his feet after he took a shot to his head? Where was he when you came over and unloaded the next 5 shots at him? Oh, he was coming at me. Right. Those aren't modified by a reference to some prior comment, even threat that the defendant, that the victim may have made.
All right. Attorney Sisti?
Yeah, I think we all better take a breath and, you know, read some case law here, like State versus Warren in 1999 that had its birth right in the very courtroom and was reversed because the totality of the statement was not introduced at the time of trial.
Yeah.
In a manslaughter case, stabbing case. I think, quite frankly, you know, I'm sitting here going, why are we editorializing what's going to be said? Why don't we just plug the statement and play it for the jury?
Well, it's very difficult for me to issue a ruling on this without seeing it. I really think it would be helpful if I could see the unredacted and the redacted and sort of, do you have a redacted one that you were prepared to?
I didn't black out anything, redact. Simply my outline was, and my manner of examination of the witness was going to be, did you ask him about brandishing the firearm? Yes. I'm going to turn your attention to page 33, line 12, and can you share your question? Did you brandish the firearm? You know, why? and then have him provide the defendant's answers.
Oh, so you're not putting it in
No.
the sense you're not, I thought you were actually putting in the transcript as an exhibit.
Nope.
No. You're just going to be asking him questions about what the defendant said during his interview and
That's right.
leaving out and focusing on the parts that you think.
That's correct. My decision about whether or not the transcript or portions of the transcripts come in was a function of the totality of this experience, that is direct and cross. If redirect, it requires, in my view, an actual transcript because things get messy. I may move to introduce portions of it, but in the first instance, I had not redacted, not knowing the scope of this.
All right, because I'll say I misunderstood then, because the way it was framed was that there was a redacted version of the interview that was going in, which now I'm hearing that's not what's happening. So the question is, you're going to ask him questions about what the defendant said.
My reference was redacted by omission. We're just not going there.
He's going to talk about things that he said. You presumably at that point are going to then on cross want to ask the officer about other things that were said, and those are going to be subject to an objection at that point, and we're going to have to figure that out at that point. But I suppose we may want to talk about it now.
Yeah, we might as well talk about it now. I guess I'm going to say let's play the whole thing. What are we doing? I mean, you want an accurate representation of what Jason was like on that night? You want to see what he was like on that night? You want to hear him speak? It's not what Attorney Barker Isay said, or how he said it, or what he looked like. It's for the jury to make those determinations, what was going on with regard to him. After 40 hours of no sleep, by the way, and being interrogated at the Rochester Police Department. Now, the doctrine of verbal completeness, if he's just cherry picking, all right, it's the same issue. We might as well get that out there now. And there's actual case law that speaks to it. It goes way back to civil stuff. In the beginning of the 1980s, and an opinion, I think it was from Justice Souter, Annington versus Hubbard or something like that. But it's really emphasized in State of New Hampshire versus Warren in 1999. I mean, this is you can't just cherry pick, especially in situations like this where there's a police-directed interrogation. I mean,
You can't cherry pick, but we adhere to the rules of evidence, and that's what I'm trying to do. We don't simply say, the entire truth, set it free.
Right.
We're constrained by rules of evidence. And two, there's nothing about recent case law that recasts the completeness doctrine as something broader than this basic principle. Is it unfair by presenting one aspect of a statement that should be modified by a more complete version of that statement? And my position is I'm aware of that principle, and none of this invokes it.
And I think it's going to depend on the particulars of any particular statement and the part of it. How close in time this other provision that you want to bring up is to things that you've brought up, and whether it's sort of intertwined and embedded in those conversations. And that's going to require looking at the specific information that defense wants to elicit from the witness and how it fits into the testimony that you elicited. Would you agree? I mean,
Yeah, I understand. I think that's an accurate statement of what we live with in terms of a completeness doctrine. Anytime there's a broad statement that gets granulated with inadmissible statements, and this is just an inadmissible statement under Newell, and as a starting point. And now, am I going to elicit something that would be unfair without providing the statement concerning the prior event?
Well, this specific information about prior offense by the same individual is admissible, all right, in a self-defense claim. What's in his head about that individual is part and parcel of a self-defense claim.
Well, but it may be admissible from your client talking about it, but that doesn't make it admissible in a prior statement, which is hearsay.
Which is not hearsay. I'm stating it's not. It's coming in.
It is from you. You can't put it in.
It's not coming in from you. They're starting this thing, okay? But they can't just pick and choose, and that's what
Well, the
worries
picking
them.
and choosing, that's the completeness doctrine. Picking and choosing is the completeness doctrine. That's separate and distinct from the hearsay issue, which is you can't put in your client's prior statements for the truth of the matter because they're hearsay. They have to come from him if he wants to testify.
Understood.
But you don't get to put them in yourself. But if completeness requires them, then completeness requires them.
That's what I'm saying. You're asking whether this is some kind of a segregated part of the interrogation. No, it's not.
Well,
it comes up more than once. And, you want to talk about cycling and all this other, techniques of interrogation. Well, it comes up more than once.
All right.
The police officer is interested in it. He wants to know why this happened that night, who this guy is, what the relationship was. And I'll tell you right now, it wasn't good. It wasn't extensive, but it was a similar or same threat to kill him and his family.
I think the only way I can effectively rule on this is I got to look at it. Take a few minutes and look through it. I also do want to go take a quick look at the Warren decisions and case law. I hate to do this because now it's 9:44. We've had the jury sitting for 45 minutes. This case is anyway. I'm going to editorialize it. Everyone's doing their best. I understand that these things happen. Obviously, so let me want to give you the statement, please. I'm going to take a few minutes off the bench to look at it.
I have a statement. I don't mean to be presumptuous, but I also have an outline. This is without editorial comment, which could direct, for instance, the court to page 43, unless you want to just do a clean read.
I think it should be a clean read. And in fact, it should probably be marked as an exhibit.
Well, we'll see. I mean, as through the testimony, I'm going to need to probably have this in front of me because when objections come up and questions come up about, well, I want to ask him about this. The only way I'm going to be able to rule on that is to have some sense of the whole document. I think.
I want to make sure I give you a clean.
Yeah, this is clean from what I can see. I don't see any other marks in the account.
Yeah, mine's here.
Obviously, if I saw marks in it, I would be worried. No marks in this. All right, just take 5 or 10 minutes. Give me a chance to get my head wrapped around this. I apologize to the jury, even though they can't hear me. I'll be back. All right.
And with this, we are already an hour behind. So yeah, just every day, let's take a break. So we were supposed to start with the jury at 9 a.m. because we lost yesterday's day with the cyber attack and everything, and then they had motions to go through, so they did that. So today we got the response on the motions that the defense did yesterday. So basically, the judge denied every single motion. The motion for mistrial, the motion for the missing witness, and there was another motion that was mistrial, missing witness, and then there was another motion that apparently I did not write it down, but it got denied. And now there is more motions because obviously now the state has its last witness. I know, Paula. They don't help at all. They only make you want to sleep. And now they are arguing because the state's apparently last witness is the lead detective, or one of the lead detectives of this case, that interrogated Jason after the incident, after what happened, and then the defense wants the whole thing in. The state only wants to introduce certain parts of the testimony, so that's why they are arguing you now. And they presented case laws and motions and the 404 something other. I need to start learning the name of these motions, but probably not, because I don't want to become a lawyer, so I don't need to know them. But it's just interesting that yet again we're wasting another hour's time of this on this case, because we've already lost a lot of time in this case overall, with all the breaks and finishing at 4 o'clock. I don't understand, right? For a judge that wants the case to be done, rather quickly, because probably there's other cases and calendars are like chock full in every single state. Starting at 10 a.m., finishing at 4 p.m., that's a very cushy trial. And then have an hour break for lunch. That's 5 hours testimony, 4 hours testimony at most. So it's just, I just, like, oh my days. But now I can wake up Polar again because I can talk. No, I'm joking. Sorry, you gotta have to listen to me again for the next 10 minutes. Because already yesterday we were supposed to have all the motions, and that's like, oh yeah, ugh. Maria, it is not well on your side. I am trying to make it well on mine. I need to boost it more, but it's just this. Oh, Paula, thank you. This court has been one of the worst courts in terms of sound that we have caught in a while, in a hot minute. I am really hoping that this new trial that's starting today, the Nicole Royce, it is a better sound than this. I am really, really interesting. I know, I get it. It's a bit to my perfectionist. I understand. I appreciate that. Thank you, Maria. But it's, yeah, I am really, like, you guys know me. I like court cases. I don't like following the same case for a long time. I'm always, like, 5 days, I think it's the most that I do in a case. Ooh, Stephanie, would you like to share? I would love to see that. That is an awesome thing. I want to do that, but I simply don't have time, and I just like to the randomness of the cases that we catch. I see something on the yeah, definitely share it on Discord. That would be amazing. Please tag me and Willow and everybody. But yeah, that would be amazing. Or send me over on Facebook, and then with your permission, I share on Discord with everybody and give you credit if you're not on it. But that it would be awesome to have. Oh, Stephanie, I would love you for that. I love you no matter what, but you know what I mean. But I like my randomness of jumping into trials, but it is nice to look forward to a specific case. For example, there's a case that I really want to follow in September, the Steven Stearns case. I still don't know about Brian Koberger. Okay, just then chat with me if you want, and then I can yeah. So I can post on Discord and tag a few people that want it. No worries. Up to you, Stephanie. That is awesome. Thank you. But I still don't know about Brian Koberger. I am still struggling with the coverage of that one. It's oh, 4 months is too long for covering just one trial. I mean, I don't know. I still don't know. So, I don't want to commit yes or no to Brian Koberger, but for now, I am still thinking. Let's. Oh, that is awesome. Stephanie, I can give you busy. Actually, I am keeping GardenBot busy today. We actually just starting to design some merch for the channel. Still not gonna be released just yet. So we're still just talking, making like a logo for it and designing and everything. So we are thinking maybe as like a celebration for when we reach 1,000 subscribers, which is not too far away. We're gonna launch the channel merch, but that's still in the works. But yeah, there's always keeping me busy as well. The Excel of cases that we follow thing, Excel file, it keeps me busy as well, because I'm keeping remember of like new stuff to insert on the spreadsheet and everything. So I'm always busy with that and investigating about new cases and cases that are on my radar. And I'm trying to do as well a list of cases that I need to keep my eye on, with like hearings and everything that you guys keep telling me about it. And right about now, it's quite a long list already, so I need to keep an eye on that too. And then I help out on the on Discord, and I have my own work and my house and a garden bot to take care of and look after, which he does more the other way around, but yeah, still need to do it. So definitely life, it's a bit busy. Lies. Oh, uh, which Emma is that? Which state is that, Paula? Um, like I need, and then that's another thing. I need to learn the abbreviations for the states, cause yeah. Oh, is it Missouri? Missouri. I think it depends. Yeah, Missouri. Oh, St. Louis, Kansas, and oh, sorry, I'm learning geography now. Um, you know what? For the not now, right? When I was a few years back, right? I knew that Kansas was not a state, but I always thought that Kansas was a state. I know now that it's not. I have learned my lesson, but yes, in my geography. Oh, Springfield. Do you think that's the Springfield from The Simpsons? No, I'm joking. I mean, I think it depends on the case. Really. Oh, it only takes me 50. Yeah, Kansas City, St. Louis, Spring. Yeah, are the bigger ones. Yeah. Oh, Kansas is a state. So see. Oh, am I confusing my? So there's Kansas. So Kansas City is not in Kansas. I always thought of that. Oh, it's not from The Simpsons. Oh man, I thought it was. I was gonna say it only takes me 15 hours to get to Missouri from here. That's not bad. It's only 15 hours. I'll be there in no time. With the time difference would be less. Oh, it's right next to. But I thought the cat. So, my days. See, I'm confused with geography. But I mean, in terms of I think there is court cases from Missouri. Is not? Is there not? Huh, interesting. I don't remember seeing any, actually. Any cases? Oh, sorry. Oh, it is right back on right in the middle where we cover cases. Oh, that's Texas. Morning, Ivamos. We're talking about geography. Good morning. Buenos dias, my friend. How are you? So I'm looking where Missouri is on a map, and it's actually. But then, hang on. So, Missouri is central, though, isn't it, Paula? Please tell me I'm correct without googling. I think it is Midwest. No, the time zone. Is it Central or Midwest? Oh, is it? Do you think that's gonna happen? Oh, I don't think it's gonna happen. It would be a lot big move. Central, yay! You're right. It is right smack in the middle of the country. See, I know I know where more or less where my states are. So it's see, I'm learning. See, I'm not a lost cause at all. Central time zone, yeah. There you go. See, I know my time zones. I'm learning. See, guys, I'm not a lost cause in terms of learning time zones. Only took me what, 6 months. And now I'm gonna get confused all again because it's not this week, it's next week. It's gonna change the time for me, so we're gonna go back to normal times from before, which I should be okay with that, but I don't know. I don't quote me on that. So it's not this week. It's on the last. Hang on, or is it this week? I need a calendar. When will we change times? Oh no, yeah. It's not this week, it's the following week. That on the 30th. Oh, it's Mother's Day here in the end of the month. Oh, nice. So yeah, on that day we change hours. So oh, that is weird, Willow. I don't think is it? It's not. I don't think it's. It is by email, but huh, weird. Maybe try to recover like a password or something or email. Huh. I am so sorry, friend. And by the way, hey, new phone. Yes, I love having a new phone. When it's brand new, I'm all careful, the not dropping, and oh, you haven't? Oh, let me check that iVamos to see if I have anything pendant. Cause to be fair, I did was there yesterday. Um, no, I don't have anything. Any outstanding thing. Uh, uh, um, Let me get the link again. Sure, I need a link. Copy link. Try that again, iVamos, if you can, or anyone that wants to, to join the Facebook group that is not on yet. Yes, Paula, if you don't mind with that, I am absolutely taking you up on that for sure. Um, hmm. Yeah, I will definitely take you up on that, Paula. I will make you, uh, find you. Oh, you are there. Hmm, weird. Where's Paula? Paula. I need to find a. There you go. There we go. Then Paula. Oh, you are there. Oh, okay. So, are you in the group or not? Okay, so I'm confused. Though. Oh, okay. Oh, yeah. All right. I thought it was because I've seen the name Siempre Contigo, and I was like, oh, that's I. Yeah, you are. We're trying to use it more, but the thing is, I'm trying to figure that out. If Paula knows, because what I want to create as well from the Facebook group, I would like to have like a chat where we could talk or people could share stuff, or you know what I mean. And I want to create that, but I don't know how. Hey, welcome back, Pickles. Hello, my friend. Um, so yeah, that's one of my like goals to do that as well. I've also have but I haven't used it in so long. I have a Discord server, but I haven't used it in the longest time, and I don't know if I have the time to dedicate myself on like too much on there. But I definitely sorry, Pickles, I just send your DM. So yeah, um, yeah. So I was like, I have it, but I don't use it at the moment. Though. Oh, hello, Jason. Hey. Hi, welcome in, Jason. Good to see you, my friend. Hi. Um, yeah, I think I know you, don't I? But welcome in. We are just waiting on the we are just waiting on court to get back. The judge is deciding on something that the defense wants and the prosecution doesn't, or vice versa. So the defense doesn't want the whole investigation of the defendant to be played in court, but the prosecution doesn't. They only want bits and pieces. So yeah, so that's what we are waiting for to start the day. Don't forget to hit the like button, everybody. It does help a lot the channel, and yeah, it helps us a lot. But welcome in, Jason. Good to see you here. Oh, me talking and the court is just coming. Bear with me, the court sound is not the greatest, but hey, we are here for it.
All right, before we begin talking about this issue, I need to talk about a separate issue, about something that just happened. Just I want to make to disclose to you all. On my way out of the court. On my way out of the courtroom to go talk to my clerks, I was walking down the hall in the back hallway and there's the jury room right here, and I was walking by the open door to the jury room. I did, as I walked by the jury room, I made a sound of frustration as I walked by the door, which I can best reproduce. It was something like, as I walked by, and I happened to glance over. The jurors heard me make that noise, and I actually saw them laugh at the fact that as I walked by the jury room, I expressed a verbal sort of expression of some frustration, and they heard that and they laughed. I don't know what to make of that. I don't think it is any prejudice to either side. I can't imagine that they're going to infer from that anything in particular other than that the truth, which is I'm frustrated by the fact that, you know, this is taking some delay to get this case moving, and that I was in my head thinking about these issues and trying to work through them. So I just raised that to your attention because it was a sort of brief quasi-interaction between me and the jury, which was totally unanticipated. I didn't know they were in that room. I didn't know the door was open when I walked by. Does either party want to say anything more about that, or feel the need that we need to address that with the jurors? I don't think we do, but...
Well, I agree. I think that's probably the general consensus of everybody involved in the trial at this point. I don't think we need to blood here.
Attorney Sisti, do you have any concerns about that? And again, there was no words. I did not say any words. It was simply a sound that I made.
We're okay.
Okay. Going forward, I'm going to make sure that that doesn't happen again. But anyway. All right. I've had the opportunity to review, particularly I reviewed State v. Warren, which is a case involving the completeness doctrine. And defense counsel is right that otherwise inadmissible evidence can be admitted under the completeness doctrine if it's necessary to prevent a party from gaining a misleading advantage. Under that doctrine, a party has a right to introduce the remainder of a writing, statement, correspondence, or conversation so far as it relates to the same subject matter and tends to explain or shed light on the meaning of the part that's already received. Right? So that's the standard. I mean, Warren was a much cleaner case in that it involved a statement in which the defendant had made certain admissions, but as part of his statement, he mentioned the fact that there was one particular sentence, I think, about a knife that the state was trying to keep out, and the court felt it was unfair to keep out that one statement about the knife as part of this narrative. Looking at Warren, I think the only way to proceed is for the state to put on its evidence, to have the witness testify, and then when the defense wants to ask questions about other parts of the statement, I'm going to have to make a case-by-case determination as to how close in time the other statement is to the statements that the state has already put in, how much it's intertwined with them, how close it is in terms of subject matter, and whether it would be basically unfair not to have that portion of the statement introduced to put the rest of it in context or for completeness purposes. I don't think I can make an advanced ruling without hearing how the testimony comes in. And I don't think Warren or any other case that I'm aware of requires that the entire statement be put in or that the video be played in its entirety. I'm not aware of any such cases, but I welcome if you all, either of you is. So that's my position at this point, so I think we just have to proceed. Either side want to say anything further on that question?
As far as close in time, I mean, it's obvious it's close in time.
Well,
I mean, you read that.
I don't think close in time means the whole interview. I mean, the interview itself probably took
3.5 hours.
3.5 hours. All right. So I don't think you can say that the entire interview is all close enough in time. I think you have to look at the particular statement and how it is connected to other things that the state has introduced.
Yeah, it's like 2 pages away from
You know, for example, I note that the interview starts off on page 17 where Officer Garston asks him, so what's going on tonight? And he gives a long narrative answer that ends on page 20. And interspersed in that answer, there is some discussion about these prior incidents. I mean, and I think there is an argument to be made that that is part of that statement and is intertwined with it. But then immediately after that, there's a long 10-page discussion just about the prior incidents. I think there's an argument to be made that's not intertwined with any of his answers. So it's going to be a case-by-case or statement-by-statement analysis. I don't see any other way around it. Attorney Barth, were you going to say something?
Well, if we could, maybe we can, maybe we can't get a ruling then on if the witness, Garston, says he, gave an open-ended question, what's going on tonight? Does that, from the court's perspective, invite admission of the prior, reference to the prior incident?
I'm looking at page 23, where they're discussing the initial confrontation. And on 24, a page and a half later, they're talking about the October one. It's intertwined.
I disagree. I think 23, he's still talking about the prior incidents. He's talking about the prior incidents at that point. And that is a part of it. I will tell you, counsel, I think when I look at what is on pages 17, for example, on pages 17 through 20, where he asks him the open-ended question about what happens, and he's telling him about, he comes out, says he's going to kill me, kill my family, and I don't know who he is, and this isn't the first time this has happened. It strikes me that is all intertwined as part of his answer. And if you elicited portions of that, I think it would be fair game for the defense on cross to ask him, well, didn't he also say during that answer? I think it's all intertwined in that answer. Now, does that also mean he can then delve into all the details of every other time he's talked about that? Not necessarily. But in that instance where it is literally intertwined in that part of his answer, about what happened that night, why he did what he did, and then he goes on to say, and this isn't the first time this has happened, he did it. I think reading State v. Warren, I think there's an argument to be made it would be unfair to carve out that one little bit of that answer. So I can tell you on that one, I think that is how I would rule on that one. Now, it's a long interview, and I can't tell you exactly how I'm going to rule on the rest of them, but that's my thinking. I don't know if that changes anything.
Can I have just a quick chat?
Sure.
What happened? Because I got distracted. Sorry. Where did they go? Oh, I think they're back. Hang on.
So?
Yeah, they're
Sure.
back.
You want to take a recess? Please. Yes. All right, we'll take a recess.
Are you serious? Another recess? I need to be patient. I need to be patient. I need to behave. I need to. Are you serious? Another break? Are you absolutely? I am like the judge sighing of. Oh, nice. Paula, can you call IT as well to sort this court out? Like on the sound and on the fact that they keep taking breaks. Um. Yeah, run to the swings. Yes, let's all go to the swings. Like, so they came back for 20 minutes or 5 minutes, and they already on the recess again. Ugh. I am trying to be patient, especially now that my brother-in-law is in chat. I need to be more patient. I'm joking. I'm not gonna change. I am me, you know me. But it's crazy. How can they already be back and be already on break again? I just cannot fathom this. The thing is, they couldn't have dealt with this yesterday. Yesterday they had the whole day to deal with this. Yesterday they came in. They couldn't do it court because of the cyber attack that happened on Friday. They dealt with three motions, and that was it. They couldn't have dealt about this yesterday and now waste more time today. I mean, I don't blame the judge being already, I'm sorry, frustrated with this whole situation of going in the hallway, having a big sight that a juror saw what was happening. I don't blame him that he's frustrated. I am frustrated as well, as long as everybody else is, because this is just wasting time of the jury. And I almost guarantee that they are gonna come in, um, and have a recess 10 minutes after. This is utterly. I am annoying, and I am annoyed, and it's just. Oh, I think we should have gotten a counter of. I think maybe next we'll see how next trial is, but I think maybe for the next trial we need to count breaks. How many breaks does the court takes throughout the, I think sidebars and breaks we're gonna count next case, because if there's anything like this two last trials that we've covered, my days, we would be almost in 300 breaks by now on a 5-day trial. Because it is crazy. But I got a little bit distracted that I did not 100% paid attention to what happened. Did anyone did pay attention to what happened? Because I didn't. I'm sorry. I should have probably, because I was too distracted and yeah, and looking on things on the phone, because I am slightly losing interest on this motions on this case because of how many motions and how much time this is taking and wasting on the side of breaks. Because today is already what, 10 o'clock? Quarter past 10? And we've had no testimony, and we are supposed to finish this case today. And they said that I think the video is 3 hours and something. So, 3 hours. So if we have to watch that takes us pretty much until lunch. And then we still have the cross of that witness, and then the possibility of Jason testifying. We're gonna still have all the breaks of the quality of Jason testifying or not testifying, and then I don't think he's gonna testify though. To be fair, in all respect, I don't think he's going to, because he doesn't really need to testify. Well, he does because he's claiming self-defense, but you know, so it's just interesting. I really, really want it, but I was saying because I think Lori, I'm still need to figure out her name. Lori Daybell, her hearing is in about an hour, I think. Yeah, it's in about an hour's time. So we might do Lori's hearing on lunch break, and then I'm gonna have to have my break like while we're watching something, either the trial or the hearing. But we need to get that done today, because tomorrow, while on the deliberations for this case on a verdict, we can watch the first day, because the first day it starts at 1 p.m. North Dakota time, which is do not say North Dakota is yeah, North Dakota is central. No. Oh my days, North Dakota is central, correct? No, Paula. I think you need to let Maria have the turn of the swings. Don't I don't need to go there, Paula. Let. Oh, Stacy. Oh, actually, you just remind me something, Maria. I need to check, and I haven't checked in a few days, if Hosanna has a hearing soon. Um, I need to go to Colorado's. I know Colorado. Paul is very, very sweet. I'm sure she is letting you. Um, but I need to check if Hosanna has a hearing soon, because I'm waiting. Okay, search, because she should have one soon. I need because I completely forgot to check that actually. Good thing we have a couple minutes spare right now. To check that, because I want to see a hearing when there is the possibility of like the reduction of her sentencing. So do for 6 months search. Hosanna, it's with the two. Varela, there we go. Let me try to see if there's anything on the docket for her. There's nothing interesting. I don't know. Weird. Um, let me Google if any news about Hosanna's come out. Ooh, actually, there is. Oh, what is this? Huh, just some sounds. There is an article published a few days ago that Stacy's got convicted. Yeah, for life. Varela, there you go. Pled guilty. Huh. Yeah, she's got sentenced, but we need to know. Yeah, because on our last trial, Hosanna was the partner of Stacey Rodriguez. That she pled guilty to the charges, and she made a proffer, a deal with the prosecution, that if she testified against her co-defendant, that she would be able to get a reduced sentence of it. But I think now she's waiting on a hearing
All right.
to reduce that sentence. That's what I was hearing. That she's gonna have
Counsel, is there anything to report back after your conversations?
No.
No. All right. So then are we ready to proceed with this witness?
Yes.
Very good. Can you please have the jurors lined up? It may take a moment because I think they're far away. All rise for the jury's folks. Jury. morning, ladies and gentlemen. Nice to see you all. Hope you all had a good weekend. Let me begin by starting by apologizing. As you can see, we've had a number of delays that have caused us to have to suspend things for periods of time, and we got a little bit of a late start today. I think I explained to you previously that's sometimes the way these things go in trials. Matters come up that have to be dealt with. I just ask you, to the extent that you have any frustrations about that you please not hold that against either party, but you blame the court if you're going to blame anyone for that. And I apologize. We try not to waste your time, but here we are. But now we're ready to proceed, and so the state is ready to call their next witness.
Thank you, Your Honor. The state calls Jacob Garstin.
Thank you.
Detective, I think you're familiar enough with the courtroom that we can stand straight ahead. If you could just turn the corner, though, and remain standing and face the judge for your oath.
Here. One, do you swear that any testimony you're about to give will be the truth, the whole truth, and nothing but the truth under the penalty of penalties of perjury? Yes, Your Honor. You may be seated. Thank you. Counsel, whenever you're ready, you may inquire.
Thank you, Your Honor. Sir, can you state your name and spell your name for the court reporter, please?
Yes. My name is Detective Jacob Garstin, Garstin.
Can you briefly professionally introduce yourself to the jury, that is to state your professional experience and training?
I graduated from the University of New Hampshire in 2013 with a bachelor's in sociology and justice studies and a minor in information technology. I have a master's in public administration from John Jay College, City University, New York in 2020. I graduated from the New Hampshire Police Standards Training Council Police Academy in 2015, and I've been a law enforcement officer for a little over 10 years.
And where is it that you have worked as a law enforcement officer?
For the Rochester Police Department in New Hampshire.
And can you briefly describe your progression of rank and duties through the Rochester Police Department?
Yes. So I was a patrol officer for about 5 years, and then I've been a detective for a little over 5 years as well.
And we've heard from other parties the job description associated, the distinction between patrol and detective, so I think we need to belabor that. I would like to move directly to whether or not you were working on April 4th of last year, 2024.
I was picking up a patrol overtime shift that day.
And did you have any involvement, respond to the investigation concerning this case, as you know, State versus Jason Levesque?
Yes.
Can you just describe how it is you first became involved with notified you?
There was a dispatch that there were shots fired on Summer Street, so all available units started heading in that direction.
So did you respond to the scene itself down to 4341 Summer Street?
Yes.
What was your job down there? What did you do?
So I arrived on scene, and patrol officers had Mr. Levesque currently detained, and they transferred custody of him to myself, and then I transported him back to the police station.
Were you with any other detective at the time?
At that time, while I was transporting him, no. It wasn't until I got back to the station that there was another detective there.
And can you confirm the very short distance between the scene and arriving back at the station?
Yes, it's police department is very close to where the incident took place.
And back at the station, did you, in fact, conduct an interview with Mr. Levesque?
I did.
I obviously want to spend some time on that, but I note that you had some other tasks which followed. Let's just go through those to address your investigative tasks associated with this case. Following the interview, looks like the next day, what did you do concerning this case?
So on the 5th, I reached out to the ATF to request a trace on the firearm to find out who the original purchaser was.
And were you able to follow that up with ATF assistance to actually conduct an interview of the genesis or origin of the firearm?
Yes.
Did you document that in your report?
Yes.
And then just to help things along here, my understanding is that on the 8th you requested all the dispatch and 911 tapes.
I requested all the dispatch tapes. I'm not sure on the exact day, but it was a couple days after.
And what was your reason for doing that?
To identify any other additional potential witnesses that we haven't spoken to. Also, if there was any excited utterances, you know, during the heat of the moment, someone might say something that they might not remember later on.
And did you, in fact, listen to all those correspondence, the dispatches, and memorialize that, that is, take notes of it in your reports?
Yes.
Did you follow up on any potential leads for witnesses in the surrounding area?
Yes, we spoke to a number of witnesses, myself and some of the other detectives, to try and identify any other potential witnesses.
In your view, did the people that you spoke to with made 911 calls have anything materially to add beyond what you were able to obtain from the people who were on the scene and the video that you obtained?
There is no real additional information that was gathered from those interviews.
I'm reviewing your report as well. Did you have any responsibilities concerning physical evidence in this case?
Yes.
What did you do?
So I believe it was on the 11th. I took the clothing from the drying rack, so anytime we have clothing that might be wet, we put into a drying cabinet so that way it can dry. I took the clothing and repackaged it, so for long-term storage.
And was that essentially the extent of your involvement with physical evidence concerning, scene analysis or anything along those lines?
Yes, I didn't do much on the scene. I did photograph the clothing as well prior to packaging it, but that was extended.
Let's see, did you, how far out, by the way, were you continuing to interview witnesses who were associated with the 911 calls?
So we identified all the witnesses that we could. We also checked social media. Any person that may have made a post that they could be a potential witness on social media, we reached out to try and talk to them as well.
And did you document those interactions and any statements people may have made?
Yes.
Once again, concerning social media, those contacts, did you determine, in your view, whether there was anything material to add to what detectives obtained from the scene and video evidence?
No, it was more that they heard the shots or that they had seen the police response, but nothing material.
Sounds like the heart of the matter for your involvement in this case was interviewing Jason Levesque.
Yes.
Let's talk about that.
Okay.
Describe for us the process that you said you took him into custody down at 43 Summer Street. Just walk us through what happens next.
So whenever we take someone, whether they're detained or arrested or in custody, we would conduct a search to make sure that there's no weapons, contraband, firearms. He got transported to the police station in the back of my cruiser. He would be driven into the Sally Port. From there, I walked him into the booking area and then transported him via elevator up to the interview room.
And where did you ultimately take him?
To the interview room upstairs.
And talk to me about that interview room. Can you describe it for us?
Yeah, so it's approximately 10 by 10, 12 by 12 room. There's a circle table in the room. There's 4 red hard plastic chairs.
And look, this is at something like 10:30 at night. Can you share with us, describe for us how Mr. Levesque, appears to you?
He was able to communicate. He had expressed that he had been working prior to that he had picked up his daughter from work and that he was going home to finish up his snow removal for his own home.
So before we get into the narrative, his account of sequence of events and things he heard and saw and did, I want to talk a little bit more about his appearance. You said he mentioned that he was at work. Did he share with you for how long he had been working?
Yeah, since approximately 10 p.m. the night prior.
For 24 hours at this point?
Yes.
Did he indicate to you that he was fatigued, tired?
He indicated that he was tired from Plowing, yes.
And did you, in fact, try and address that in any way? Did you provide him with, for example, water?
Yes, so I offered him food, I offered him coffee, gave him a moment to compose himself as well, and he indicated to me that he was able to proceed with the interview.
Let's be clear, the food you offered him was like a Slim Jim
Yes.
along those lines. Did you ask him whether he wanted more than that?
I asked about food. I can't remember if I asked more than that. We did offer him some candy as well. It's hard to get food in the PD at 10:30, 10 o'clock at night.
Did he at any point, make any statements about his physical sensations, how he was feeling to you?
Yeah, at one point he did indicate that he was either lightheaded or dizzy.
Pardon me?
Sorry, at one point he did indicate that he was either lightheaded or dizzy.
And how did you respond to that, if you recall?
I asked him if he wanted EMS to evaluate him.
And what did he say?
He declined.
Did you continue to question whether he felt comfortable or capable of making a statement?
Yes.
Now, was there a period of time where you were, frankly, setting up? That is, did you go right into the interview, or was there a delay between arriving at the station and actually beginning the interview itself?
There's a little bit of a delay. There's usually some rapport building before you start talking about the specific matter at hand. Also some arrangement of the room. And we also had to gather a Miranda form that we could go over with Mr. Levesque.
And during this kind of setup process, did you recall whether or not Mr. Levesque actually asked to lie down, literally on the floor?
Yes.
And did you accommodate that?
Yes, we did.
Well, describe what he did.
He laid down at one point. We let him rest on the table when he wanted to rest. We didn't prevent him in any way from taking breaks when he needed.
And after that process where he said, I'd like to lie down, did you revisit whether or not he felt comfortable or capable of having a conversation with you?
I asked him multiple times if he was willing to, if he was okay, and if he needed any sort of assistance, or if he's willing to participate, yes.
And from your perspective as an investigator, how did he appear during question and answering?
Yeah, he was able to recall fine detail. He was able to articulate himself. He was able to recall memories as far as what happened.
Was he responsive to specific questions, for instance?
Yes.
So you oriented them to the topics that you were asking about?
Yes, and even before the interview, he's asked basic questions as far as his name, address, date of birth, phone number. He was able to recall those. No difficulty doing those as well.
Then I want to get into the substance of your conversation with Mr. Levesque.
Okay.
Did you ask him about the specific activities that preceded his contact with Kyle?
Yes.
Let's do this. Was this interview recorded?
It was.
And are you aware that there was a transcript generated of this recorded interview?
Yes.
Have you had an opportunity to review the transcript and the recorded interview?
I have.
Your Honor, I'd like to approach this witness. Well, I guess I can do this foundation. Do you recall each question and the specific words that Mr. Levesque used to respond to each question?
No.
Would using or referencing the transcript assist you in your memory and it being accurate concerning the words you used and the words Mr. Levesque used?
It would be. Yes.
Your Honor, may I approach this witness?
You may.
Your Honor, my request is to leave a transcript with this witness to refer to from time to time rather than a back and forth.
I have no objection to that. My question is, does it make sense to have one copy of the transcript marked as an exhibit for ID purposes?
Well, first of all, it should be marked certainly for ID. I mean, we would prefer it all.
Well, I understand that. We've had that discussion, and I'll allow you to remake that argument if you need to at a later point. But at this point, where it's going to be used to refresh his recollection, as I understand it? Or,
If we could briefly approach.
sure.
Sorry about this. I was trying. I will send some. I'll send some. Sorry, but they were on the sidebar, and I had my mouth full of shortbread. So I was trying to chew and not to talk. But I'm like, come on, and shortbread. It's like you think you have to take time. So I was like, I'm not even finished, but I'm trying. That will teach me a lesson of not eating while on stream. And because this happens, I have to talk and I can't because um oh no, it's okay. Oh yeah. Uh, See, this trial has been a nothing burger. Absolutely a nothing burger trial. If you ask me what's happened so far, I can tell you the highlight of the trial was that a witness on Friday brought an emotional support bunny to court. I think that was the highlight of the trial. It's been was not a very good choice. I'll send some pickles. Here, I'm sending you some. Make sure you grab it. I know. I am sorry. This was probably not the best choice of trials. I thought it was gonna be more interesting than actually it is. Yeah, I think definitely the bunny was the favorite part, but yeah, it's I this case has been, in my opinion, a nothing burger because the victim won't testify because of PTSD and
With court's
everything.
permission, I'd like to mark this transcript.
I guess I'm getting interrupted again.
And counsel, I just would like to remind you that I have been told that some folks are having a hard time hearing, so to the extent you can sit right up close
Yes,
to
sir.
that mic. I know you're sort of
Yes, sir.
soft-spoken by nature, it seems like, so if you keep your voice up, that would be helpful.
Yes, Your Honor.
Thank you.
How was that department? You know, I have nothing to know.
I'm sorry, what was that? All right. So the transcript is now States Exhibit 29 for identification.
Yep, 29. Sir, can you just take a look at that and confirm? We were just talking about whether you'd seen a transcript of the video interview. Does that appear to be the transcript you were referring to?
Yes.
I just indicated, I wanted to ask you some questions about the details of this conversation with Mr. Levesque. On page 33, line 25, is that the area where your question is about line 18, 19? And can you just read that to the jury?
I asked, okay, and you said you were going to clear the driveway?
What was his response?
Yeah.
And what did you follow up with?
Okay, and what happened after that?
And can you then describe Mr. Levesque's description of events before contact with Kyle on lines 22, following over the next page?
So I made a couple of passes, moving the snow towards 39 Summer Street. Then I turned around and I made one pass to grab the rest of it off the sidewalk and push it towards 43 Summer Street. Then I was going to backtrack the driveway, so I backed up and I got out to lock the hubs. They're the old manual locking hubs. They're not electronic or anything, so I got out to do that, and that's when he came up to the driveway.
And what was your understanding of what he meant by backdragging the driveway?
Sure, it's when you drop the plow and then pull it back instead of pushing the snow.
And so did you get into even a conversation about where that snow is going to go?
We didn't discuss the backdragging of snow to my knowledge, no.
Was it your understanding based on this description that Mr. Levesque had not completed his task of plowing his own driveway?
No, the driveway was still in the process of being plowed, is my understanding.
And the next question, did you ask him when it is and where it is that he first sees Kyle? I believe it's on lines 6 and 7.
Yes, so I asked him, okay, where's the first place you remember seeing him?
And can you share his response, starting line 8?
Yes. When I heard him yelling, screaming, or making some kind of commotion. I honestly don't know what he was saying. I remember hearing a voice or something coming from that direction.
Let me just take a little side step here. At this point, had you received and reviewed the videos that were ultimately obtained from 43 and 41?
During the initial interview, no.
And so at this point, were you able to, for instance, compare this claim that he heard yelling and screaming from 43 with the actual audio video evidence?
I was not.
And then did you follow up to try and get a better sense of where it is he first saw Kyle in the following question, which I believe is at line 12?
Yes, so I asked him, okay, and when you say that direction, which, and he responded from 43 Summer Street.
And did you ask more specifically where at 43 Summer Street?
Yes, so I asked him, like the corner of the house, the garage, and he responded, the driveway.
And your response?
So I asked him, the driveway? Okay, so you look, I'm assuming you look over because you hear the noise.
And what's his answer?
Yeah, and there I saw him come from where I can finally see him coming out of the driveway. He was putting on his shirt. He was shirtless, so he was putting on his shirt.
And so his answer to you, when he sees Kyle for the first time, he's actually doing something. He's putting on that hoodie.
Correct.
And were you able to later view video and confirm that Kyle did in fact put on a shirt or a hoodie all the way back in his driveway at 43?
Yes.
And so now, from here, did you get into questions about, his actual appearance? You said you've established that his first time he notices Kyle, he hears something over there, and he actually sees him coming out of the driveway. I want to turn your attention to page 35. Did you try and get an understanding of what Jason claimed he saw in terms of Kyle's actions? And so I'm going to direct your attention to 35, line 6.
Yes, so I asked him, okay, so he was putting on a hoodie at that point. Describe, I guess, he's yelling at you.
Okay. And just before that, by the way, was he able to, even from that distance, give any kind of detail about you know, the nature of the shirt that he was putting on. And this is line 1 at 35.
Yeah, I described it as either green or camo hoodie.
And so then we were just saying, after the hoodie, did you ask more specific questions about, say, distance and activity?
Yes.
Line 10, what do you ask?
How far away from the truck does he get at this point?
And what's his answer?
Oh, he's walking at a very fast rate towards the truck.
And did you ask him now about concerns for, say, weapons, or if he was brandishing anything?
Yes, so I asked him, okay, anything in his hands?
And what were his answers?
His initial answer was, I don't know.
And did you pursue that?
Yes.
Line 16, what did you ask him?
Okay, are you able to see his hands from where you're seated on the truck?
And what was his response?
Yes, I could see. I guess I could see his hands.
And did you follow that up at 22 and ask him whether he was armed or had anything in his hand?
Yes, so I asked him, okay, and you're not sure if you saw anything in his hands?
And what is his answer at 24, 25?
I don't believe I saw anything. He had his hands clenched in a fist, like.
And then on 36, does he continue to describe Kyle's hands?
Yeah, so I said, oh, like this, and demonstrated a fist, rather, and he responded, yeah.
Did he also demonstrate a fist?
Yes.
And did you go on to continue to ask about the details of what, if anything, was in Kyle's hands?
Yes, so I said, all right, but at that point his hands are in a fist. Did you see him holding anything?
And what was his response?
I did not see him holding anything. I don't think so.
Is it your, I don't know if technique is the right question, but where somebody you're interviewing makes a statement or a series of questions, do you tend to kind of loop back towards it? Do you revisit the same questions at a later time in the interview?
Yes, for an interview you might ask the same question multiple times in different manners.
Why?
One, to check consistency. Two, sometimes further on in the conversation they might recall something that they did not recall at the time, but mostly to check consistency.
Page 98, line 12. Is that an example of you revisiting whether he had a weapon?
Yes.
And what was your question?
Had you seen him with any weapon or anything at any point during any of this exchange or in the past?
And his answer is 15, 16.
I don't know. I don't believe so. No, I don't believe so.
On that same page, and he's described earlier in this conversation where he's coming over to the truck at a very fast pace. He's got his fist clenched. Did you ask him here about his daughter at same page, line 9? Oh, excuse me, no, yeah.
Yeah, so on line 7, I asked, was he making any movements towards your daughter at that point?
And what was his answer?
No, he threatened me again, was just threatening me and I'm going to kill you and your family.
Okay. Then let's get to that, the threat. It seems like you've asked multiple questions about the threat. I'm going to go back to 36, which is the first description of this. You've asked him details like what he's wearing, if he sees any weapons in his hands, and then at line 15, 16, it seems like you're now getting into the threat.
Yes.
Can you indicate this line of question?
Yes, so I asked him, sneakers, okay, so he's coming at you yelling, can you make out anything he's saying at this point?
And how did Mr. Levesque respond at line 18?
Yeah, he said, if you put that fucking snow at the end of my fucking driveway, I'm going to fucking kill you and kill your fucking family.
And did you ask, kind of any certainty or how specific that was? Can you give us the follow-up from that?
Yes, I asked him, okay, and just to make sure that we're not paraphrasing, is that the, and he responded, yeah.
And can you go on? What term does he use to describe it?
He describes it verbatim.
Is that his word?
Yes.
And on line 37, too, does he continue to confirm that those are the terms?
Yes, he says exactly what he said.
Did, at any point, I mean, you revisited the question about the threat.
Yes.
At any point, did it change to be more specific, say, towards Kira or daughter or anything like that, other than beyond, first, if you move the snow, I'll kill you and your family.
Yeah.
Did it ever change?
From what I recall, it was the same conditional threat throughout.
And you described him, you asked about the process of coming over, what he could see, what he heard. Can you describe then what he claimed about the actual encounter itself, where that occurred, how close that happened? Page 40, line 10, 11.
So I asked him, okay, and if he and if he reached out and put his hand on your shoulder, was that close, or, and he responded, closer.
And what did you say?
So I asked him again, closer, and he responds, because was literally his nose was touching my face.
And does he reiterate what was said when they were literally nose to nose or face to face?
Yeah, he reiterates, if you put that fucking snow there, I'm going to fucking kill you.
Put that fucking snow there. Did Mr. Levesque ever indicate what snow is going where?
I don't recall as far as specifics. I'd have to refer to a specific page if you have a reference.
And did it ever deviate from snow somewhere, then I'm going to kill you and your family?
No, to my knowledge, it was still all the conditional threat throughout.
So he described to you a face-to-face, a nose-to-nose encounter combined with a threat. Did he describe what happened after the nose-to-nose encounter? Where did Kyle go? What did he do?
Yes, so after they exchanged words, or that rather that Kyle made the threat, that he started to walk away.
And then I want to direct your attention to page 45, line 12. Well, let's start at 10. That's Mr. Levesque's answer. Your question is at 7. Can you
Yes.
share your question?
Yeah, so I asked, all right, so he starts walking away, you said, and how far away did he get from you at that point?
What's his answer?
Well, my truck was parked. If this was my driveway right here, my truck's parked here, and he had made it to like the front of the house, and that's when he stopped and turned around and came back.
And did he describe on page 46 how he claimed Mr. Violette, how Kyle appeared when he turned around and started coming back, 46 line 10?
Yes. He said he's still very agitated. He's got his fist. He's very animated in how he's yelling. And just, he's going to fucking kill me and my family for moving snow, I guess.
And he claims at this point, while Kyle is in front of 43, that he's yelling these things, correct?
Yes.
And at this point, did you yet have the audio from 43 and from across the street?
We did not have the video or the audio at that point, no.
And did he describe to you on page 48 then what he did in response to Kyle walking back towards the house? This is 48 line 9.
Yes.
Well, can you just share your question on line 8?
So I asked him what happened next, and Levesque responded, when he started coming back at me again, I didn't want to I went and drew my firearm and I pointed it at him.
What does he claim happened after he brandished, that is, to take out and pointed his weapon at Kyle?
That Kyle continued towards him.
Well, can we be more specific? Line 13, same page. How does he describe Kyle coming at him after Mr. Levesque drew the weapon?
Yeah. And at that point, that's when he came at me. He was coming back at me like he was ready to go.
And did you kind of follow up on that? Actually, why don't you share with us your next question on 16? Okay.
So I said, okay, so let's kind of dissect that a little bit. And he responded, yeah. And then I asked him, so as far as he was coming at you, ready to go, help me understand what you mean by that.
And what did he say?
Like before, he kind of was, his hand was in a fist. Now he was coming at me like he was going to attack me.
And you responded to that?
I responded, okay.
And did he continue to speak of this?
Yes. And he said, or he was going to take the gun. I don't know what he was going to do, but he was coming at me. He was ready to go.
And this is his claim after he takes the gun out and points it at Kyle.
Correct.
And again, did you have the video to compare his words to the images captured on 4 different videos?
Not at that time.
Did you try and get even more detail on this notion of Kyle coming at Jason with his pointed weapon in terms of how he was able to infer that he was going to be attacked?
Yes, there would have been follow-up questions to that, yes.
For example, a follow-up question on line 3.
Yeah, so I asked him, okay, and what makes you think that? And he responded, I don't know how to describe that, but I'm sure if you saw somebody coming, you can tell if someone's coming at you and they're going to attack you. But if they're coming they want to take something from you or hurt you or whatever.
And did you have, again, did you revisit, did you confirm whether or not Mr. Levesque actually had the firearm out and pointed when Kyle was supposed to be coming at him to attack him?
Yes.
It's that page, again, 49, I believe you asked a question at 14.
Yes, so I said, okay, was the gun out at that point when he was, and Levesque responds, yes. When he started coming back at me again, that's when I drew the gun.
And did you ask more details about how far away he got or how far away he was when the gun came out?
Yeah, so I asked, okay, how far away was he when the gun first came out? And Levesque responded, probably about 10 feet.
And you?
So I said, 10 feet? Okay, and did you see his hands at that point?
What was his answer?
Yes, they were clenched and I asked, they were still in fists, and he responds, fists, yeah, right.
And just to clarify, did you continue to really make clear that this is when he has the gun pointed? In your follow-up question, did you ask, well, where was anything about the gun?
Yeah, so I asked, to be perfectly clear, I was getting some more information. I asked him where the firearm was prior to this, where he drew the firearm from, if it was in a holster, where it was on his body.
And what did he say?
He said that he was in his waistband, in a holster, yes.
Okay. And did you use the term, and again, this is at line 3, page 50, prior to this description, these claims about what Kyle was doing?
Yeah. So I asked, and where was the firearm prior to this?
And what was his answer?
And he responds, in my waist.
And, just getting back to asking about Kyle's hands, at any point at this point, this is not the nose-to-nose, but where Kyle turns, does he claim that Kyle had a weapon or anything in his hands that could cause lethal injury?
At no point did he indicate that he had a weapon on him, no.
And his claim was that Kyle didn't stop, but rather came out.
Yeah, that he continued to advance on him, yes.
In fact, you get into a little bit more detail about this on page 53. You asked a question at line 2. Can you share that?
And then you pointed at him, and he responds, yep. And I asked, and what does he do when he sees that?
And what are you referring to, pointed it at him?
The firearm.
Any question about that, reviewing prior page? For instance, 52 of line 18.
Yeah, so at 18 I said, so you pulled out the gun with the right hand, and when it comes out of the holster, where is it going from there? And he responds, in my hand like this, and he gestures with arms stretched out in front of him, imitating pointing the gun.
Got it. And so we were at the point where you're asking some follow-up about what Kyle does when he sees the firearm. Can you share Mr. Levesque's claim at line 6, page 53?
Yes. That's when I guess the best way to describe it, it looked like a rage, like that really infuriated, like he was angry. He was coming at me, and he was going to hurt me and take the gun, whatever, maybe.
And did you have some questions about that claim?
Yes, so I said, okay, what makes you, like I need you to be as detailed and descriptive as you can. And he responds, I saw him come at me, like the look in his eye, like he was angry, like he was pretty much gave me a look like it's you or me.
And did he describe how quickly, after the firearm is produced and pointed at him, how quickly Kyle continued to approach him?
Yeah, so I asked him, and how was, I guess, his pace towards you? And he responded, he was coming at me right at a pretty fast rate. So then I asked him, did that change at all from before the firearm was drawn? And he responds, yeah.
And what's your next question?
All right, so he walked, and Levesque responds, he quickened when I drew the firearm.
And your next question on 54.
So I asked again, okay, so he went towards you faster, and he responds, yes. And I finished my question, once the firearm was drawn, okay, how was it prior to the gun being, I know it was slower, but are we talking like he was walking? And Levesque responds, no, he was walking, a fast walk.
All right. I'm going to ask again. You've advanced a number of pages in the transcript and sequence in terms of the narrative. At this point, when he's claiming not only did Kyle continue to walk at him, after he produced the gun, but he actually increased his pace towards Mr. Levesque. Have an opportunity to review the actual video at this point.
At this point now.
You actually have an opportunity to review the actual video of how Kyle responded once the firearm was brandished or produced.
Sorry, can you repeat that?
Did you have an opportunity to view this moment when how Kyle responded in the video when Jason brandished or pointed the firearm?
No, as I had not had the video, access to the video at that point.
Does Mr. Levesque explain to you what happened as a result of Kyle continuing to advance towards him in a rage and rapidly closing the distance?
He does.
What does he claim?
And as soon as I saw that look in his eye, I knew I had to protect my family, and I pulled the trigger. So then I asked him, okay, do you remember how many times the trigger got pulled? And he responds, yeah, 6 times.
And what do you ask?
Okay, so you fully emptied the clip at that point? And he nods in affirmative. And then he says, so the first one that I first shot, it hit him. He turned around and he walked away. And he turned back and he came at me again.
I'm sorry, he said that after he fired the shot, he continued to come at him?
Yes. Sorry. So the first one that he shot, it hit him. He turned around to walk away, is what he said.
Okay, and then what happened? He's walking away?
So he's walking away, and he said that he turned back and to come at him again at that point.
All right. Do you continue to follow up on that claim on 55 line 2 and 3?
Yes. So I said, all right, so you said that he turned to walk away, and is that where you said after the first shot? And he responds, mm-hmm.
We had talked earlier about you looping back later to the same topic, same subject. Did you do that concerning this moment after the shot was fired?
Yes, later on I did, yes.
I direct your attention then to page 105, line 17.
I'm sorry, what was that page reference, counsel?
I'm sorry. Just confirming his actions prior to the actual shot. This is 105, Your Honor.
Thank you.
And Detective Garson, I direct your attention to 105, line 15 through 16.
Yes, so Detective Flathers asked, what was his reaction to you pulling out the gun? And Mr. Levesque responded, that's when he got angry, like he got really angry, or like more aggressive, or I don't know what word I'd ought to use, but you'd think he was not happy, like he wanted to come, he was going to get, hurt me or take the gun, or something like that.
And then at 106, line 2, does he continue to make this claim? Or actually, is it Detective Flathers continue to ask questions?
Yeah, so Detective Flathers asked, so you're taking out the gun didn't make him stop where he was?
What is claim?
Levesque responded, right.
What I think I forgot to do is some basic housekeeping. You just mentioned Detective Flathers. Can you tell us when Detective Flathers came into this interview?
So he was in the first part of the interview, some of the last part of the interview he had stepped out.
Okay. And can you just identify Detective Flathers for the record and for the jury?
Yeah, Detective Flathers is one of my coworkers. He works for the Rochester Police Department, and he has been working for the police department before I got hired on there, so it's at least over 10 years.
Let's talk then about your inquiry concerning the shooting itself. You talked about brandishing the firearm and his claims about Kyle's response to that. Page 55.
Okay.
17, you asked a question concerning the actual gunshot.
Yes. Okay, and he's coming towards you, so 5 feet or less, the first shot goes off. Do you know where roughly on his body, though, it hit?
What's his claim?
No.
In fact, you continue to press that.
Yes, so I said, okay, do you know if it actually physically hit him, the first shot? And he responds, I think so.
And is this an area that you revisited later in your interview?
Yes.
I'm going to direct your attention to page 111, 1 through 2. What was your question?
Was it your intention to stop him, to kill him, something else, like
What's his claim?
just stop him?
And do you follow up on that?
Yes. So I asked to stop him. Okay. Did any of that change during the next series of shots that went off?
How do you answer that?
No, the first one didn't. I think it affected him he heard the shot, but it didn't stop him.
I'm sorry. So his claim at this point for how Kyle reacted after being shot in the head was it didn't seem to affect him.
He indicated that the first shot didn't stop him, yes.
He didn't describe him going down to the ground.
No.
And this was in response to your question about what was your intent, to stop him or kill him?
Yes.
Page 54, this appears to be also in the same area of inquiry. I'm going to direct your attention to 54 lines 21 through 23.
So Levesque says, so the first one that I first shot, it hit him. He turned around to walk away, and he turned back and he came at me again.
Okay, we had just visited that, and so now he's indicating that he had struck Kyle with the first shot, but actually describes him walking away and then turning around and coming back at him. Am I understanding that correctly?
That's what he indicated at that time, yes.
Does he describe him going down on the ground and crawling away?
Not during the initial interview, no.
You indicated that you had asked him about the distance that he shot him at the first shot. You recall how far away he claimed it was? This is 55, 9 and 10.
Yes. So Levesque says, the first shot was a very pretty close distance. I would say maybe 5 feet or less.
And do you remember whether Mr. Levesque claimed that he actually closed the distance or whether he stayed put and it was Kyle who closed the distance to supposedly 5 feet?
Yes. So I asked him, and you were still standing at this point. You hadn't gotten back down or anything, I'm assuming, right? You're still on your feet? And he responds, yeah. And I asked, okay, and he's coming towards you, so 5 feet or less, the first shot goes off. Do you know where roughly on his body that would hit? And he responds, no.
At 55 line 21, you asked, do you know if it actually physically hit him, that first shot? Do you recall his response at 23?
He says, I think so.
And did you follow up on that?
Yes, I asked him what makes him think that.
And how does he describe his basis for thinking, he might have hit him at 25?
Something hit him. Let's cut off. Maybe it didn't, maybe it was just the...
Can you back up to line 1?
Yes.
And reread that? page 56. Did we give you a bad copy?
Yeah, it looks like some of it was cut off.
I'm going to approach this witness, Your Honor.
Please.
How pervasive is that? That's pretty bad. I'm going to show you is a better copy and ask Your Honor, and for the record, this is 56, continuing on to line 1.
Yes. So you could tell maybe something hit him. He flinched, or maybe it didn't. Maybe it was just the noise. Like he reacted to it, I guess would be the best way to describe it.
Did you say flinch?
Flinched, yes.
And that's according to Mr. Levesque's claim.
Yes.
And he added, maybe it was just the noise that he was responding to?
Yes, he said maybe it was just the noise, like he reacted to it.
So from his claim of being 5 feet away and discharging the firearm, he doesn't indicate, yeah, I shot him in the side of the head and he fell to the ground.
That's not what he indicated at that time, no.
He flinched as though he might be reacting to noise.
Yes.
And did you follow up on that, 56, line 5 and 6?
Yes, I asked, did you hear him make any sounds or say anything? And he responds, I don't know if I heard him say anything. I mean, the gunshot did just go off kind of loud, but I did see him react and either it was the noise or something had hit him or it surprised him. But he was definitely a reaction from it.
Okay, so he doesn't change that initial claim that it was maybe he was hit. He actually commits to it. It provides a little bit more detail that maybe Kyle was surprised by the sound of the gun.
Yes.
And did you follow up and ask, more about Kyle's reaction to this gunshot going off?
Yes, I asked, okay, does he stay on his feet? And Levesque responds, yeah.
Okay. This is in reference to the first gunshot going off. And he's described his reaction to it as maybe being surprised, maybe surprised by the noise. But you ask physically, what does Kyle do? And his claim was Kyle stayed on his feet after being shot?
That's what he indicated, yes.
And does he describe what Kyle did after staying on his feet somehow?
Yes, so I said when the first shot goes off and you said he turned, which way did he turn? And Levesque asked, so you mean like counterclockwise or clockwise? And I clarified saying, like which direction was he turning? So Levesque says, so then he turned, he was still heading for me, he started going back towards his house.
And did you get more specific? So initially, he claims he's actually continuing to head towards Jason Levesque.
Yes.
But then he turns to his house. Did you ask for more details on that?
I did.
What did he say?
So I said, and how many steps did he make before he turned around a second time? He responds, a couple. So I said, so he went a couple of steps, and then did he say anything or do anything, or just kind of turned his body around? And he responds, he turned his body back around.
And he turned his body back around. His claim is that he turned his body back around towards towards Jason.
Towards Mr. Levesque, yes.
And let's focus in on what he claims happened next. This is 57, line 3.
Yeah. So Mr. Levesque says that he turned his body back around. So I asked, all right, and then what happens? And Mr. Levesque responds, and then I unloaded the gun.
So this claim is that Kyle, after being shot, turns back towards Jason on his feet before the next rounds of ammunition, the next 5 rounds go up.
Correct.
Didn't say anything about him being on the ground?
Not at that time, no.
And did he actually make any claims about the distance that Kyle closed on Jason before he fired 5 more rounds? This is a continuation of 57.
Yes. So I say, and how far away was he when those next 5 shots went off? And Mr. Levesque responds, a couple of feet. So I asked to clarify, and just to be clear, I want to make sure, what's a couple of feet? Mr. Levesque says, I would say 3 feet, 5 feet. And then I ask, all right, so he was about 3 or 5 feet away, and Mr. Levesque responds, yeah.
Okay. From that distance, standing in front of him, did you ask anything about the injuries or the shots connecting in any way?
Yeah, so I asked, and do you know if any of those shots connected? And he responds, I'm guessing, while nodding his head in affirmative, just due to the fact that he ended up like how he was holding himself, and he started walking back towards his house, like holding him like he had been hit.
That after taking the 5 additional rounds, Jason Levesque describes him holding himself and walking back to his home?
Correct.
Do you ask any follow-up for detail on that claim?
Yes, so I said, okay, where was he holding himself? And Mr. Levesque responds, I believe on his abdomen. So I ask him his abdomen, and Mr. Levesque responds, yeah.
Is this the kind of detail you were referring to at the outset of our conversation when you said Mr. Levesque seemed responsive to your questions?
Yes, he was able to answer questions asked in multiple different manners and provide fine detail as well.
Did he ever say, you know, look, I don't even know what you're talking about anymore about firing the gun or where he was positioned? Did he ever invoke to you, this basic confusion, I'm too tired?
Later on in the interview, when he did ask to put his, to think for a minute, to have a moment where he put his head down, but then he was able to clarify. But at that point in the interview, no.
Was that after you shared the fact that investigators were looking at video?
That we indicated that we had finished the initial investigation, that we had spoken witnesses, that we had video, yes. And in fact, during that time too, we asked basically for me to reiterate what he had previously had said at that point.
Just to continue on the detail associated with him holding his abdomen after being shot 5 additional times. Did you ask some follow-up questions for detail? Page 58, for instance, lines 4 to 5.
Yes, I asked him if he saw any blood or anything at that point, and he responded that he didn't.
Couple of follow-up questions. You said that Mr. Levesque consented to the sharing video, giving you access. I just want to clarify this concept of consent. If you could share with us, really what are the 2 main avenues available to law enforcement to obtain physical evidence?
Sure. Typically, whenever law enforcement is trying to get evidence, as the council had mentioned, there's typically two manners. The first one being consent. So someone can voluntarily provide consent as long as they're the owner of the property or have some sort of constructive ownership of the property. The other one being a search warrant. So we basically ask for a permission slip from the judge granting us permission to either search or seize some property.
And so consent, is this something you're familiar with utilizing, not in this case, and more broadly speaking, as a tool to enhance investigations?
Yes, we get consent all the time in cases from both victims, suspects, witnesses, from a good amount of people throughout the course of investigations.
Let's focus on suspects. What's your experience in suspects of crimes granting you consent that subsequently leads to damning or incriminating evidence?
Sure.
Do you have a conversation with the defendant, Mr. Levesque, about what he did after the shots were fired?
Yes.
And I'm going to direct your attention to page 61. And I think your question is line 4.
So I asked him, what did you do at that point? And he responds, I got back in the truck.
Did you follow up for more detail?
Yes. And Mr. Levesque goes, and I took the clip out of the gun and put the gun up on the dashboard and sat there and thought what would be the best thing to do or safest thing to do before any of you guys got there. I knew you were coming, and I pulled the truck into the driveway so I was out of the road. And I tried the phone to call 911, but then I heard the sirens coming, so you guys were already on your way.
And did you ask him about any conversations he may have had with his daughter?
Yes, so I said, okay, did you talk to your daughter at all within the truck? And Mr. Levesque responded in the affirmative. And then I further clarified, what was the conversation you had with her? And Mr. Levesque said, I said, Kira, I'm sorry. I said, I'm sorry, that shouldn't have happened in front of you. And she said, it's okay, you're protecting me, I know.
And did he make any admissions about asking Kira whether he should run or not?
Did he make?
Yeah.
He did not say that at that time, no.
Did he provide any details about a conversation where Kira was giving him advice not to run?
No, he didn't indicate that, no, not during our interview.
We had talked a little bit about how he appeared and his sharing that he was quite fatigued when he first came down to the police station. Did you follow up, or did he make any statements concerning how that may have impacted his judgment back at the scene? And I want to direct your attention, I guess, first to page 75.
So Flathers asked, yeah, worked 24 hours, and Levesque responded, yeah, and I was up all day the night, and I was up all day the day before because they didn't call me till 6 o'clock to say that I was going in at 10.
And on line 13, did he indicate how that may have factored in at all?
So he responds, yep, maybe that's why I was laying down. Maybe it's just I've been overwhelmed, I don't know. I'm sure that it probably has something to do with my, probably making a bad decision and not thinking clearly.
A bad decision and not thinking clearly?
That's what he said, yes.
And does he make any references to that again? I'm going to direct your attention to page 150, line 12.
So at that point in the interview, Mr. Levesque says, if I wouldn't have been up that long, it probably would have had a different outcome. I don't know, who knows?
If he hadn't been tired, he wouldn't have shot Kyle?
That's what he was expressing, how I took it at least.
As you know, attorneys assist you like this in public.
Okay.
Thank you. Good morning.
Good morning.
Let me go through some preliminary stuff with you too, because the jury heard that this entire interaction with Jason was video recorded, correct?
So while Jason was in the room, yes, it would be recorded on my body cam, correct?
Right, and that means that you have a video recording of the interaction at the Rochester Police Department that would be full and complete, correct?
Of when I was interacting with Jason, correct?
Correct. And that video recording would also show the jury what Jason looked like that night, right?
It would.
And that video recording would more perfectly explain what he looked like rather than your answer to some questions, right?
Video would show more accurately someone's description than my words, but I could also articulate as far as what he was wearing or what he looked like because I was there.
Yeah, what he was wearing and what he looked like. How about what his face looked like and how he looked as far as being alert and physically fit? How about that?
If you had specific questions about that, I could try and recall as far as what your questions were, yes?
But we actually have video of how he looked, right?
Correct.
We actually have video of him and how he was affected by being up for over 40 hours, correct?
There's video, yes.
Okay. And there's video of him literally laying down, trying to rest, right?
There's video, yes, of him resting.
There's video of him telling you that he's feeling hot, right?
Correct.
There's video of him being helped by you so he could sit down, right?
When we're first walking into the interview room, yes, he was escorted into the room, yes.
Right? And you didn't want him to stumble or fall, right?
Correct. I do not want him to stumble or fall.
Right. And he's complaining about being hot, right?
At one point, he was complaining about being hot, yes.
About being exhausted,
Yes.
about being overwhelmed.
Yes.
And in fact, you're concerned to the point, before we're getting into any of this question and answer, about whether EMS should be called, right?
Yeah, so obviously, whenever we have someone in custody, there's a concern about liability. So if there's any concern about someone makes an expression that they're, tired or shaky, we'll at least offer up EMS. Whether or not they take it, as long as they're competent, they're able to make that decision for themselves.
And he did express that he was tired, right?
Correct.
That he was shaky, right?
Yes.
That he was dizzy,
Yes.
that he needed to lay down,
He has to lay down, yes.
right? And he did say that he was confused at times, didn't he?
Confused, I'd have to look at a specific reference if there was.
He may not have gotten things right. He told you that.
Later on in the interview, yes, he expressed that he may have not gotten things right the first time once he was confronted on some of the other information we had, yes.
And you were very understanding on that video, weren't you, Detective?
So, yes, as part of the interview process, we are trained basically that you get more information by being able to talk to people. If you're coming at someone a little bit harder, you're less likely to get information.
No,
Yes.
that's very understandable, but it's also understandable that he was going through some trauma at the time, too.
Trauma?
You suggested he was going through trauma, that it was a traumatic experience.
Sure, of course, it would be a traumatic event for anybody for a gunshot to go off and shoot somebody.
Right. All right, so let's go through this a little bit. We've got a video that will more clearly and specifically express his mental state, right?
The video would be able to show basically how he was that day, yes.
Right. His physical and mental situation at the time of the interview, right?
It would be able to show how he was that day, yes.
Yes, and it would be specific with regard to some of these questions that were asked by the prosecution, right?
It would be the same answers and responses from the transcript, but yes, it would be specific.
Well, there'd be a heck of a lot more questions. Yeah, the entire thing could be shown to the jury and they would see the whole thing. No objection.
sorry about that, guys. I was just dealing with something. I mean, I have a proposition for you guys. What you guys want to do? If it is another short days in this case, because you know, I think it might happen that sadly we're gonna have another short case. This is if the defense doesn't present the case whatsoever. I was gonna thinking, cause we have the hearing for Lori Vallow to do. What we can to do if I can't speak. What we can do is watch the hearing for Lori, and then we could jump to the new trial and do the first day that they have today. And then tomorrow we can do closings and then verdict watch on this one. Jump on the second day. What do you guys think? Is that too crazy to do? Is that too much? Or not? Because I'm not gonna lie. I've lost interest in this one. I want to do it for a completion thing because obviously, you know, complete everything, and I still want to see the outcome of this crazy case. But nothing is too crazy. Definitely nothing is too crazy. So then we'll do that. If this case ends up early, what we might do is do Lori Vallow's hearing and then jump on a new case, because the new case only starts in about 2 hours. So, hey, nice one, Garden Bot. So, yeah. Yes, we are doing verdict game. We always do verdict game. I will post a link on it on there. Yep, the verdict game is up and running. We can do it. We are gonna do it. The verdict time. So make sure you play. So that's what if they finish early. I don't know. I don't know what's their plan, but probably the probability of them finishing early is quite high. Sadly. Which will annoy the judge, will annoy us, but that's what we're gonna do. We're gonna do Lori Vallow no matter what. During lunch break, I don't think it's gonna be a long hearing today because I think it's the final hearing before jury selection starts on the 31st for her trial. So I don't think it's gonna take a long hearing. So we can do that on the lunch break. Of the hearing, because I think the hearing it's going to be posted in about 10 minutes because they have the delay on hearings, and then we can do that and then carry on with this day. Otherwise, what we can do is do Lori Vallow's no matter what after when this court finishes, and then when the new trial starts at 1 p.m. North Dakota time, which, hang on, I think it's 2 p.m. for Eastern. Hang on, let me see. North Dakota time to Eastern. Yes, 2 p.m. So, because the new trial only starts at 2 p.m. Eastern, so what we're gonna do, we can do that. I can do a break after the hearing and then start a new stream for the new trial. And then tomorrow, when we do closings and verdict watch on this, and then we can catch up on day 2. That sounds crazy, but it looks awesome. It sounds awesome. Because I am really looking forward to the new trial. Because it's a cold case. After almost 20 years, they actually found the person that allegedly committed the crime. And now they are taking her to trial. I mean, after so long, they actually have concrete proof and more proof to actually take someone to trial. After almost 20 years. It is absolutely crazy, so I really, really want to watch that trial. And it's crazy to think that 2007 was almost 20 years ago. That doesn't make me feel any better either. So that doesn't not make me feel good. Makes me feel very old and definitely not looking forward. Well, it's 2007. I think I was finishing school or something. Oh my god, it's just no. That's crazy. How can 2007 be almost 20 years ago? Where's time gone? It's crazy. So we might do that today. Oh no, Paul, I am so sorry. Back to work. I know. Work keeps us busy. I mean, I don't mind work, but it's just when it interferes with court watching. It's just when it starts not being funny anymore. Which gladly mine doesn't, because I work in the mornings, but it does interfere me to watch rubber, which is not nice because I don't like that interfering, watching rubber Ramada. I don't like that to interfere to. It's like, why do I have to bake while at the stream, which is not fair. um so yeah, don't forget to play the verdict game if you want to. I still haven't decided what is gonna be the price of this one. Um, yeah, oh, definitely we have a good time, but I want to engage more. It's just, oh, really? Oh wow. Oh, okay, Gordon, but give me 2 minutes. I'm just waiting for them to come back from sidebar, and I'll be right back there with you. I kind of get that. I sometimes, well, I have Garden Bot to talk, and I always talk with you guys. So, like you, I consider you guys. This one. Sorry, I think I took the wrong way. I'm sorry about that. Jason, absolutely, this is going to be crazy. We are going to be following that case here. It's going to be crazy because of the time difference. But for sure, it's going to start around, I think, the 7th of April. And it should take about 6 weeks. Case one, sorry. I know, I think probably, yeah. But definitely that she representing herself, it's going to be crazy. It's gonna be crazy. Ooh, people are answering. Do you guys think guilty? And a quick verdict. So, sorry, I'm just literally looking at the verdict game responses. I think I'm gonna be. Oh, see, what do you, Garden Butt? What do they get in return for you getting me for 2 minutes? Jason is asking. Um. Oh, Willow, can you imagine that? Oh, I will write you down. Yours, case one. Don't worry. Swan, guilty. 1 to 4. Got it. So I. I think she is gonna testify. I don't think this is the case that she's like, oh, I'm not gonna testify. She is. There
The
is
objection
absolutely.
is sustained.
Ooh, sustain.
At this point, ladies and gentlemen, I am going to instruct you that there are circumstances and times when there is potential evidence or information that the jury is not always allowed to see because of various rules of evidence. And the mere fact that there might be some evidence that you have not been able to see, you should not draw any inference from that fact. Questions as to the admissibility of evidence and what evidence comes in or doesn't come in is for the court to make. Those are decisions that I make based upon the law, and so you're not to draw any inference one way or the other from that fact. Attorney Sisti, you may continue with your questioning.
Thank you. So let's start from the beginning of your interaction with Jason. You described escorting him into the station and taking him to a specific room,
Yes.
and you went up an elevator, I guess, to that specific room?
Yes, we took the elevator from lower booking up to the ISB interview room.
And right at the beginning of this particular interaction, Jason described to you that he was dizzy.
He indicated during the elevator ride that he was getting dizzy, yes.
Yes. And this would have been at or around, what, 10:30?
Somewhere around there, yes.
Shortly after the shooting incident.
Correct.
And he says he's dizzy, and that was just when you started
When we started what, sorry?
talking to him.
Talking to him, we didn't talk to him about specifics at that point. We were just bringing him into the room, get acclimated, build rapport at that point, yes.
Yeah, it was the first contact you had with him. He's already telling you that he's dizzy, right?
Yes, that's why I asked him if he would like EMS.
Right. And it was at that point in time you asked whether or not EMS should be called in, right?
I asked him if he would like EMS, and he indicated no.
You told him that it's not unusual, right, that in fact his body is reacting to stress.
Correct?
And let me just ask you as an aside, have you been involved in any officer shootings? Anything?
I've been on scene for one, but I wasn't directly involved with it, no.
I mean, let's go right to it. Have you ever discharged your firearm during the course of your service?
No. Not at somebody, I'll say that. I've discharged it as part of training and as annual qualifications, those kind of things.
Right, but never during a situation where it was discharged and actually a round struck a human being.
No.
And even in your business, as trained police officers, you know for sure that your body would react in such a situation.
Correct.
And in fact, in your situation, the policy is there's a cooling off period before you make a statement.
I'd have to look at the policy. What do you mean by cooling off?
Judge, I'm going to objection sustained.
You haven't been involved in an officer-involved shooting, right?
I have not been directly involved in an officer-involved shooting, yes.
But you sympathize with Mr. Levesque that he would be experiencing stress, right?
Sympathize might not be the correct word. I'm doing an interview. I'm trying to build rapport, yes.
Well, you're trying to, doing a couple things. You're trying to, establish rapport, but you're also trying to make sure he's okay.
Yes.
Then you go over some medical stuff with him. You want to know whether or not he has any pre-existing medical condition?
I asked him at one point in the interview, yes, if he had any pre-existing medical conditions.
And you want to make sure he's sitting down so he doesn't fall, right?
For safety purposes as well, yes. I would like for him to sit down or lay down, not be on his feet.
And without him even asking, you offered him some water so he can relax, right?
For him, water, coffee, food, it's part of my training for interview and interrogation. As far as that, you typically, especially if someone had been out working all day, you want to make sure that they have access to bathrooms, access to food, that we're not treating them unfairly.
Yeah, we don't want to do that. And the other thing is that, again, as the prosecution said, the food that was offered was like pretty minimal, right?
It was a beef jerky stick and candy. That's all Flathers was able to come up with while I was with Jason, yes.
Let me ask you, do you know what he had eaten over the past 40 to 42 hours?
I don't know, no.
Isn't that something you generally ask to make sure that he's okay?
Again, I asked if I offered him food and water. As far as generally, I don't know if I've ever asked somebody when the last time you've eaten on an interview.
No. When's the last guy that you interviewed that had been up for over 40 hours?
I don't know if I've been in this unique circumstance before as far as interviewing someone that's been up.
Right. That's an extreme amount of time to be up without any sleep, isn't it?
You're asking someone that does shift work.
Yeah.
It's, as far as answering questions, I mean, I think everyone in the room has at one point in time stayed up all night and either had college courses or tests or final exams or kids. It was my understanding based on his responses and how he interacted that day that he was able to articulate himself.
Articulate himself, and that would be something that was, again, something that would have been on the video.
Correct.
You knew he had worked all day, not only just stayed up all day for 40 hours, but was working.
Yes, I've worked for a plowing company before. I know what kind of work it is, yes.
Right, and it can be very exhausting.
Probably less so for driving the truck, but yes, it is still exhausting.
Right, I mean, you don't know what else he was doing. Was he loading salt too that night?
He did indicate at some point that he handled salt, yes.
So he'd been in and out of the truck, right?
He would have had to handle the salt, yes.
You don't know if he was doing any hand shoveling either, right?
I don't believe that came up during the conversation.
Did you ask?
I don't recall.
At one point, you said, if you feel like you need EMS, or if you just want water, Levesque says that would probably be good, right?
Is there a page in line that you're
Yeah, it's
referencing?
page 9, lines 3 through 6.
Yes, he responds, that would probably be good, yeah.
And then you take his handcuffs off so he can eat and drink, right?
Yes, I say, I'm going to have you stand up, take the cuffs off for you so you can eat and drink, still feel good, not like you're going to pass out, right?
And he says, no, I'm still wobbling.
Correct.
So at the point he sits down in the interrogation room and the cuffs come off, he's wobbling.
Is what he's saying, yes.
Yeah. I mean, he's expressing to you his physical condition.
Correct.
And you said, I'll have you sit down after just because I don't want you to fall.
Correct, and he says, I appreciate that.
Right. And you respond, yeah, no, it's traumatic, I'm sure. So you can have a seat. And if you want to take your hoodie off, right?
Correct.
If that makes you more comfortable if you're hot, right?
Yes.
And then he asked permission to take it off.
Correct.
And that's when you notice some blood on his hand?
Yes.
Do you ever figure out where that blood came from?
I asked him about it. He never clearly indicated where it came from, no.
Right. In fact, he was kind of mystified by it as well, right?
That's what he expressed, yes.
So he doesn't even know where the blood, and it was on his, was it his left hand?
Correct.
He doesn't even know at that point in time, while he's sitting there with noticeable bleeding, where the blood would have even come from, right?
Yes, and to be clear, it was very minimal blood.
Right. You noticed it.
Yes.
Okay. He apparently didn't even notice it.
Correct.
And then you drew his attention to it, right?
Correct.
And then he said, I don't know where it even came from. Basically.
To something to that effect, yes.
Now, you want to give him some time to compose himself, right?
Correct.
And this is where you start building the rapport with him, right?
Yes.
But right out of the gate, to direct your attention, where it's nice to meet you and so forth, on the bottom of page 11,
Okay.
where he says, my name is Jason,
Correct.
and you introduce yourself as Jake,
Yes.
and then basically he says, nice to meet you, Jake. Wish it was under different circumstances, right?
Correct.
I'm going to object to continuing. It's just hearsay.
Can we approach?
And sidebar. I think if we would be counting sidebars, we would be already on 500 by now. Probably not 500, but you know, I like to exaggerate. But I think it should be so interesting that Laurie Who's Laurie Dell? Laurie. I don't understand his line of questioning is asking, oh, we identified you as Jake. No, I identified me as clown services. Lol. I know. That's, well, we don't have Bucky's here, but definitely emergency run to Costco. I can definitely, oh, I almost pressed the button that ends everything. Oops. We all got it.
Ladies and gentlemen, it is 12:03 and we're going to take our lunchtime break. It's meaningful time, and so we're going to stop. We're going to take an hour lunch. We're back at 1:03 or thereabouts, following lunch. Thank you, folks. All rise for security, please.
Oh yay! It's lunchtime. So what we're gonna do is we're gonna very quickly go. Hang on. 1 second. Oh, where? What did you order, pickles? I need to know. 1 second. Sorry. Hang on. Oh no, we are watching. Never mind. Just me. Oh, okay. All right, Willow. Are we gonna probably watch the Lori Vallows hearing, during lunch break, and then do a bit of a break, and then yeah, for food. Oh, are you sharing? I'm gonna Google that restaurant pickles. If anything happens to my Google account. Oh, sidebar. Why? Oh, they are actually. It is. It is actually a restaurant garden, but I did Google. It's not. Sorry, it looks very awesome. Sorry, it's hilarious, pickles. I don't know if I should stay here or go, or because like I don't know why they are arguing a sidebar. I think they are talking about timings and schedule. I know you don't lie or you don't lie about food, but I thought it could have been a misspell. Okay, I thought it could have been that a misspell of something. It could be the hormy, not the you know. Just an awesome coincidence. All right, so we are on lunch break. Nothing has happened. So what we're gonna do is we're gonna jump to Lori, and hopefully that one won't be as long as the court. But I know we need to be back in an hour into this court. We will be back. So where's Lori? Let me just put from the beginning. It only started like 12 minutes ago, but so we have an hour anyway. I don't think the hearing will be that long anyway. So you were what about the foot, about the hearing of Lori? Both. So we're gonna watch now the Lori Day Bell hearing. It's one of the last hearings that she has before her trial on the 31st of March. The jury selection starts on the 31st of March. So here we go.
List as people that they may hear.
What I could do is on question 15, where it lists out my name, the court staff, I forgot I need to include your name, the attorney's names, the advisory council's names in there. I'll add those. But at the bottom where it says other potential witnesses, I could do a third or another category that says other people that may be referenced but are not going to testify unless those names. That's fine. Is there any in addition to those two?
That would be the only for that. I think the other issue is, of course, the defendant's supplemental 15.2 names.
When was that filed? I haven't seen it.
I filed actually 2 motions to preclude them all and emailed them to your court Sunday.
Okay, maybe that's in my folder that's on my desk. Before we,
Defense filed that on the 12th of March.
okay, before we get to that, let me ask the defendant. Other comments on the proposed questionnaire and the information that we're going to put in there?
I think it's
What's that?
pretty clear.
Okay, do you have any objection to listing Tylee and JJ because they will be mentioned?
No?
Okay. All right, let's take a look here. Let me ask the state, you have 21 witnesses listed. I need to look at the defense witnesses that were listed. And after jury selection, I recognize jury selection could take longer than the initial week that I've set forth, but from April 7th to May 15th, the current screening, that is 20 full days of trial and 2 half days, so essentially 21 days of trial. Do you really think we need to screen that far out? I know you're being overly cautious.
I think, especially given that I'm not positive we'll pick a jury in that first week, I think we should, Your Honor.
All right. Defense have any comment on how we're screened through May 15th?
I think it's plenty of time, Your Honor, myself.
All right, let's deal with a couple things. First, I've received the notice of compliance. That was when the defendant requested the Gilbert video. Is that apply to the second case or this case?
Your Honor, it's an incident that occurred in January. It's not really, it was disclosed because it is mentioned in the DR. The defense had filed a motion for the state to disclose that, and then had brought up again on the 11th that the state had not disclosed it, that there was some YouTube video of that. I have looked for said YouTube video. I have gone through the police report. I don't know what video she's discussing, but we're not aware of any video that hasn't been disclosed. So I'm just providing notice that disclosure is complete as to that police report that is peripherally relevant.
All right. Any comment on that?
Yes, Your Honor. For clarity, is the state proposing that there is no video or that they don't have to give it to me because it's not attached to that DR number?
I think what she said was she's not aware of what video you referenced. So as far as her knowledge, she doesn't have it and doesn't know about it.
So I should go directly to Gilbert Police Department to get it?
Well, last time you were in court, you said your investigator or someone told you about it.
A mitigator.
A mitigator.
Showed it to me.
If they have that link, why don't they just send it to the state, and that may help the state determine if that's something they've already disclosed?
I will tell you why they won't, because that is my former team, and they will not do anything to help my investigator, my paralegal. They won't give us any information that they found. They won't talk to us at all because apparently there was a conflict. So they will not help us. They will not send us anything. They will not email us anything. They will not answer anything that we ask them to. So that has been the response from my former defense team. That's where we are.
All right. Do you know, and maybe your advisory councils can speak to this, did they turn over a file to you, or did you have to start from scratch?
No. From what I understand, all they turned over was the 22 terabyte hard drive, and that is it. They didn't turn on any notes, any work product, nothing that they had done to that point. Continue to stand by that today, even though a lot of that information I gave to them, they would not give it back to me.
All right. I'm going to make an order, and it'll be in the minute entry that they turn over a copy of their entire file, including any mitigation information that was gathered to the advisory council. That makes Hicks, you look like you want to say something.
I don't know. No, I'm good, Your Honor. Thank you.
All right, so I'll do a more detailed order about, they should have turned over a copy of their entire file to advisory council when they withdrew. Defendants, all right, so I've read the defendants' disclosures that were filed March 6th and March 12th, as well as the state's motion to preclude. And, well, let me start. Have you received any response from the defense, anyone from the defense team since you filed this on March 16th?
Your Honor, last night at 10:30 or so, defendant's investigator sent over a list of the addresses of the witnesses. I did speak with him this morning. I still am unclear if defense will be setting up those interviews or if they will be providing phone numbers to the state to set them up ourselves. As for the expert, again, last night at like 10:30 at night, defense investigator emailed the state and indicated that the defense expert would need to or wanted to obtain the physical laptops and cell phones that the police had impounded so that he could then review them, do his own Cellbrite or extractions. So obviously the expert hasn't even begun work, let alone, they've also requested all impounded items from law enforcement. I'm unclear if they're asking for ones that were impounded in Idaho as part of their investigation or just the ones here. The statements from the investigator appears to be all of them, which would mean the state would have to request Idaho to send those to the investigator. So again, given all of those issues, I don't see how that it would be possible for the state to provide that to the expert prior to this trial beginning, let alone to get a report or an opinion prior to this trial beginning.
All right, let's set aside Dworkin for the time being. So you're, well, let me ask the investigator. What's your name, sir?
Jeff.
Jeff what?
White.
Okay, Mr. White, are you going to be setting up interviews for the state to interview whatever potential witnesses the defendants noticed?
I'm trying to verify, excuse me, sir. I'm trying to verify the phone numbers to be correct. I do have a few of them, but some of them I'm trying to make sure that these are the correct numbers.
Okay.
I did the searches for them, and I have to apologize. I left yesterday, and for some odd reason, my email just did not go through. So,
Your Honor, my understanding is that the state has interviewed every single person on my witness list previously. That's where I got the people from the interviews that they had from the state previously. So I understand that they're allowed to do another interview of them, but they have interviews of every single person that is on my list, with the exception of one.
Which is who?
Which is Nate Eaton.
Okay. When you say the state's done the interview, do you mean police or someone from the prosecutor's office?
In discovery, I have interviews with police on every single one of the witnesses that are on my list.
Okay.
So I know that they had their addresses. I know that we were trying to get the addresses to them in the quickest way possible. And where I am at the jail, the communication is very difficult for me to get a hold of my investigator, to get a hold of my paralegal. I'm 23 hours a day locked down. If I don't have Wi-Fi, I don't have a phone. If I don't have battery, I don't have a phone. I don't have access to get to people. So I understand that I understand the time constraints, and we're doing the best that we can of getting things answered, getting things put together.
So as a threshold question, your assertion is that all these people that you've listed in your notices have relevant information for trial?
Correct.
And do you know if the police have interviewed these people?
Your Honor, the
They may be
first
referenced.
listed person is a reporter. So I'm not really sure the relevance of a reporter.
He's the only one that hasn't been. So that's what I stated.
So, Your Honor, the point is to start with, one, these people, I'm not sure all of them actually have been interviewed. Those that have would have been interviewed 5 years ago. So whether or not their addresses are correct, unclear. It's not the state's responsibility for the defendant to do the defendant's work and find these people. I have an absolute right to do interviews just as the defendant does. So in terms of the witnesses, I think that most of them, as best I can guess, would be character evidence, which would be improper under 405. So depending on what they say, then I need to file motions to preclude or motions in limine for any or all of these witnesses.
All right, so it's premature to address these today. The state's going to have to interview them and find out if, in their opinion, they have relevant information or not. And then if there's a dispute out there as to whether or not they'd be called, I'll have to deal with that as it comes up. But if they're unable to be located or interviewed, obviously they won't be called at trial. Mr. Dworkin, if you want him to do extractions, you're not ready for trial. So in order for him to do the work that he's requesting, getting copies of a laptop or a cell phone or whatever the case may be, that's going to take him time to extract and analyze and then prepare a report, months maybe.
I understand that, Your Honor, and I'm hoping he can do it in an expedited manner. I requested him from OPDS on January 14th. He got approved on March 7th.
Well,
from OPDS.
You're the one pressing for your speedy trial, so you kind of have to make a decision on, we're set for trial. You want to go to trial or you want to have him do that work that you want? Because I don't think both are going to happen. Even if you got the laptops today, generally those types of things can take weeks, even months to analyze and prepare a report on.
I understand that, and I also understand that I've only been given 10 hours for him from OPDS, right? So if he could spend 10 hours this week getting them ready, then he can give us a report with the best that he can do.
Well, the report's already late technically, but if it were allowed, first of all, it's going to take time to coordinate him getting the, let's start here. Specifically, what are you requesting? Because the state wasn't clear whether you were requesting items here impounded by a particular police department or items that may be impounded in Idaho.
Well, I'm sure that my investigator would like to have all of those things done, and I realize that we're on a time constraint, and I would be only concerned with one item, which is at Chandler Police Department, which was Charles, my husband's phone, Charles Vallow's phone. And I would like a copy of the extraction that they took from it. The digital forensic extraction from Chandler Police could be given to him immediately. That would be very helpful.
Wasn't that already disclosed?
Yes, Your Honor.
Was that part of the initial terabyte?
Yes.
Excuse me.
Yeah.
Everything that I have is on a 22 terabyte. So if hard drive. So if I give that away, I can't do my work.
Well, can't you make copies of files out of it?
22 terabytes.
I understand that.
Okay.
So what's your proposal?
I'll take it up.
I mean, if you have all that information in a file, I'm not saying you have to copy the whole 22 terabytes, but there's a file in there somewhere that's the Celebrite extraction already for that requested item that's been in defense possession for however long now. I'll take it up to Lonnie. So I'm happy to make an order, but again, if he's not done with that information you want, are you still wanting to proceed to trial at the end of this month?
Yes, Your Honor.
Okay.
Do you know what's really fun? Making a website on wits.
And secondly, under the rules of evidence and rules of disclosure, and secondly, depending on what he says, the state would have to have an opportunity to consult with an expert as well. So even if he got something done, it could still be precluded, but I'll give him the opportunity to do whatever it is that you think he needs to do to analyze that. But that information's been in defense possession for months, if not over a year.
More than a year, Your Honor.
Yeah.
And he was just approved by OPDS last week, Your Honor.
I thought you said he was approved. You applied in January.
I applied for him in January and last Friday, he got approved.
Again, this is one of those things where you have to weigh your options on whether it's worth it to get a continuance so you can have your defense do the work that you want done on your defense. But if you're telling me you don't want to do that.
I would like to do that, but my situation in my housing department precludes me from doing that.
From asking for a continuance?
No, from getting things done in an effective and quick manner.
Okay. All right, well, so you're telling me you don't want a continuance because any information he has at this point could be precluded as being untimely.
I understand that is the rule, and I understand how unfair and prejudicial that would be to me.
Okay. So I guess I'm going to have to cross the bridge on whether these notice defense witnesses are even able to be located and interviewed before I make a decision on whether they have relevant information and can be called at trial.
Obviously, Your Honor, we have a little over a week to try to interview these people, so I will
understand.
file something at the end of next week indicating who I've been able to reach and interview and ask to preclude everyone else.
All right.
They also obviously asked to preclude them regardless,
Right.
based upon what they may say.
All right. What else do we need to address today then?
Your Honor, the only other motion that we did not address last week was the state 609 motion. I presume the defendant will likely testify, so I don't know if we wanted to address that now.
Are you prepared to address that now?
No.
I generally will, I guess I'll advise the defendant now that if you choose to testify, it's likely that the jury would hear about the convictions. But at your request, they could be sanitized, meaning that they would only hear about the fact that you have convictions as opposed to what the nature of the conviction are. But that would be up to you whether you want that information out or not. And then the jury would receive a limiting instruction that the existence of those convictions is only to be used for the purposes of determining credibility. So you should be aware of that when you make a decision on whether you want to testify or not. Oh, if you do want to testify, it will be question and answer, meaning you need to write out all your questions that you want to be asked and have one of your advisory counsels ask those questions to you when you're on the witness stand.
Right.
Okay, so you can't take the witness stand and just give a narrative. It'll be question and answer.
So am I supposed to reply to the 609? Is that what you're saying? And ask for it to be sanitized if I want that?
We can talk about that when we actually have a 609 hearing, but yeah, you can make that request orally. You don't have to do a written response. I indicated last time for your opening statement and closing argument and questioning witnesses that you'll pretty much be limited to the podium. We'll be in a different courtroom apparently for trial, but it'll be set up very similarly. Either your investigator or one of your advisory counsels will approach witnesses with exhibits if you have to show a witness an exhibit. So I'll have to do the same limitations on the state. The state would be confined pretty much to the area of the podium, and the state would have someone assist in approaching witnesses with exhibits and that sort of thing. All right.
I have some motions that I'd like to file. I've had a really hard time getting, my paralegal
copies
is
for the
very
state?
busy. I don't have copies.
All right, we'll make copies and give them to the state, and then we'll file them, and depending on what they are, I'll rule on them as the response and replies come in, or we may have to address them depending on what they are. So plan on that questionnaire going out. I think we said next Thursday, the 20th, will be sent out to potential jurors for the first batch of jurors, and then the responses would be cut off on the 26th.
Judge is going to be sent out Monday the 24th and will end on Monday the 27th.
All right. And then I'll meet with the parties on the 31st to go over those remote responses. So that'll be the 31st at 10:30 a.m. Then again, I'll just reiterate on April 1, are we having we're not having walk-ins, Izzy, until the 1st?
Right.
Okay, and then on the 1st, we will meet again, and for the rest of that week, we'll likely be meeting at 10:30 and continuing with jury selection every day until we get enough jurors. Hopefully, we get enough the first week. If we have to, we'll go into the second week.
Yeah.
Judge, I know that I'd given you a date that I was going to need to be dark on. I'm going to put out there, since I obviously don't know when we will get the jury picked. I do have some witnesses that are flying in, so I may have some days where I may need to end a little early or whatnot to try to accommodate some witness schedules. But I'll keep the court updated once we get a jury picked.
I think we'll have a good idea by about day 2 of jury selection whether we're going to need to go into the next week or not. That reminds me, though, is I would like the parties to plan on, we're going to have a much better idea after about the second week of trial and the first trial, how the second trial will unfold as far as how many jurors we might need. But I would like the parties to plan on doing another remote questionnaire with a much larger pool for the second trial and meeting on Friday, May 30th. And for scheduling purposes, so everyone knows, I'm planning on probably going Monday through Friday of the week of June 2nd, as well as Monday through Friday the week of June 9th, to try to get as much done as we can. And then there's going to be some dark days there toward the end of June, but we need to get it done by July 4th.
Your Honor, when are you planning on starting that trial?
So jury selection would be starting May 30th. All right, anything else from the state for today? If you want to stick around, we'll get you copies of those motions.
I do. Your Honor, I guess the only other thing is, for the questionnaire, I'm going to put in the defendant's 15.2 witness list.
I'll put in those names preliminarily. It doesn't hurt, just in case anyone is called from that list. And if anyone knows any of those people, I will put that in, actually. Anything else from the defense?
So I'm unclear on where we stand with the video that I requested.
The state says they don't know what video you're talking about. they've disclosed everything they have, so I'm gonna make an order to your prior team to give you whatever that is. If you have a link in that information, you can forward it to the state so the state can see if that's something they've already disclosed or if that's something Gilbert didn't give them, or on the other hand, since it was told you secondhand or showed you secondhand, whether it's something different than what you thought it was. I don't know. So I'll make an order that they hand over all those things to you, so maybe you can figure that out. But at this point, the state says they've disclosed everything that they have and everything that they're aware of.
And in that order, they'll give it to my advisory council, or who?
Who do you want me to, I was gonna say give it to your advisory council. Do you want a more narrowed order? Maybe any mitigation work that was collected, or do you want a broad order that's basically everything in their possession?
Well, it would be nice if they could turn over everything in their possession that we worked on.
I was just thinking
together.
it would be easier for you maybe to find that needle in a haystack if it was a more narrow order.
Well, she knows what the link is, and she could just give it to us, and we asked for her to do that, and
What's that?
the attorney said, no, she can't do that. She can't give you any.
What's that mitigator's name?
My mitigator's name? Pamela.
On your prior.
Pamela Kearney.
Do you know how do you spell Kearney?
Cerny.
All right, I'll make a specific reference to that.
And do we need an order, Your Honor, to pick up my husband's phone at Chandler Police so that Lonnie can do the extraction?
Well, you already have that extraction in your discovery. What's the state's position on Lonnie Dworkin meeting someone at, you said Chandler, right? Chandler
Yes, at
Police
Chandler
Department
Police
to do another extraction.
Your Honor, obviously the state and defense have always had stipulations so that should something happen to the device while it's in the possession of Mr. Dworkin, that there are now no issues with chain of custody or anything else. So the state would have to draw up a release, have that scheduled on who it's going to be picking it up, have the defendant sign that release indicating that she understands that should anything happen to that she waives those rights to claim those things. So
I think what I was asking was, does Mr. Dworkin have the ability to just do the extraction on site?
on site where? At Chandler?
At Chandler.
I don't think the police departments allow anyone to go in there and conduct their work in the police department.
Okay. All right, so to maintain the chain of custody, the state can draw up an agreement, and if the defendant signs that agreement, then Mr. Dworkin could pick up that phone.
That's perfect. Logistically, how's that gonna happen?
She's gonna forward that to your investigator, and I guess he'll have to come down and have you sign it.
Okay.
All right. Be at recess.
All right, so that was the hearing for our lovely friend Lori Vallow. Well, friend, you know what I mean. A bit too gracious there. It's interesting that I am hoping that they don't go until May in this trial, because I need to talk to Garden Bot, and maybe I need to talk to as well to our friend Zio. That there is a week in April that I am not gonna be able to stream, because as you guys know, I've told you before that my sister-in-law, she is due at the end of April. So, and obviously for that week I'm gonna want to be with her, and I wish, Paula, I wish it was. Well, I wish and I wishing, because I'm gonna get to know my niece, so, which I am very excited about, and I want to take a week to be with family, to be with her, and everything. So I really, really wanted to be with her the first week. And I'm even going to try to take some time off from work, but I'll see how things go, because she's due at the end of April, but, you know, it can be at any time. but yeah, I really want to spend some time with her. But I'm either Garden Bot is going to replace for me, or our friend Zio is going to be doing the stream for me on that occasion. But I'm going to be so upset if they go really into the end of April, which is more likely that they will. And I'm gonna be a little bit gutted, but I'll see how it goes. And it all all depends on my niece if she decides to come on time or not. Uh, all depends on her. And if everything goes right. So we'll definitely keep that in mind. But I will have something sorted and in place in the case that I need to hand over the stream for a week or so, or a few days, because it would be perfect if she was born on a Friday night, on a Friday, because then I would still have the weekend, and then now I need to make sure that she is born on a Friday, not on a Thursday, on a Friday. No, I'm joking. Um oh, Jason, don't make me even more jealous. I really want to go to the US. I'm trying to get the Garden Bot to go to the US so much, but things keep happening and responsibilities. And why do we have to be responsible adults? I don't know why. I would like not to be a responsible adult anymore. I would like to unsubscribe to that adulthood. But we're planning maybe next year to go. I was thinking this year, but the way that our year ended, probably not. Definitely not, sadly. But maybe next year we'll see, because it takes as well time, a lot of time, to apply for visas and making a plan. Because then the thing is, I need to know exactly where am I going to be, like a point would be easy for everyone to reach, or do a couple of states or and everything. I know, adulting, Stephanie, don't even, especially when you have to wake up at 4 a.m. to go adulting. It's not good. Definitely. It's but oh, 1 second, give me 1 sec. Sorry, sneezels. I was quick enough. But it is interesting that it would be. I think if Lori, it's almost, I would say, it's almost 100% sure that Lori is gonna testify. First of all, she will not refuse to of an occasion to testify and to talk about herself. Yeah, I think that is gonna be probably the best place, Paula. But I do want to go to Florida for some reason. I don't know why. I don't like the heat. I don't like the hot weather. So I don't know why I want to go to oh. I was it that exciting, Stephanie? That's a bit early for bagels. Oh, that would be awesome. The thing is, I really want to go. I don't know why. One of the places definitely that I want to go, it's New York. For some reason, I want to visit Florida as well, because I do have some true crime friends from there. You know, Jules and Chris and Erin. I would love to meet them in person. So my ideal would have been, so I would do New York, Florida, and then go to Missouri, and then in Missouri, people, maybe Pickles and people could come to Missouri, because I don't think I'm ever gonna go to LA. I think that would be way too crazy over there. It is a crazy state, but well, that's why they probably will take care good of me up there, because I'm crazy. Nah. But I don't know why. I was like, I literally need to do a US tour. I wish I could do a US tour, literally go to, but yeah, to visit everyone and seeing everyone, that would be amazing. Definitely. I think Missouri for sure. Absolutely, because it's in the middle and it would be like the middle point. Um, as well, to meet everybody. To we could do like hang out stuff. I mean, it's we can talk about probably when we have more concrete plans and everything, but definitely that is an idea for sure. Just doing a bit maybe of a recap of this hearing, and then what we're gonna do is I well, I've heard maybe flying would be best because I don't think driving. First of all, driving would be driving on the other side of the road and of the car for us. I watch way too many dash cam videos to ever attempting driving in the US, so that would be no. And I've heard that like you can drive for 8 hours and you're still in the same state. And yeah, I want to try maybe to save as much time as I can. I don't know. Um it is that is why like one of the things that is like driving in US. Yeah. Oh wow. Okay, that is not too bad. Well, a day, do you mean 24 hours or like 12 hours, like half a day? Uh, yeah, because I was like, I don't know, because driving, first of all, I would definitely not drive. I would let Garden Bot drive. That is 100% sure. I would definitely not drive in the US. I barely drive to work as it is. I don't know. I drive if I absolutely have to. But not if I have Garden Bot with me. Definitely I'll let him drive. And he doesn't do well as a passenger either, so me and him together, perfect match. But definitely like if I could not do New York, I don't think I would be sad, but I don't think I would be a lot sad if I only do Florida and Missouri. I think that would be okay. I but it's just a thing of planning a lot. There's a lot of planning, and then make sure we can find places to stay, hotels and stuff like that, and yeah, and saving for that. But that's definitely on in the plans and in hopefully very short future projections. I can't even speak. um Oh no, it's alright. Not really. They were just talking about scheduling the new trial pickles. That is gonna be like in end of May, beginning of June. So that's just the normal standard things. And now we're just talking about the possibility of me coming to the US next year. We're just talking about that. And what we would, even though like what is gonna be crazy is what's gonna happen is when the court starts, I am gonna be a little bit behind the scenes because I'm gonna have my lunch because it's dinner time, it's tea time in the UK right now, and Garden Bot is gonna make tea in a second, and I need to eat. But we'll watch court. I don't think they're gonna take much longer. The defense trying to question, but I wanted to talk. Who here thinks, right, that Laurie is gonna testify? Because I think that she is gonna testify. I am almost 100% sure that she is. She is the type of person that she wants to have the last word, and that she's gonna try to talk. But by talking, by wanting to testify, she's gonna open the door, literally, of the sentencings coming in and absolutely get her. I think so. I think so. Absolutely think so. And I cannot wait for that. I honestly, if she testifies, and I don't even care about the time difference, I am gonna be there and I'm gonna be watching. Even if she finishes at 5 p.m. Arizona time and it's gonna be like midnight for me or 1 a.m., I don't care. I'm still gonna be there. I am gonna listen to her testifying for sure. I want to watch that live. I cannot watch that on a rewatch crew. I would if I have to, but I will try to. I will definitely be here for that, which is gonna be awesome. The state's having 21 witnesses doesn't scare me as much it is gonna definitely be more than a 2-week trial. I think it is very high likely, unless the witnesses that the state have are very quick, like bang 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 done, and they do what, 5. So if, like, for example, because I'm like contrasting the 21 witnesses with this trial, because we've had so far 9 witnesses on this trial, right? And we are on day 5. If they have 21 witnesses, that will be about 10 days, 11 days for the state's case. And then we would have the defense, so that'll be about 2 weeks, 3 weeks time. I don't think it's gonna be a lot until like 15th of May, like they say it will, and I hope not, because, well, it's the attention span that is not gonna last long. But I think Laurie is gonna keep that too entertaining to definitely keep our attention grabbed, and us at the edge of our seats for sure. And we need to start thinking of what we're gonna count. Oh, sorry, 1 second. Oh, sorry about that. GardenBot was getting a phone call, but it was just spam call. I still need to figure that out. The getting, maybe for Lori Vallow, I can try to see if I can have like a line you guys could call, and at the end of the day we could chat. That could be an idea. But I still haven't found a good how to work that. I need to ask maybe alright about that, how to do that, and how to get that set up. But I haven't figured it out yet, that, and I need to, because I really want to do it, because that would be fun, you guys calling in. Or you can just jump on the stream, on StreamYard. You can just click on the link. We can do panels and stuff like that. For sure we're going to be doing panels with Lori, and talking about this crazy. You don't have to be on camera. You can just have your camera off, and you can just come in, give your opinion, and then go. Absolutely, that could be a good idea, and it will be easier to do than actually doing through the phone, because sometimes phones, the lines, you don't hear very well. Well, the internet happens exactly the same thing. I'm not saying internet it's 100% clear, but yeah, it could be that. So what we're gonna do is we're gonna go. I'm gonna put the feed up, right? The feed is there. Everything is set up. I'm gonna go and garden what we're gonna eat. I'll be back in about half an hour. I think Court probably will be back by then, but I'll still be here. But I'll just be eating. So yeah, you can try now. Do you want to try now, and you want to come, Paula? I can put on the chat if you want to come. Let me just turn this off. Take that out. So put the link in the chat. If anyone dares to come up, you can come up. Sorry, 1 second. So if anyone wants to come up, please, you can come. I'll be waiting. I am waiting. See if anyone is brave enough. No, I'm joking. If you want, just be like obviously mindful that we need to be careful, but we can do that. I'm waiting. Ooh. Hello? Can you hear me, Paula?
I can, but are you?
Yeah,
Can you hear me?
Yes, I can hear you now, and I think can you hear Paul on stream? I'm just having GardenBot to check it. 1 second.
I had to mute one stream.
Yeah. Oh, you are. Yay! We hear Paula. Hey!
Yay!
Is this your internet debut?
Well, no. It is through StreamYard, but I've called RA before.
Yeah, awesome. But well, it's a first time in our channel.
Hey guys. It'll work.
That is awesome.
It is painless.
It is painless, isn't it? It's not that hard. I mean, I thought in the beginning was so hard and I was so shy. Can you believe me shy? Yeah, that was it was so cringy in the beginning. But yeah, please don't ever go look into those streams. No. Yeah, so Pickles, that is in the chat is the StreamYard link if you want to jump on and have a chat and while Court is on break, we can start doing that on breaks and everything.
This is fun.
Yeah, and on breaks and on after trials and everything, we can just chat for a couple of minutes and then yeah, just to get your opinion because sometimes just talking to myself, it's yeah.
Oh, William.
Thank you. We are waiting about 10 minutes. It's crazy. This hour has gone quick. Well, we have been busy, so. It's okay.
You're at work, yeah.
Yeah, Pickle. Maybe
I can,
one.
'cause
Sorry,
I
you
work
go.
from home. I can work from home, so I can.
I think that's. Oh, Mort is back already.
Okay, bye.
All right, bye. See you soon. Are they back on? Oh, the Court. Sorry, I heard some noise. Like, was check 1 2? They were doing like a mic check or something. It's okay, Pickles. Like, we can do it like a day that's like either after work with time differences or anything, or at any other point. It's absolutely fine. I am starting to think, like, for example, at the end of a trial, maybe on a Saturday when like most people sometimes can join, we can do like a panel of a few of us and just discuss the trial for like an hour and then we could hang out a little bit so to give you guys opportunity and a voice as well. I really want to be able to do that for you guys to as well participate because it's our channel. And now Court is not are you absolutely kidding? This Court. So yeah. Yeah, exactly. It's like talking on your phone if you don't have your camera on, and you don't have to have your camera on. As you are comfortable to be, you can be with or without camera. A microphone is a bit more required because I need to hear you, but it's up to you if you guys want to talk or not. Don't feel obligated to, but it's an option if you have. I can share the link if you guys ask me, if you want to jump on a break or anything, obviously you can. Then you can see chat as well, and as well, yeah. So it is a cool idea. It's a cool thing that you are able to do, and I'm glad that like it, and it is free. So the only thing you spend is internet. So that's even better as the cherry on top of the cake, as they say. And I thought they were gonna come back. Paula, I'm so sorry. Oh, that would be crazy. Absolutely crazy. But I think we can make sure that everyone is respectful to everyone anyway. But just we would have like a talk moderator. And I'm joking. But the thing is, I think I can access the mute button for everybody, so I can just mute and talk. No, I'm joking. I can just mute everybody and talk. So, but yeah, it's up to you guys. It's an option. It's an option. It's there if you want to take it. Just want your garden bot to go start making dinner so we can have dinner soon. Pretty please. So we just second item. We need to discuss food. We can discuss on here. What's up? What food? Anything? Sorry?
With mince and peppers.
I am sick of mince.
Just do my usual.
Sure.
Also,
Give me 1 second, guys. Sorry about this. You just got them talking a little bit more about because we getting into a little bit of a snafu, but it's not of a big snafu. Yeah, I know. I need food too, Paul. I am starting to get very very hungry, and Gardenbot is gonna do our usual food because we get like. We've eaten so many minced meat that I am in the point that I can't see it anymore. But it is the one of the only things we have at home at the moment, and we are trying to use everything that we have in the freezer before we go back to. Hang on 1 second. I'm hearing my own voice. Yes, Costco. Oh, nice. That would be awesome, Pickles. That would be so amazing. That'd be cool. Yes, of course, Costco. Where else we're gonna go? Absolutely. So we're trying to use everything up before we go back to Costco and buy food again because I like to like get it empty, maybe defrost the freezer because I haven't done it yet since last year, so defrost it and then go and restock the freezer and kind of get from scratch. It is going to be expensive, but we haven't bought meat in a while, so what we've been saving on that we can just use towards the big Costco meat run, I guess. But it's getting to the point that the only thing we have is mince and gammon at the moment. So it's either mince or gammon, and I am kidding. Court is making such a weird sound, my days. I think they are trying to figure it out the tech problems, but it's not being nice to my ears either. But it's just interesting that Gardenbot just left because he's just next to me, right in the living room where we are. It's just outside of the camera view, and he's been helping us out with the modding and everything, and he's in chat. And he was listening to the stream, and he left the living room to go do dinner, and the headphones disconnected, and I started to hear myself from his computer, and that was cringy. Oh, sorry, Pickles. Hello.
I'm trying. Hold on.
Yeah, I got it. We can hear you. I can hear you. Just let us know when you're ready. Just I heard Pickles. Woohoo! It's so funny. So awesome. Just whenever you're ready. So, yup. There, we're just waiting. I know, I think we scared Pickles. I'm sorry, come back. Oh, we are just having fun, Sissy. We're just misbehaving as always. As always, we are misbehaving. Now, I just shared the link for the StreamYard. If people want to pop in on breaks and everything, we can just have a chat and yeah, and talk. No, it's on the StreamYard, so it's a link to the StreamYard, which is the platform that I'm using, and then you can just pop in, talk, like it's like a phone. You don't need to have camera on or anything. You can just be voice, like Pickles and Paula was earlier, and then you can just talk to everybody and me, I guess. I can post the link again if you want me to. But yeah. So we are just waiting for I know it was just shortly a while ago. Sadly, I thought the court was gonna come back because they started speaking and testing the mics, and she went off, which was sad. I am sorry. So yeah, now we're just waiting. Yeah, Pickles is here. Yeah, but I think she's at work, so she's trying to make sure that she's safe to talk and everything. I did hear a voice though. Sorry, I'm very excited to get like it's a little bit that I get to know you guys more, and which is awesome because you know me already. And I'm having that chance, and it is amazing to get to yeah. But it's so awesome. I am so excited. I look like, oh no, court.
Speak to me before we get started. Oh, your client's still coming. Oh, do we need him? And by the way, I heard there's one juror they're still waiting on. They just texted him. I expect he'll be back in a moment.
Right now, we're editing a clip that we can play to the jury.
Okay.
Where we know it's clean with regard to any objections. So
Oh, great.
I want to sure get in there for obvious.
Okay.
We'll have it marked as the closed different after this. Or can have it marked. We're doing it right now.
And is there agreement from the state? Yes. Very good. All right. How much longer do you think that's going to take? Of text? Okay. 15 minutes probably. You can probably do a page a minute. All right. Then what we'll do, as I said, we're still waiting on a juror who... Oh, jurors are all back. So I'm happy to give it a few more minutes, especially because that sounds like that'll expedite things. All right. I'm going to step off the bench to let you all continue that. Let court officers know if you could when you're ready. And I'm going to let the jurors know that we'll be starting shortly. Thank you.
Well, we are in another break. Absolutely crazy. Wait, what happened though? Are they doing a deal or something? Anyone? Like, yeah. That is crazy. This court is absolutely crazy. I mean, oh my days. I just don't understand. Are they doing a deal or something? Someone is late. Typical someone is late. It's just I don't know. I hope not. I honestly hope not. I would be so angry if he just goes and takes a deal right now. Please don't be a deal, because if it is a deal, I am just gonna go crazy. What are... Well, the deal includes the penny. That would be hilarious. Oh my days, that's hilarious, Pickles. That's funny. Let me, if you don't mind, my friend, I'm just gonna remove you from... Oh, the meat. Gammon. Gammon, it's like ham, cooked ham that we have a lot here in the UK. It's like a smoked meat, like bacon type thing. I don't think what it's got. Oh, hang on. Or it's like ham. Yeah, it's cooked ham. Oh, yeah. Thanks, Pickle. Sorry. Thank you for that. I absolutely will have you very soon. We'll definitely keep this up. If you guys wanted to just, if I don't remember, I will put it in the chat. Oh no, it's okay. It's fine, my friend. You're absolutely great. If I don't remember to share the StreamYard link, you guys please keep me accountable. Yeah, it's like smoked ham or in smoked ham. Yeah, Google gammon. Um, please keep me accountable to get you the StreamYard link. Every day because it's gonna change every day, or for you guys to come on and talk and everything. It is very good because it's nice. So please keep me accountable for the StreamYard link, for you guys to come on and join and chat on breaks. That would be so awesome. That's gonna be amazing. That's gonna be great instead of me just talking. That will be a lot better. um, and I am looking forward to that. So I don't know what happened. Yeah, I know it is. It's gonna be that. But the link is gonna be new. But just yeah, it is like ham. Yeah, but it's gonna be new every day. But just remind me of it because it's very easy to do it and very very simple to do it. And I would love to hear from you guys. So let me see if I can go back and see if what happened because they came back. Right, someone was late.
And is there agreement from the state? Very good. All right, how much longer do you think that's going to take?
He said something. Is their agreement from the state? So yeah. Oh yeah, we can put that. Yeah. So definitely. So he says, is there an agreement from the state? And he says, yeah, I am. Oh, grievance. No, agreement. So I'm like very interested of what agreement this is. If the witness agreement, as in the plea agreement. If I stood 5 days of this court being late, don't mind the early days of not and ends up in plea deal. I am gonna be very hungry. I am gonna be hungry. I'm already hungry. I'm gonna be angry. I know. I know. At least we had the bunny. At least we had that. But it's just wasting the jury's time, our time, everybody's time. Well, we were busy a couple days with the trial. Now is good, and we could hang out. We hang out, and we were together. But yes, I would have rather have hams. But no, like the thing is, if they do come to an agreement and ends today, hey, we can start a new trial right now, which is gonna be good. I have got everything set up for the new trial. We can just literally set up and move to the. Well, I have everything. I don't have everything. I don't have the verdict game form done yet for the new game for the new case, but I can do that in 2 seconds. But yeah, that would be good. Oh, I Dizzy, I think definitely that for tomorrow, but he's making dinner now. Which I am very excited because I'm hungry. So we are waiting on whatever is happening in court, an agreement, maybe a plea. What do you think? Do you think that the state has offered a plea over the lunch and he's taking it? And I want to know what kind of plea is they taking. I'm still gonna count him for our statistics. So whatever he gets, but I don't think he will get life. If he's getting a plea, I think he's gonna get years. So I don't think is getting life, because I think that's what he's looking at the moment. It's life with the possibility of parole. So I don't know. We'll see. What do you guys think? I would be mad if they would be taking a plea deal right now, and we would be wasted all this time. But hey, I think it's life. It's one of those things. Yes, you can vote to no more work. Yeah, absolutely, Pickles. Yes, you can. I will vote with you. And yeah. Oh, talking about work, my job, my day job, the supermarket job. We just got a raise. Because we are paid hourly, right? And so we just got a notification that it's gonna raise. It's not even a pound or a dollar anyway. Oh yeah, the Nicole Rice one. Yay! It was not. It's not even $1 per hour, but it's fine. It is better than nothing, I guess. It's just for them to keep us happy. But the new trial is the Nicole Rice one and Anita Gnuston, and it's out of North Dakota. It's a cold case. Yeah, it is, because I'm trying to hide it. Hey, thank you. Also, thank you. I know I could live in this. Pickles, I will literally could live in this sweatshirt and the other merch that I have. I am addicted. I have a problem. That is the new trial, the Nicole Rice out of North Dakota. It's a new state. We haven't covered any trial in North Dakota, so I'm excited for that. It's a cold case from 2007. This happened in 2007, the new case. And only in 2022 they were able to make an arrest on that case. Now she is going to trial. The case is actually supposed to start today. They are starting today in about 40 minutes. The case is starting, but we'll be catching up tomorrow. Hopefully tomorrow while on verdict we can catch up on the first day and then catch up on the second day, and then maybe Thursday be a little bit behind. We'll see what happens. But yes, so that's our next case. It's literally lined up. Jury selection has been done, has been completed. All pre-trial motions are done as well. They're literally starting openings this afternoon, which is crazy. And I really want to watch, because it's a cold case. What's intriguing me in this one, right, is after almost 20 years, right, they get concrete proof that this girl did it, that they take the trial and everything, because you would think that after so long they probably would like not prosecute or get a deal or something. But yeah, I know it does sound very good, so I am hoping that this one finishes quick so we can just jump on straight. And I think the judge wants it to finish, so that's why I'm not too mad if he gets a deal. If they do get an agreement, I'm literally creating a new StreamYard already, a new link for the new case that we can literally jump onto and just start the new trial. I know, I'm crazy. But that is exciting. This one's, I thought it was exciting as well, but it got too boring. Yeah, I know. I am good with a deal for this case, because in a way, I don't think the state has proven a lot, but also in a way, I don't think the defense hasn't proved that is either. So I would say that the jury would be a hung jury. For me, I think if I would be playing the verdict game right now, I would say hung jury almost for certain, because I don't think they can get a conviction without either the victim testifying or Jason testifying. So yeah. Oh, about what? The Nicole Rice or this trials, is it, that we're watching right now? Yeah, exactly. Yeah. There was a fight, yes, but we don't know. Oh yeah, this one, yeah. So that's weird. I don't think it's a very popular trial because I think it's uh I don't think, yes, there was a fight, but without the defendant testifying and without the victim testifying as well, it's a case he says. So there's no concrete proof because the cameras don't have audio. There is not a great picture of what's happening because it was dark. So the evidence is not a lot. Yes, there was an incident that has happened, but who provoked who? I came into this trial not thinking that he was guilty, and I am on the hung. Uh, yeah, I think so. Yeah, I think Gore TV quit. I think they quit on streaming this one because they don't even have a feed anymore. Yeah. This is not the trial that they were expecting to be. Um, I don't know. It's the court pickles. I'm sorry. Uh, and that's another thing. I think that people are not really into this case is because the audio is absolutely horrible. Oh, nice, Paula. That's so good, Ollie. You're so sweet. Oh, that's awesome. Then is so. Are you sharing what kind of pizza, Paula? We need to know what kind of pizza is this. We need all the information possible. Um, I have never heard Godfathers. We have it Goodfellas here in the UK. We have Goodfellas. Oh, pepperoni, best kind of pizza, definitely. I send some. Guys, oh, actually, oh no, I think we ate the rest of the pizza the other day. Ah, man, I was thinking, oh, there's some pizza. No, there's not. We ate it all. Because was the other day, like, it was I think it was more than the 18-inch that Gartenbot got the other day, and it was so good. I think it was Friday, actually. Yeah, I think it was Friday that he got it. Well, someone is playing with the audio from court. They're like, they look like a DJ going up and down, up and down, up and. I was like, decide yourself, please. Yeah. Oh, it smells so good. I wish Smell-O-Vision was invented right now because it smells so good right now here. Garden Bot is making dinner, and I'm like, oh my nice. I am getting even hungrier with the smell. Garden Bot is very good cook. You know, guys, he is getting very good at cooking, which I'm very proud of it. That is getting very good. Of course, my cooking is also good. Cause the other day I actually made Garden Bot's favorite dish and his favorite dessert. So see, I was a good wife on Sunday. It was because it was Sunday. Yeah, there was because it is not this preferable thing to do, but because I'm doing this and I can't cook as much as I used to, so he's been helping a lot, Paula, and I really appreciate that he does. And I think he's getting there. I think he's kind of liking it. It's just we struggle most is of what to cook every day. Deciding every day on what to cook, it is something that I did not sign up for. And even like when I used to cook myself, not cook myself, but I used to cook, I struggled with what to cook and what to do. Yeah. Yeah, it is. He's a very good man. He's amazing. He is very. I am very lucky. Yes, Izzy. There was I think it was a last hearing before her trial started. Um, yeah. He's a chef, he's a gardener, he's a mod, he is a crafts guy. He's he does everything guy. He's and but garden is the main thing for sure. He does everything. Garden bot does a bit of everything. So like like I do, but I seem like I don't do as much because I'm always here hanging out with you guys, but I also do a lot. I'm running a YouTube channel, I'm working on my job, I try to spend time with my in-laws, with friends, and everything. It is. It is. I am yeah. I am very very lucky to have him. I could not have been luckier to have a garden bot. So, and I speak good about him. That's what I do too. Nah. Oh no, I don't do that much because I wish sometimes I could do more. To be fair, in all fairness. And sometimes I feel bad that I don't do enough for others and for you guys as well. And sometimes the other day, right, on Sunday when I was a hangover, I just watched rubbish TV all day. I watched Dateline, not rubbish, Dateline. Pickles, what have you done to me? I what you've done to me? You have got me hooked to Dateline so bad. It's the only thing I watch, and they had a YouTube channel. I know. I corrected myself. It's not rubbish. I I got hooked, and I think they had the you created a monster. Indeed, I think they had a YouTube channel open that I was able to watch without the VPN. And I was fine. But now I went there today when I got home to while setting up the stream and everything. I like watching and hearing something, so I went there and I cannot watch anymore. But I have a VPN, so I'm gonna be able to watch. But I absolutely cannot get away from it. It is so intriguing. Even though the other day I was so annoyed that I think I watched it too much that I got to the point that they started repeating the cases. I think that is Oh no, it's fine. I have a VPN. It's fine. I'll be okay. I'll just turn it on. It's okay. I don't pay for it. I pay for the whole year, so it's absolutely fine. Pickles, I appreciate it. Thank you very much for that. Give me 1 second. Yeah, we are live and it's playing. For a second, I was like, "Are we even live?" We are, and it is playing. So I'll just turn on that and I'll watch it. But I think I've watched so much on Sunday that I literally repeated the whole the whole thing. But I did notice that there is not new for me. It's new because I haven't watched much Dateline, but there is a lot. Oh, I am in love. I fell in love with Dateline. It's absolutely gorgeous. Give me 1 second. Sorry, just work 1 second. Because there's cookies on offer tomorrow at work, and I want to make sure that the guy that is doing my prep for tomorrow makes enough cookies so I could have a good display for Oh, that is nice. I only watch well, I can because I'm gonna have to turn on the thingy, the VPN. I can watch the website as well. I know, case one, it's not good cookies. Do you know how many cookies I am gonna have to pack tomorrow? Do an estimation, guys, of how many cookies you think I'm gonna pack tomorrow. Considering it's like a supermarket cookies bakery thing that I work on. It is gonna be wild. I don't like when cookies go on off because we're gonna have to do. I'm gonna be spending a good like maybe 2 hours packing cookies. Oh, I wish I could eat, but I think I would be sick of it because it's. Oh no, it's not not that many. Well, I don't. Well, that's not. Okay, I shouldn't exaggerate it. It's not that many. So anyone else play the cookie game? uh, Not that many. It's gonna be it's man, like, if he was 50 dozen cookies, I think I'll be there forever. I would. Well, Susie, you were close, definitely. I think this is close. It's gonna be about 200 cookies, 200 packs of cookies. Obviously, each pack has. It depends on which pack you're buying. Each pack is had that either has 4 or 5. So, oh, okay, all right. I'll see you very soon. I know it is. We are putting Girl Scouts out of business. That is for sure. But it is good because it's going to be quite a few hours. Like I take about 2 hours to do them anyway. So that is going to be 2 hours of my shift that is going to be gone. So and normally that's going to be my last 2 hours anyway to do. Oh, okay. All right. No worries. I'll see you very soon, Paula. So it's gonna be about 200 packs of cookies, which during the math, oh, I don't want to do the math. Yeah, it is gonna be a lot of cookies, but those cookies sell a lot. They sell pretty quick. The people are in this area. They are wild for those cookies. But I found them a bit too chocolatey. Yeah, 200 packs of cookies. Yes, I know. It's 200 packs. It is a lot of cookies. And guess who has to do it? Me! Me, myself, and I. And I don't get help. But I only take about 2 hours because then the good thing is I can have music. So, my own music. So, I'm just gonna be packing cookies. So, if after tomorrow I cannot see any more cookies, please don't blame me because that's gonna be me after tomorrow. But it's gonna be okay because then I'm off for yeah. Wow, good maths, Susie. Thank you very much. Yeah, that is about that. So it is gonna be baking a lot of cookies in the morning and then having to pack all of them cookies. So yeah, it's gonna be crazy. It's gonna be a cookie station for sure. But they are gonna go on promotion and they sell quite very well. I am sure that at least they're not gonna yeah. It's the thing is they are nice and they are sell and they last a while. They last, I think they have a week's shelf life. So they're gonna be there for a while. So we normally I like to do that a big batch, and then I'm okay for until at least Monday. I'm gonna be okay on cookies, and then on Monday I can do the same thing for the week. So it's not. Obviously, sometimes we have to top it up, which is crazy, especially on the weekends. If we do the cookies right on a like Wednesday, Thursday, we're gonna be fine by the weekend. But I almost guarantee you that Monday, Tuesday, we're gonna have to do this again, because on weekends it's they fly. I think they gain wings and they literally fly out of the shelf. It's just absolutely crazy. So yeah, so they're still not back. It's absolutely crazy. I think definitely something is going on. I think definitely a deal is in the works. Oh, here we go. Me
So
talking.
you're just reviewing it to make sure it's, or is it still recording it? Oh, I see. All right, I'm just getting concerned. All right. We'll just, hopefully it won't be too much longer. Okay, that's okay. Very good.
So I don't think it's a deal. I think they are recording something to. Oh, hello, cameraman. Hi. I don't think it's a deal. Sorry. We had a bit of a close up of the cameraman. Oh, we are doing a 360. Sorry. Hello. We can see him. We can see people in court. Hello. Everybody wave. Wave to the cameraman. I'm sorry. What are you doing? It's cleaning. Oh my days. I'm so I'm literally crying. I'm sorry, this is too funny. So he's cleaning the camera. Because you make it. Oh my god, oh my days, this is too funny. Look his face. I'm sorry, but this is hilarious. This is too funny. This is absolutely too funny. I'm sorry. Yeah, I think he hurt you, Pickles. He wants his nose back. Oh, that was way too close for comfort there. Um, like, yes, give us the seal again. That was, oh, he knows. Oh, absolutely, he knows. That was absolutely hilarious. Garden Bot, you need to go check the stream because we had a very up close. We had a very close up to the cameraman. It was hilarious.
Nice.
It was if and food. Oh, you did. You came back, and food is here. Look at this gorgeous food. Trying not to turn it too much, but that is food ready. So now I'm just waiting for Court to come back so I can eat my food. Please, food. Please, Court, come back. I want to. I know, way too close encounter. That was a little bit uncomfortable, sir. Please do not do that again. We would like to. Yeah. I know it looks very yummy. I cannot wait. It looks so yummy. E-made. What's it this called, Garden Bot? Because we get like we used to get the HelloFresh thing, and we got some recipes. Oh, this I need to get you the recipe. Would you?
Maybe 5 minutes.
Okay, in 5 minutes, I will take a picture. I'll post on the Facebook group. Yeah, I'll post the recipe on the Facebook group, and I'll send it to you, Pickles, as well on Discord as well. So I'll definitely share that. I liked HelloFresh as well until I heard some things that I did not like as much. So I am thinking of trying another company. That there is a ton of companies like that of that because was so much easier. I know. It was like so we compiled yeah, it is, isn't it? Case one, it's like got a little bit expensive, so we're gonna try another company that we have here in the UK. It's a Gusto or something like that. So we're gonna try that one because they say it's cheaper than HelloFresh. So we're gonna do that. Try it again because we compiled the HelloFresh recipes, right? And now we just buy the ingredients that we need and pricing shade. Oh, that is so true. Good Pickles. Oh, true that, girl. So absolutely, we're gonna try to do that and compile the recipes that we I know it was so hard, and I still get emails. Even though I told them I don't want get emails, I don't want to. I know. I was like I completely was like they keep sending me emails and coupons. I was just like no, I just don't want to do it anymore. It is very convenient. I really like it, but it's just got too much in the end. But I've compiled a good book of recipes that me and Garden Bot like, and now we just do them. And I think we got stuck on this one that it's very easy to do and it's very quick. I mean, took Garden Bot what 20 minutes to do, which was absolutely. Oh, I know. Even though you say you don't want to get more emails, they can still send you emails, which is so frustrating. I hate spam emails. I get, right? This not related to food now. Yeah, it's for sure case one because we get blocked in terms of ideas or what to do for food. It is just so ridiculous having to cook every single day. We should be able just to cook once a week, and be okay for the week. But I don't like batch cook. I like batch cooking, but there are certain things that I don't like reheated. I don't like pasta reheated. I don't like rice reheated. I'm very picky. So it would be very hard to batch cook stuff for me because of my weirdness. But it's just I struggle with ideas as well, in terms of what to cook and what to make every single day. It's just so hard. But what I was gonna say something else and I forgot. Oh, I get so much spam emails. So last year, Garden Bot had to get, I think it was a shed type thing for a job that he had to do, and every single day I get an email from the company that we bought the shed from, even though I've already told them that I want to unsubscribe from the emails, that I don't need them anymore, but no, they just keep sending emails. So it's like, I am tired of getting emails for literally junk, because I'm not gonna 1 second. Huh? 1 second. Work again. Sorry. So I was just I know I only open my email if I see the title of the person that is something that I'm expecting. If I know it's spam, I absolutely do not open, and it's just crazy. And I unsubscribe on the other day, a couple weeks back. I spent about a good 10 minutes unsubscribing from a ton of spam. But yet again, I still get, I with no exaggeration, 15 to 20 emails a day of just spam. And now, especially doing like this YouTube side of things, I even get more spam emails of other stuff. So, and it's just, I just don't get it. I hate emails. It's it is a great way to communicate with people for free and everything, which is awesome, but spam emails should be abolished. And then don't get me started on how Apple now organizes their emails. So I it's just crazy. I know you can turn it off, but I don't have the time or the patience to do it, so I don't do it. Is so yeah. Yeah. So I'm hoping that Court will be back soon, because I would like to eat my meal, um, my meal warm or hot. Um, Come on, Court. Would you guys mind if I would eat, please? I'm sorry. Um, yeah, just because I would like to eat my food warm, you know, because again, I don't like reheat rices, rice. So I'm just gonna eat my food. I am gonna be here. I'm gonna be in chat. But it's just gonna eat. Okay. Yeah. All right. Okay. I will be back very soon. I will be back soon, Pickles.
Are we ready to proceed?
Yes.
Very good. Let's bring the jury out, please. Yes.
All rise, jury entering. Please be seated.
Good afternoon, ladies and gentlemen. We are ready to continue with the continuation of the cross-examination of this witness. Counsel, you may proceed.
Thank you very much, Your Honor, and thank you guys for being patient. Detective, let me just give a little introduction of what we're going to be doing here. We're going to play some of the video that was captured on your camera that evening, I believe, right?
Yes, sir.
And it starts at 10:17:09 p.m. and it's dated the 4th of April, and the location is 41/43 Summer Street. That's what we got going, and you're aware of what we're about to do.
Yes, sir.
Okay. Let me give a little introduction here. It's going to take about 25 minutes total recording. Some of it is dead time. You'll see some transport and detective. Some of it will be a muted body cam. Can you tell the jury why that happens? I mean, we're not trying to sneak around here. Just want to make sure.
Sure. Sometimes we'll mute a body cam when we're by our personal spaces. People have family photos. There's other case information that necessarily we don't want getting out.
But can you tell us generally what we're about to see? We're going to see a bit of the transport and the initial processing. Can you explain to the jury where we're going to go, what we're going to be in, etc.?
Sure. So as we kind of previously had talked about, this is going to show my initial response, showing up on the scene, and the actual transport of Jason back to the police station and then transporting him up on the elevator to get back upstairs.
Okay. And can we assure the jury that they're going to be able to see some questioning, but they'll be able to see the condition that Jason was in on that evening when the questioning began?
You'll be able to see Jason before he was interviewed, yes.
Thank you. We could start that up. I'm not going to say a word during this. Afterwards, I may have some questions.
Okay, thank you, sir.
Step down.
Yes, sir.
Just so the record is clear, this is a full exhibit, correct?
That is correct.
Defendant, thank you. What is the height of the Lawrence Grove Council?
And just know you're also being the other way. Okay. So I'm just getting here. I don't know what's going on. So just so you know, you're just being detained at this point. Okay. That's something like that. So, is he just detained? Sorry, I can't hear. Oh, no worries. That's what we're getting paid to do. So we're gonna just head back to the station. We'll kind of talk there just because it's kind of not the best environment with people yelling and stuff like that. And we'll kind of talk over there. Get out of the weather too, stay dry. 6 airports. Being transported one detail is being ordered and to be approved tunnel. Perfect. once you go upstairs, where we'll dry her. Sorry. No, you're fine. Any injuries, anything you need EMS to check out for? Anything that changes, you want to do or anything? What do you do for work? Okay. Yeah, it's tough. It's tough before I was a cop. I did construction and I need some guys that are not plowing but shoulder with the plow trucks. That's my work. Okay. So we'll head upstairs. Just have a civil water. Yeah, I'll get you a couple orders. I'm going to go upstairs. Water or coffee? That's where. Yeah, no problem. Plan all day until you want any food, right? Okay, yeah, I can make sure that happens. Yeah, Mr. Dave, we'll wait for the other item on that. Just let me know when you're good. We'll have upstairs and there's chairs on the table. Okay. I just thought if you just want you to know about this. Okay. I'm not sure you want the elevator, but as soon as we go upstairs, we'll be chairs and tables. I'm not sure to sit down. And if you feel like you want us to check it out, something like that, more than welcome to ask me, and I will make sure you have some of those. We'll get you seated. So that's just your body, you're going to stress. Do you have any medical conditions or anything? No. Are you good walking for a second? Just get through the chair. I'll help you up on the front. So this room is also video audio filtered. I have to see you for 1 second. I'll give you a couple of water. I want to make sure it's all I think I'm down here. Do you mind actually, you go downstairs, there's a kitchen. Just go right downstairs. There's a kitchen and then have that top should be cups, like bigger cups. You get that, just put somewhere. This one. Still doing okay? So, that's it. Okay, you find it. I'll talk to the artist part about it. So, if you give me food, find some food. This is food. Yeah, that's it. Cats. So we're just going to get you some food, and then the other guys need some water. I know it's especially plowing all day. Long day. Slim didn't work? That works. You don't have any food allergies or anything like that? Do you do like commercial, residential kind of combination? Okay. How long have you done that? Do you work for them for outside snow, or is it just or so like your day to day? What do you do for like a day? Oh, nice. Where do you do that? Okay. Yep. Right on 108 there. Yeah. How long have you been doing do you do students only, is it? Or you got some? How long have you been doing that? Good. Right. Couple of years, months, yeah. Yeah. All that speed of sound, or? Yeah. Okay. Again, if you feel like you need EMS or you just want water, so I'm going to stand up, take the cross off. So feel good about making that pass out. Why just sit back down? Just because I want you to fall. Yeah, no, it's traumatic, I'm sure. So you can sit, see, and if you want to take your footy up, I'll make you calm. Yep. Looks like you got some blood on your hand and others. Okay. If anything changes, you feel like you're getting too lightheaded, let me know. Yep, so I'm just going to go over some paperwork and stuff. Yeah, I know, I hear you. I just want to make sure that you're aware of your rights and everything else too. You know, you sound pretty straight up honest. It sounds like this was kind of like something happened that wasn't planned, is what it seems like. So I just want to get, you know, there's two sides to the story. So I just want to hear what your version of events and we'll kind of go from there. But I want to make sure that you're fully aware of what's going on before you're talking. So make sure you get a second to compose yourself for some words. Especially if you have one.
Italian when I first name. Right? It's just Jason. Jason and Jake. Yeah, I mean, you want to have to make sure it's like I'm just going to check on you. You're good to just hang out here. You hear anything like that in terms of yours, I'd like to just shout. Like I said, help yourself to the deep jerky steak and water. Kind of all the time. But you won't lay down on the floor. It's fine. You feel like you're going to pass out? Do you want to eat this?
You know. Okay. No, I just want to just talk to this guy while he's still going and talk to us. Right. I'm going to take mine off, yeah. Do you have the cameras up? Yeah, if you want to try and get that up too, I'll just leave. I can't open that key anymore anyway. If the room's video recorded, I can stop my body camera. I'll just record on my phone too, or should I? Do you have that mount? I think mine's on my desk for the other one. Yeah, just put it on the table. Do that. Alright. Why don't you go do Flather's desks, and I'll show you as far as getting the computers set up so you can watch. Yeah. I don't. So then, okay. Yeah. Yeah, if you want to share on. What's the spelling of your first name? J. Davis. And Jason, how do you spell your last name? L-E-V-E-S. I'll pronounce it back. Which one? And a given one. And
right now. Okay, we started that video at 4143 Summer Street at around 10:17 p.m. and it ends about a half hour later, approximately. Okay?
Okay.
And that's just the beginning of your contact with Jason on April 4th, 2024, right?
Yes, sir.
And that's what he looked at like at the very beginning of your contact.
Yes, sir.
And how many hours went by before you broke off with Jason?
When I last had contact with him or stopped because we took a number of breaks throughout.
Yeah, when was the end of the interrogation?
The whole body cam footage, I believe, is about 3 hours and 40-something minutes.
Okay, so it went on more than 3 hours from the time it cut off there.
From my initial response time before the camera started rolling for today, all the way till the end of my contact with Jason, yes.
Can we safely assume that he wasn't given like an hour to sleep or anything?
It wasn't a full hour, no.
In fact, basically you would leave the room at times and he would just lay down on the table.
Correct. He had also indicated that he would like to speak with me, so that was part of the other discussion that was going on as well.
Oh yeah, I mean, you guys went through an entire, give and take for quite a long time.
I'm not sure what you mean by that, sir.
Well, I mean, after we cut off on that video, you kind of basically started by building that rapport with him.
We had a conversation and then we started going into some of the details after reading him his Miranda rights.
Yeah, after you gave him his Miranda rights, right?
Correct.
Yeah. And before you gave him his Miranda rights, you kind of did your introductions with him.
Yes.
And you made clear to him that you just wanted to hear his side of the story.
Something to that effect, yes.
Yeah, to the effect of, you knew that it went pretty quick that night and you just wanted his side of the story.
Correct.
And then you went over the Miranda rights with him. And then he basically said, the floor is yours. Tell me what the heck happened. Right?
Yes, I left it very open-ended to start so that way he could tell me what had gone on that night.
What he told you that went on that night was that he was plowing, and plowing in front of his home and the home of the, actually not even plowing in front of the home of the alleged victim.
So he said that he had done a couple passes, so he hadn't really started going too extensive with the plowing, but yes.
He never told you that he was plowing any snow onto the alleged victim's driveway or anything?
He mentioned doing, I believe, if I'm correct, about 2 passes one way and then 1 pass the other. I'm not sure if he went into detail as far as where the snow ended up. If there's a certain line that you want me to reference, I can certainly look at that.
Yeah, but I mean, you actually looked at independent videos and you came to your own conclusion.
At one point later in the interview, I was able to watch some independent video, yes.
Right. And he only plowed up to that utility pole.
Correct.
Right. And that utility pole is on his side, his property.
I'm honestly not sure.
I'm not sure. But it certainly isn't in the driveway of Mr. Violette.
The telephone pole won't be in a driveway, correct?
All right, so he was not plowing snow into the driveway of Mr. Violette, right?
I don't know that.
Well, you do know that. You looked at the videos, you had an opportunity to speak with him, I mean, just photographs, I mean, the whole thing.
Yes, I've watched the video. I can't, personally, I'd have to rewatch it, the video to see if the snow ended up going into the driveway or not.
You recall no such thing happening?
From the vantage point of the camera, I couldn't tell you if the snow ended up in the driveway.
And the jury has access to the videos as well.
Okay.
All right, but you wanted to know what the contact was with this guy and what happened that night. And he told you that he had just gotten home from picking up his daughter,
Correct.
and that he was a plow guy. He was plowing, and he had a black truck, and he was doing cleanups all day.
Yes.
And he says he's starting to move snow, and all of a sudden, something's going on. He's going outside and he's locking up his hubs, right?
Yes.
Can you tell the jury how he explained that to you, what that was all about?
Yes. So he basically said he has to manually lock the hub, so he would have to get out of his vehicle to basically activate the four-wheel drive in his vehicle.
Right, it was mechanical, it wasn't electronic, it was something he had to actually do manually.
Correct.
He explained that to you.
Yes.
And if you look at the video that the jury has had access to, that would be him bending over near the front of his truck.
That would be consistent with what he's explaining, yes.
And then he describes what happened. And he says, all of a sudden, he came from his driveway, which is 43 Summer Street. Now, this would be meaning how Violette.
That's my understanding, yes.
And he describes him as having no shirt on, he put his shirt on. He was yelling at me that he's going to fucking kill me. Fucking kill my family if I put snow in front of his driveway.
Yes.
That's what he said. Now, this comes out of nowhere, right? He tells you this is like, comes out of nowhere.
Essentially, yes.
And he says he looked at him, and then Kyle gets in his face, and Jason's saying he can't believe what's going on, right?
Is there a specific line that you're asking
I'll
for?
give it to you. Line 18, page 18.
1818. Thank you, sir.
Yeah, it's okay. Basically says I just kind of look at him. He got in my face even further that I didn't believe him that he's going to fucking kill me and my family.
Yes.
And he says, I don't even know this guy, right?
Correct.
But he goes on to explain something else. What else does he explain?
Is there a specific line?
Can you approach?
So another approach. Sorry, I'm trying to send this email to Zizi with the picture of the food. So that video was a point nothing burger, in my opinion. Absolutely nothing came from it, in my opinion. I did not see the point of watching that video because that was what happened before the interrogation started, and was him basically asking about the food and everything else. So, excuse me, I did not see the point of watching those 25 minutes because literally nothing happened. The guy asked if he wanted to drink, if he wanted food, and they were talking, I think, some about chicken or something, but absolutely nothing happened during those 25 minutes. So that was half an hour waste of time, in my opinion. That's absolutely no point. I don't think, because what we're trying to prove, because they said, oh, they did not offer him any drink or any food or anything, but they did. It's recorded in a body camera that they did. So what are you complaining at? So I don't understand where this defense is going with this cross examination. I don't think it's going nowhere. It's just crazy, but he likes definitely to swear because half of that counter of the f bombs, it is just the defense attorney, not the prosecutor. The prosecutor also says it, but I don't think as much as the the defense attorney. But it's just wild. Also on our new trial, they haven't started because they were supposed to start about half an hour ago, but they haven't. I think they might only actually start tomorrow with the openings because they might still be finalizing the jury panel. I'm trying to see if there is any news on it or anything coming out on it. They did about 3 hours ago. The defense moved to dismiss the red rum charge in the Nicole Rice trial, so they probably dealing with that because the news article says that the defense attorney filed at an 11-hour motion on Tuesday to dismiss the case. In their filing, the defense accused the state of committing what's known as a Brady violation by failing to disclose evidence that could implicate an alternate suspect in the Kynaston unaliving. So, and they also argued that the state did not disclose impeachment evidence against this case. And the case agent, Detective Carmen Asham, the defense also argues a previous interview with Evan Hall, who they consider an alternate suspect, defeats any probable cause against Rice. So, I think they might be holding a hearing on this matter before the jury be starting. So the new trial might not even begin because yeah. It might be a Brady violation. I don't know. This is another state that you can see the court docket, but you can't see any documents. So, but this happened about 3 hours ago. So I'm keeping my eye out for that. If not, well, we'll find something else. I'm sure we'll find something else. So far, I'm still. This hasn't proved to me anything. I am still in the same place of hung jury for this case. I don't think this is gonna be anywhere. And I think if the state decides to prosecute, I think they might try on in a less. Oh no! Are you okay, Pickles? My friend, are you all right? Well, I hope you're okay. Please be careful. We need you. Yeah, it is. I think you're fine. I think you. That would be that. Like, yeah, I bang my head, my legs, my any part, so hard, easy. But you guys, you would be very happy. I haven't burned myself in 3 weeks, so yay! Oh, Garden Bot, look at the chat. Zizi's comment. So, yeah, Zizi, can I pass your email to Gardenbot and you guys can talk? Would that be okay? So, yeah, yeah, I haven't, yep, okay, awesome, thank you, I will. Let me grab that. Yeah, oh. 1 second. But yeah, so it's been 3 weeks, guys, that I haven't injured myself. That is amazing. I am so proud of me. And because, like, I found a way of actually now taking the trays out of the oven. Yeah, I would. I know there is a lot of ways to do hoodies, but then I want to make sure I want to get the best quality ever. Obviously, I want to get the best quality. That is the problem. There is so many companies to do them, but the quality and everything is not always the best. And I want to make sure whichever company we use is a good quality, and that I am satisfied and you guys are satisfied as well. So yeah, I just want to make sure it is the good quality and not just, you wash it and everything comes out and that's not what I want. So I like to investigate companies and garden bot as well, and because it's something that we want to make sure. Yeah. Yeah, that's the thing. It's the thing is, I want to make sure that they are good quality, and if we do only a few, because I'm not gonna make them a lot of them, it's just a start point to see how it goes. um yeah, to see how it goes, but it's just yeah, to see the quality. And because even it is like a garden bot's dream that he was saying one day that he would love to do that, like t-shirt printing anything from home. If we ever get to that point, that would be awesome because we could just do it in the house. But obviously for now it's going to be contracted out. Yeah. Oh, okay. See, oh look, um garden bot. So, oh, that is awesome. Um, so yeah. Now we are on another sidebar. Um, oh no, are you a cow? Oh, sorry, Paula. I'm so sorry. Uh, oh, that would be great. Just yeah, a garden bot. Reach out to Zizzy and definitely, um, we can work together. Definitely. Oh, no, Paula, what kind of bread were you trying to make? Was it sourdough or no? Wait, sourdough. You have to leave the dough breathe and everything. Sorry, you have to leave the sourdough breathe. Hang on.
Okay, the objection is sustained. May I ask the next question?
Thank you.
What he explained to you was that this individual came at him across the driveway, correct?
Yes.
And he came at him unannounced, and it was a mystery to Jason as to why he came at him.
He did mention having reread 18 about that he did move snow into the front part of his driveway of his neighbor to where his neighbor's grass was, and then he backed up. But as far as the reason why he was coming out at that time, I'm not sure as far as what Jason thought.
But the impression and the clear communication he had with Jason was that he was surprised that such an activity took place.
I believe so, yes.
And when he came out, it was almost immediate that he was threatening Jason, he was threatening Jason's family, and in fact, Jason made it clear to you that his daughter was in the truck with him.
Yes, he indicated that his daughter was in the truck and that the other gentleman had come out and was making threats towards him.
Now, during direct, the prosecutor said that, and you somehow stated that it was a conditional threat.
Yes.
Well, it was a threat.
Yes.
Okay. And it was clear that the individual that was the aggressor would have been Kyle Violette, right?
He's the one that's coming out and making the conditional threat, yes.
He's the one coming out and not only saying things out of his mouth, but literally sticking his nose into Jason's cheek, right?
He got close. The video quality's not good enough to say that his nose touched his cheek from what I saw, but he definitely got close to him, yes.
Well, the jury's going to be able to run those videos over and over.
Yes.
In the deliberation room, and they were shown to the jury. And at one point, we counted the number of contacts that Kyle would have had
Okay.
with Jason.
So the video that I saw was the one that was taken from, I believe it was possibly the neighbor's apartment coming from that angle across the driveway. That was the video that I watched.
So you weren't able to ascertain what was going on?
I could see that he gets up there, but as far as cheek touching, you can't tell from that video, no.
You could tell that Jason didn't make one step toward Violette, though, correct?
At which point in time?
At the
Sorry.
initial point.
At the initial point, it looked like he had just stood there, yes.
Yeah, he just stood there, and he stood there, and if Jason kind of described it as though he was like paralyzed or just standing still, that would be what you saw too.
That's what he said in his statement, yes.
Yeah, and that's what was on the video.
Yes.
And also what he said in the statement was that he didn't make a move toward Violette, but Violette made the move toward him.
For the initial interaction, yes.
Yeah, for the initial confrontation.
Yes.
So it's clear, I just want to make this clear, because we're going to be moving down the road here a bit, that the initial aggressor would have been Violette, right?
The individual that came out of his house and started making threat was Kyle Violette, yes.
Now, you'll agree with me, things can go fast in these situations. Right? I mean, it can go like a blur.
It can go fast, yes.
And we're not talking about a situation where somebody had a lot of time to roll over in their mind what to do and how to do it, right?
These are quick decisions, yes.
And we also know the background of Jason Levesque that day was one of an individual that was up over 40 hours, right?
I'm not sure what time exactly he got up, but he said that he had been plowing for over 24 hours.
I told you that he had gotten up, I think at 8 o'clock the preceding day.
Do you have the page and I can reference?
It's all painted. He got up, he didn't have any sleep the preceding day from the time he got up.
Okay.
And we saw the video just moments ago of him needing to lay down.
Yes, he has to lay down.
And he also told you that he was tired because of the plowing and the time that he was up so long.
Yes.
And, he was offered food. Did he ever eat anything?
Yes, he ended up eating some chocolate.
A little bit of chocolate?
Yes.
Went like 2 Hershey's Kisses or something?
I don't remember exactly what he ate, sir.
And that would have been later on during the interrogation.
I'm not sure if he ate them during the interview or the interrogation part of it.
Okay. Now, he also attributed to Violette the fact that Violette had threatened him on more than one occasion that night, right?
In the initial, I believe he said that he had threatened him once, but then he may have repeated the same threat, possibly more than once throughout the night, yes.
Or other things, because he was saying he was screaming at him, yelling at him.
Is there a specific line that you're referencing?
He didn't have any specific recollection that evening, right?
I'm sorry, I don't understand the
Let me ask
question.
you something. Did you ever ask him, as you were moving through the interview, other than the initial threat, were there other threats that he made?
During the initial response, it was more open-ended. I let him just talk, and then there were some follow-up questions. As far as if there was a distinct question, I'm not sure.
But he was very concerned about another individual that was with him that evening, correct?
He was concerned about his daughter, yes.
Yeah, he was concerned about his 19-year-old daughter that was seated in the passenger seat.
Yes.
And in fact, he was concerned that Violette had threatened her as well, right?
The initial threat had threatened both him and his family, so that would include his daughter, yes.
Right. Now, he stated that, in fact, that his daughter was, in essence, petrified, right? Scared.
Is there a specific line that you're
I
referencing?
think it's 41. I think it's after you had said, and I don't want to get into. Oh. Sorry.
Sorry, I was just checking something. Why are we going sidebar again? Oh, this is This trial is trying to test my patience. That was a quick sidebar.
Rephrase question, please. Sure. Did he communicate to you that his daughter was afraid that night?
Yes.
Did he communicate to you that his daughter had gotten out of the truck briefly and then got right back in the truck during this altercation?
Is there a specific spot for that you're referencing? I don't recall that.
Okay, let me ask you this. When Violette is coming toward Jason, all right, walking towards him, and starts getting nose to nose, is she still in the cab?
He expressed to me, I believe, that she had stayed in the vehicle seatbelted the whole time. But if there's a time that I may be forgetting, if there's a specific spot you want to reference, then I can take a look.
No, that's fine. That's exactly the answer. And he also says that at this point in time, he felt overwhelmed, right?
I believe so, yes.
And that would have been when Violette literally was nose to nose with him.
Correct.
Now, did Jason claim to you that he had a perfect memory of what went on?
I don't believe he ever said that, no.
Hey, let me ask you another general question. Did you ever think that maybe after you got a good night's sleep, you might want to actually sit down and have another interview with him?
That would be a conversation down the road, yes.
Did you ever attempt to reconnect with Jason, let's say the next day?
So I'm not sure. I'm trying to remember if that was the next day arraignment. Typically after they're arraigned, they would need attorney involved due to constitutional protections. But I didn't speak to him again after that, no.
No, I mean, did you reach out to anybody and say, let's get back together now that Jason's, recovered, gotten some sleep, and we'll go over his statement so he can review it and see if it's accurate. Did you ever do anything like that?
So I never spoke to him again after that initial interview.
Now, how many different angles of that video did you observe?
To my knowledge, I just remember watching the video from, at least in its entirety, the video from the neighbors. Other detectives might have had the cameras open at some point watching them, but that's the main one that I saw that night.
Okay, so that's the only angle and the only distance that you were able to ascertain contact, right?
That's the only video I remember watching that night before I interviewed him or interrogated him on that part.
Now, Jason tried to get it point by point with you. You'd agree with me that in such a situation, shortly after a traumatic event like that, he may actually have been inaccurate in some of the things he was telling you.
You're asking if he could be inaccurate when he's telling? Yes, he could certainly be inaccurate on details.
Yeah. I mean, when you take in the factors of the recency of the event, the shooting itself, the fact that he hadn't slept for about 40 hours, all these things should be taken into consideration.
Certainly, you got to take into effect people's amount of sleep. You got to take into effect the time, spatial distance between the event and when you're talking to somebody. But again, it was Jason that indicated that he wanted to tell me what had happened that night.
No, I get it. He said that when he was standing up, that's when he saw Kyle coming.
I believe so, yes.
Yeah, and I think on page 44, you said, so you stood up because you hear him yelling, a natural reaction.
Yes.
And Jason agrees.
Yes.
And then you said, and when you were overwhelmed, kind of describe what your body was doing, how you were thinking, that kind of stuff. And he gave you an answer.
Yes.
And what was the answer?
He said, I kind of just froze, like I didn't know what he was going to do. I didn't know if he was going to come up to me. I didn't know what was going to happen.
So at that point in time, he didn't yell back at him or do anything, right? Right?
I don't believe so.
No, he asked. So you never said anything back to him at this point?
Correct. And he said, no, because I didn't want to. I didn't want to escalate the situation or, irritate him or whatever you want to use for a word, but make it any worse.
Right. And you were actually asking this question to see what was going through his mind at the time of that contact, right?
Correct.
And at the time of that contact, he says, well, you say, okay, and what does he say?
He says, again, my daughter's in the car. I don't know who this guy is. I still don't know who he is. I don't know what he's capable of. I just didn't want to have any type of problem with him.
And you agree, and then he answers, and he says what?
And obviously, he seemed like he was ready to fight.
So that was the impression that you asked him to convey to you with regard to the initial contact, right?
I was asking, yes, what he was thinking, what his emotions, what his body felt like during the initial response, yes.
Right. And the initial response, in essence, was he was frozen, he was shocked, and he thought this guy was ready to fight.
That's what he expressed, yes.
And he was concerned about his daughter.
Yes, he also expressed that as well, yes.
He also goes on to indicate to you that at one point he walks away and then turns around. I'll give you
Who are you referencing in that?
Page 46. And from the top down.
So I ask, is when he turned around, and how far away is that at that point? I'm not familiar with where and Mr. Levesque says, yeah, no problem, maybe 15 feet. So then I ask, okay, and so he turns around, and how's his body? What's he saying, that kind of stuff.
Okay, so you'd agree with me, if you look at the video, this beginning of the contact to the end of the contact with the last shot fired is about probably a total of 11 seconds, something like that.
It's fairly quick, yes.
And he says, what does he say when you say, what's he saying? That kind of stuff? What's his answer?
Sorry.
Line time.
Yes. Mr. Levesque says he's still very agitated. He's got his fists. He's very animated in how he's yelling. And just, he's going to fucking kill me and my family for moving snow, I guess.
Now, this whole conditional threat, he didn't say that when he turned around and said that it was a conditional threat. He said, he's going to fucking kill me and my family for moving snow, I guess. Right? So Kyle didn't say for moving snow, I guess, right?
He's explaining what happened. I don't know if he's actually saying verbatim like he did previously as far as what the threat was. I think he's paraphrasing more, but certainly he does say, and I can read it again, he's still very agitated. He's got his fists. He's very animated in how he's yelling, and just he's going to fucking kill me and my family for moving snow, I guess.
Now, the prosecutor asked you whether you heard anything on the video, any yelling or anything like that, right?
I believe so, yes.
I mean, did you guys do any kind of a scientific, test out there to determine whether or not you could even hear any yelling from that spot?
So, no. Again, my involvement for this was the arrest and assisting with some of the follow-up. That was my involvement with this case.
Okay. Do you know if any kind of a decibel reading was taken at or around 41 Summer Street at the location where yelling was claimed to have taken place? Not from the house, not from individuals running outside, but from that very spot.
Sure, I'm not sure how if someone's yelling, I don't see how that's relevant because people's voices could be higher distances. I'm not, depending on where they are, I don't see the relevance of it, but.
Well, I don't know, I mean, it was asked on the record.
Sure, I didn't ask anything about decibel readings, Your Honor.
Did you hear yelling? Remember that on direct?
So you have, should do your best to answer the question, so we're going relevant, not relevant.
Sure, I don't remember it. I believe he asked about yelling, but I'm not positive, but I don't recall anything about decibels.
I'd say, okay, let's forget the
So
decibels.
yeah, we have a question.
Let's take the decibels and throw that out, okay? You recall being asked about, did you hear any yelling?
Is there a specific page? Okay, yeah, no, I don't recall.
Now, you agree that you said to him, and I'll guide you on this, it's the page that got cut off, I think, without the number. Might be 47. Basically, Jason was focused on Kyle, right? I'll give you
He talks about, there's a female as well.
yeah, he hears a female yelling, and that may very well have been Kyle's girlfriend that was yelling in that video.
Oh, presumably, yes.
Now, let me ask you something, okay? I'm going to go through this checklist with you because I want to make sure that we don't paint Jason in some corner where he's trying to avoid answering questions. Okay? He's the guy that waited in his driveway for the police to show up, right?
After from what I've heard, after asking if his daughter, if he should run, yes, he waited in the driveway.
He asked whether she, I mean, you don't know. There were many other things, we'll get to that, that may have, of course, been discussed in the cab of that truck, but he didn't run, right?
No, he didn't run.
Okay. Not only did he not run, he preserved the firearm and made it safe so that when police showed up, all right, it would be there for them in plain view in the cab of his truck, right?
Yes. This is what he told me.
When the officers arrived, he made sure that they knew he would be coming with them without resistance. In other words, he exited the truck with his hands up, right?
That would be a question for the other officers. I arrived on the scene after he was already in handcuffs.
Well, did you describe him as a cooperative individual when you were on your way to the station?
Yes, he was cooperative with me the entire time, yes.
Right. And this cooperative individual, in fact, did everything you asked him to do. He didn't resist one iota, right?
Not that I recall, no.
No, not at all. You had no reports of that at all, right?
I don't recall him not being cooperative. He was cooperative throughout.
Right. He told you where everything was. He said you could search his truck, right?
Yes.
He said you could seize his video equipment and the videos from his home.
Yes.
He, when given the Miranda rights and the constitutional rights afforded to him, made a decision that he was going to speak with you, right?
Yes.
He was cooperative during the interrogation.
Yes.
I mean, he was basically sitting there as long as you wanted him to be there.
He was willing to answer my questions and talk to me for as long as I had questions up until that point, yes. He never asked to stop or anything like that.
You're the guy that terminated the interview, not him. He didn't say, I've had enough, I want to talk to you.
No, he never made a statement like that. As far as the termination, It was more, he was going downstairs to get fingerprinted and processed, I believe is how the interview kind of concluded.
Now, this is, the backdrop of this is that you've got the guy that the jury saw in the video, but later on, about an hour later, in fact, you start asking him questions again, like, can we go over, or what happened that night, right?
Yes, I would ask the same question a number of times in a number of different ways, yes.
And you wanted to swab his hands?
Yes.
Can you tell the jury what that's all about?
Yeah, so typically we'll do GSR kits. It's a gunshot residue kit. Basically it just shows if you're in the presence of a firearm discharge or the equivalent. One of the questions on there is if you handled fireworks, because there might be some similar kind of chemicals or materials that you might handle that are similar in both.
Now, about an hour in, as you're going through this swabbing process, and this is after what the jury already saw, he
do you have a page reference?
79, 25.
Yes. I believe I was out of the room at that time.
Was there a trash barrel or something offered in case he vomited?
Again, I can look at the transcript and say that, but I was out of the room when that conversation occurred. That was with Detective Flathers.
At that point in time, though, does he express that he's overwhelmed and tired?
So he says, I don't feel so good, just a second. And Flathers asks, do you want a trash barrel or something? And Levesque says, no, I want to lay down too. And then I come back. And then he goes on when I get back in the room saying, just give me a second, I think I'm just overtired and overwhelmed.
Yeah, that's when Flathers says, do you think you want an ambulance?
Yes.
And he responds, I'm overtired and I'm overwhelmed. Right?
Yes.
This is about an hour or so after what the jury just saw.
Get into the room at 11:42 p.m.
About an hour. And he says there's a lot going on. Right?
Yes.
And he says, I'm trying to stay calm and focused, and sometimes I just get, I don't know. And I guess your partner says, like a little rush, and Rebecca says, yeah. Hot, cold, I don't know. And I apologize if I stink. I feel like I just smell awful. Right?
Yes.
And that's because he had been working all day, hadn't had the opportunity to clean up.
Correct.
And then you go through the hand swab, correct?
Yes.
How long of a process is that?
It's relatively quick. They have basically almost like the kid stamps where you're just stamping around different portions of the hands and then filling out a page that kind of asks them a few questions as well. But it's not a long process.
And he was cooperative through that, right?
Yes.
And you're trying to understand exactly what's going on, and he's telling you that there's some gray area with regard to what he's telling you, and that's on page 117, lines 23, 24, 25.
One moment. So he says, right, so I don't know if maybe there's a gray area, and that's what I think happened. And I just don't remember, I don't know.
But he's willing to stick around and continue to answer questions. And this is when you're actually asking him to rethink some of the things he's already said to you, right?
I'm asking, yes, if he basically as a tactic to ask him if, maybe the first story of events, you were just still in shock, so you weren't trying to mislead or lie to us or anything like that.
Right. In fact, you tell him that. He's saying, I'm being completely honest with you. And you say, maybe the first story of events, like maybe you were just still in shock. And he goes, yes, or right, correct?
Yes, as part of an interrogation tactic, you can offer someone an opportunity to save face. If you tell somebody you're lying, sometimes that shuts somebody down and they won't talk to you anymore. So you give them an opportunity, a way out to still be able to communicate, still be able to talk to you without basically giving them no alternative.
Yeah, I mean, that's lovely, but that alternative wasn't offered to him when he had gotten a good night's sleep, right?
He had indicated that he still wanted to talk. So as far as asking if he wanted sleep, I didn't ask him if he wanted to stop to have sleep at that point in time. We were in the middle of the interrogation or beginning the interrogation at that point.
Or if inviting him to take a look at his statement and make any corrections.
Yeah, so he did ask me if he could review his prior statement, and there's a reason why, again, we do these spatial gaps. It's harder to remember all the lies that you're telling if there's a little bit of gap in between. Also, again, asking questions different ways. There's, some benefits of having that space.
Is it a good tactic to interview and interrogate people that are sleep deprived?
Again, Mr. Levesque indicated that he was willing to do the interview. There's no obligation to do so. I read him his Miranda rights. It was his decision to speak with me.
Yeah, I'm glad that's the answer you're giving me, but is it a good tactic to interview people that are sleep deprived? Is that part of the tactics that you guys have?
As far as that, we don't typically go out seeking people that are sleep deprived. It's just the circumstances of events. He had been out plowing that whole night. We don't choose that, that he was out that whole day. That was the hand that was given to us, so that's what we had to work with.
But that's a hand that you can reshuffle, right? That's a hand where you can say, hey, we'll come back at 8 o'clock in the morning and talk. We'll come back at 10 o'clock in the morning and talk.
Again, no one was forcing Mr. Levesque to talk to us.
Nobody's forcing them. But would you take a neutral witness and say, hey, I know you haven't slept 40 hours, but I want you to give me a statement? Or would you say, would you like to have some sleep? And then give me an accurate statement.
Again, if he's willing to talk to us that night, we're trying to figure out what had happened that night. We're going to talk to him. If at any point in time he indicated to me that he would rather speak to me the next day, so that would be something that we could revisit.
Well, you saw the guy nodding off right in front of you, didn't you?
So even during the daytime, during arrests, we do have people nodding off. We have people, in booking that could be lying down. It's not uncommon for people to lie down on benches just during day shift, during the middle of the day. So that's not super uncommon.
Super uncommon. But the jury got to see what he looked like. He's bedraggled, isn't he?
They certainly got to see what he looked like. What was the question? Sorry, I missed the last part.
Yeah. I know that you may say it's not super uncommon, but are you saying that it's a good tactic to interview witnesses to get an accurate story when they have not had slept for 40 hours? Is that a good environment to get an accurate statement? Honestly.
It's still fresh in his memory. I think there's still some benefit of talking to him then. Certainly, again, revisiting once you get a full night's sleep, you might be able to get some additional information. Right. But again, at that point, he would have been arraigned.
and sidebar 500 and million and one. I absolutely don't see where this defense attorney is gonna go, because nowhere. I think that's his destination. He keeps asking the same questions, and I agree with him.
We're going to do a 5-minute break. After this, I'm hoping we can wrap up this today, but we'll take some time. All rise. All right.
Yes, sir. Yes, Ron.
We'll be in the gallery. Can you see this? I just want to put on the record real quick before you start. I looked at the cases while we were about this issue involving completeness. And I just want the record to be clear. I'm relying on a couple cases, State versus Botello, which is a 2013 case, 165 New Hampshire 751, and State v. Mitchell, 166 New Hampshire 288, a 2014 case. Both cases involve situations where the state attempted to put in portions of an interview of the defendant, the defense is trying to see other portions of that interview and document completeness, and the court declined that, or rejected that argument, argued as a hearsay, and argued that there wasn't sufficient prejudice or there wasn't sufficient misleading that you had to include those. And I think those are helpful for telling cases to review, especially the Botello. I just wanted that part of the record clear. Now, Counsel, you have things you wanted to discuss? Yeah.
The thing is, right, the defense attorney is more focused on the fact that they did not offer food. They did not give them a buffet of food when he got into the interrogation room. That he wasn't treated like royalty, like when he was in the interrogation room. And for the fact that he was awake for 40 hours. Well, it's not the the victim's fault either. Bouvet. The victim's fault that your client was up for 24 hours. Nobody asked him that, did it? No, it's not the victim's fault that now for the rest of his life he's going to suffer what he's going to suffer because your client decided to stay awake for God knows how many hours. And it's like, but how, first of all, can someone, right? So he says that he was plowing for more than 24 hours. I'm sorry, but how is that possible? I'm sorry, it doesn't probably snow that much, and it is, I'm sorry, stupid to be snowing, to be plowing. I it's it's pointless to be plowing for more than an hour straight. If it carries on snowing that much, just let it snow. If you stuck, then you plow. You're not going to be plowing because it's pointless, because you start on one end plowing. By the time you have to come back, it's already covered in snow. What you're going to do? Just do it the same thing, and then it doesn't make sense of what he says. How do you call it? What time? The buffet? Yeah, exactly. So it was like, and then he said he was plowing for more than 24 hours, and then he was up for 40 hours. I'm sorry, there's no human being that can be up. I know there is the disease that makes people not sleeping, but or they sleep. Oh, the thingy. I can post the invitation here again. Hang on. Here, just press that link and you'll come up on stream. But it's up to you if you have camera or not. Have camera or not on it, and just let me know that you're coming as well. Cause yeah, but it just doesn't make sense. whatever he's trying to say, and then the fact that he keeps focusing on the same thing. But about the food, what about the sleep? It's like your client wanted to talk. He could have said, "I don't want to talk. I'm too tired. I just want to go sleep. I just want to rest," and talk another time. But your client never did, so it's not your fault. Um, Oh no, it's absolutely fine. You don't have to have a camera. It's absolutely fine, Zizi. It's like a phone line. You don't have to have camera. So absolutely fine, my friend. So it's just like he could have said, "Oh, I don't want to talk, and I just want to go to my cell or whatever. I don't want to." Like he could have said that, but it didn't. So he voluntarily carried on work talking. So there you go.
Can you hear me?
Yes, I can hear you. Hello. Hi.
My dear.
Hi, so nice to hear you. Oh, this is awesome.
Yeah, I don't have a regular American accent. I've got one from Chicago, so it's it's kind of unique. They
I
don't
love
all
it.
yeah, well, they don't all sound like this, but I live in the South, so but I wanted to say it's not unusual for folks in the northern part of our country to plow for 24 or 48 hours at a time because the snow now is not always heavy, so they got to do it while they can, right? And it's
Yeah.
side money. So a lot of times it's landscapers that put a plow on the front of their truck and they just plow when it, plow people's driveways, parking lots, stuff like this. But the thing I have a problem with is this same guy that was too tired to be interviewed was carrying a gun and plowing his own driveway and street. So, if it works one way, if he shouldn't have been interviewed, he shouldn't have been driving, he shouldn't have been plowing, he shouldn't have been carrying. So
Exactly.
and I don't know why the defense or the prosecution's just sitting back and letting this poor detective swing on the line like that.
Well, and I agree, Zizi. I absolutely agree. That it shouldn't be, and the prosecutor should be saying something, but maybe on the recross that he is gonna say something, and hopefully, well, that's the hope anyway. But I just don't understand because he keeps focusing about the food. What was has the food has to do anything with
So
anything?
what, yes, so what the defense attorney is doing, and very wisely, he's just getting it in front of the jury many, many times that the guy was not in his right mind. He was food deprived. He was fatigued over and over. He's being allowed to do this. The judge isn't saying move on, and the prosecution is not going object, asked and answered, object, ejection, badgering, and, there's just all sorts of ways they can stop this, but they're just letting him run with it like over
Yeah.
and over and over. They must think it's a weak defense, but he's getting it in front of the jury over and over.
Well, yeah, that is true, but it's also true. But the detective also said, but he could have asked to stop. He could have said, like, "I'm too tired to do this. Can we do it another time? Can we do it later? I need some rest. I'm too tired. It's just been too traumatic event." He could have just said, we'll do this later," kind of thing. He could have controlled like that.
Yeah,
Because
yeah.
if he was so calm and collected, who is so calm and collected? Because he was saying that he was not shaking, no, he did not resist the arrest, and he was all cool and everything. After almost unaliving someone, I would be a freaking case, you know.
Yeah. I think, because there were many arguments over years of these neighbors not getting along. I think that the animosity had just built up to the point where, and the guy was fatigued. Obviously, he was tired, but he knew he had a gun, so it was beyond, right? It's beyond because he shot him 6 times, and there's just no way this man is wriggling out of this. So
But do you think that maybe because he was too tired, then he thought that something was happening more than he actually was, and made a bigger deal out of it than it actually was? Because
no, I think
if he was too tired, he probably thought that Kyle was going to attack him or something, and he did in self defense. But then that's not the victim's fault anyway, and that was not the case. No.
Right, right. Well, the whole thing is if you were too tired, so, the impetus wasn't the shooting. You're too tired. You shouldn't be out there plowing, so,
Or
that's
carrying.
not, that doesn't stand with me. I would just, blow that right up because if you're too tired, then, but if not for you plowing when you're too tired, if not for you arguing when you're too tired, and if not for you, with all this animosity carrying a gun, then this guy wouldn't be walking around, with all his injuries now, So all of this is, if not for this guy shooting, and not only shooting, but shooting 6 times.
Exactly, because if it was one time, okay, I think there was another case that was exactly the same thing. PPing one time, that's fine, but now more than one time, especially if the person is already on the floor because of the first one, right?
Right.
You would not need to do it anymore. You could have just called 911 and say what was going on, but now going and carry on doing it, that is just. But then
Yeah.
again, I don't
Well, not
think
only that, you got
Yeah.
6 shots and this guy lived. You ought to go to jail just for that. You had 6. You're a bad shot. No more gun for you.
I was like, I don't know, but I think the state in a way, yes, he has proved something has happened, but he hasn't proved what led to this, because they were saying about some dispute or whatever. The daughter, the victim's daughter, didn't testify much to a dispute. The bunny girl, sorry, the bunny girl.
Yeah, the bunny girl is the defendant's daughter.
Yes, exactly.
Yeah,
She
so
is.
so the victim's daughter, right? This poor guy walking around, his life is altered forever.
Right.
His daughter's up there, no bunny, no friend, no, battery. Who remember was Stacy with the battery, an emotional support
Stacy with the battery.
she didn't have anything. And the one whose dad did do the whole, almost, assault with a, she needed a rabbit. She cried. She couldn't remember the event, like she went to Vietnam or something, for Pete's sake.
I know, but it was interesting the fact that she with the defense, she did you hear about the fact that she came in and said, "Hi, Mark, how are you?" It's like
Yeah.
you
How
knew
nice.
the defense attorney, and with the defense, he literally remembered every single thing. With the prosecution was, I don't remember.
Right.
So I know she was a defense, a prosecution witness, but I think she was a prosecution witness reluctant that she was one.
Right. Well, when you're subpoenaed in the United States, you don't have a choice. You have to show up.
Exactly.
But I
you either
would have
go
put,
or you go to jail. Yeah.
I would have put her at the end, because they say you lead with your best and you finish with your best, and everything in between fills in the lines. So I would have led with the daughter of the defendant, because she was absolutely goofy, and it was absolutely unbelievable that you can only answer one side. Juries know this, right? I mean,
I know they know this exactly. Yeah.
yeah, so then I would have finished with the other daughter, who was shaking and crying and tried for both sides. You could tell she was genuine in her attempts to fill in the answers, right? Honestly. And those would have been, your slam dunk. And all this other this poor detective is looking at the prosecution table like, help me out here. Yeah, he said several times, I don't think this is relevant, which means they should have objected to relevance.
Exactly, but the prosecutor, I don't know if he's sleeping, if he's in another planet, but it's just, and this is what is causing me as well. That video, right? We wasted half an hour of our lives watching a side view video again.
Right. Not only did we waste half an hour of 27 minutes of video, it was the 20 minutes before as they were playing the video to get it.
It was absolutely pointless, that video. I did not see the point. Oh, yeah, fine. Well,
okay, bye. Okay. Bye, honey.
Bye. Nice to talking to you.
All rise, Jerry Antrim. Please be seated.
All right, counsel, you may continue.
You know, in your interview, towards the end, and I've been asking you, like, why didn't you reconnect with him when he slept? Let's get the page. He indicated on page 152, we're already up to 1:47:40 a.m. So he's been in there quite a while, right?
Yes, again, the whole interview was about, well, my whole response was about 3 hours and 48 minutes, give or take.
Did you ever indicate to him that this was not the end-all and be-all, and that you can always touch base again? Page 150, line 21.
Yeah, so I said, and this isn't the be-all, end-all. If you think of something after, we can always touch base again, but we'll take another break. And he goes, yep.
Take another break. He basically says he needs a little rest on 151, line 23. Right?
Yes, that was near the,
And Levesque puts his head down on the table.
near the end of the interview, yes, he put his head down on the table.
He's exhibiting exhaustion, isn't he?
Yes.
He's not saying he wouldn't talk to you again. In fact, he kind of dangled it out there.
Yes, I indicated that he could reapproach us and talk to us. Again, if he's tired, this might be the only opportunity that we have to speak with him. Once this hits the news, once he's arraigned, once he has an attorney, there's a very low likelihood that we're ever going to get another chance to speak with him. So, yes, I did speak with him.
I know he did. And again, he made no invitations afterwards.
Again, it was said right there, the line you had me read, that this wasn't the be-all, end-all. If he would like to speak with us again, certainly we can reapproach.
Or if you would like to speak with him.
If there's other questions, yes, that we had.
And again, you didn't ever send out that invitation, did you?
I did not know.
Now, he's repeated to you on a number of occasions that he's trying to give you the best description that he can. I mean, I'll just I can go through a number of pages, but I'll just randomly pick one out. Page 117, starting at line 11.
So Mr. Levesque says, yeah, I've been completely honest with you about the whole thing to the best of my knowledge, to the best of what I can remember. That being said, I don't remember correctly, or I'm not giving the right account of it, but it's hard to try and give the best description of it if, you know what I mean? Like, to break it down slowly like we did.
Right. And you said, yeah, like I said, and he says, I'm being completely honest with you, this is on 118. You say maybe the first story of events, like maybe you're just still in shock, right?
Yes, again, it's offering that save face opportunity, that maybe he wasn't telling the truth the first time, but here's your opportunity to tell us what had happened.
Well, maybe the truth is a little hard, don't you think, detective? Maybe he wasn't being completely accurate because he was exhausted too, right?
Tiredness could certainly have an impact, yes.
And in fact, you told him, so you weren't trying to mislead us or lie to us or anything like that. And Levesque shakes his head no. In fact, you continue with him and you say, I don't think, again, I think you're intentionally lying to us or anything like that. I think it was just, an honest mistake, that first version of events, and Levesque goes right. And he sticks with you and he says, let's go through it again, basically, right? I mean, he's telling you, take my video. He brings it up to you, right? On 118.
So on 118, he goes, if I wouldn't go, hey, I have some video of, and again, the whole situation, like.
Yeah. He's trying, right?
Trying to what, sorry?
Be honest and complete with you.
It's totally speculative.
He's telling you that, and you're telling him that on page 119.
What his claims are concerning his honesty versus whether it's being
Oh my days, there might actually be hope after all, because he is actually objecting. My days. Relevant, ask and answer, put it all in there. Yeah, it is. But then the thing, case one, like me and Zizzy we were talking, is if he was so tired, what he was doing out there, and why was he carrying? I've never wanted a trial to be done and over with like I want this one to be done and over with, because this defense attorney, the judge just needs to move on, man. It is 25 to 4 o'clock. I don't know what time they're gonna finish today, court, because it's good as guess as mine. And he's still on this, and we still have the recross to get through. Oh my days, dude! I'm done with this trial. Move on. Like, oh. And now it's out, and then we get good trials, and then I thought that this one is gonna be interesting. I thought a snowplow incident, a neighbor, I thought it was gonna be a bit more spicy, but now we're discussing here that he was too tired, and the food that he ate or did not eat when he was being questioned. Oh, just move on, Mom.
Let me ask you next question. You told him that the most important thing in his life was his daughter, right?
Something to that effect, yes.
And he agreed, right?
Yes.
And this is the same daughter that he had articulated concerns about during this whole interaction.
Yes.
Same one he picked up that evening, and the same one that was in the cab while they were being approached by Kyle Violette.
Yes, while he was being approached by Kyle Violette, she was in the vehicle, yes.
Was there other procedures that took place that he was cooperative with that night? I'll go through a couple. Fingerprinting?
Again, I didn't do the fingerprinting, so I'm assuming he was cooperative, but that's only an assumption. I can't tell you that for certain.
But there were no reports that he had any problems with any of the police officers that he...
I never heard of him having an issue with fingerprinting.
I could have 1 second.
Yes.
Thank you.
Counsel, redirect?
You had been asked about tactics for interviewing, interrogating people. What's the objective of any tactic that you use?
To receive an accurate, honest answer.
And is it included in your tactic to determine whether or not somebody's being straight up and honest with you?
There's definitely some consideration. You're interpreting what they say and trying to determine whether they're being honest, yes.
Well, let me put it this way. Would you lay out all the evidence in an investigation before you ask somebody questions about their claims concerning events?
No, it's actually better to let people continually tell a lie. That way you have more foundation to basically cross some of the statements that they're making to determine what's accurate, what's not.
Similarly, do you think it's a good tactic to get honest and complete answers and to test credibility by affording a suspect an opportunity to, for example, consult with other people, review evidence that they may have available to them before approaching them to question them?
No, with that being said, though, certainly give them the opportunity if they want to confer with an attorney or a lawyer. But as far as if they're willing to talk to us, we're going to ask the questions and try and get the accurate information, yes.
And in fact, we'd refer to Miranda. Did you give him an opportunity to consult with a lawyer before talking to you?
Yes.
And did he waive that right and agree to talk to you?
Yes.
You know, concerning his fatigue and whatnot, was he accurate, for instance, in describing where these events occurred?
Yes.
Was he accurate in describing what he was doing, his activity prior to these events?
Yes.
Was he accurate in describing certain very specific details, like Kyle putting on a hoodie that was green or camo walking out of his driveway?
Yes.
And was he accurate in terms of disclosing to you how many rounds he shot into Kyle Violette's body?
He was accurate on how many shots he fired.
There were some other things, though. Attorney Sisti asked you about a section where you're saying, I believe you're not lying to me. Were you sharing your opinion about his credibility with him, or was that a tactic?
Again, it's a tactic. My opinions on the matter are kind of irrelevant. We're trying to figure out, you know, the truth of the matter. So giving him, again, outs, giving him some belief that we're believing what he's saying is another tactic, basically, that you can use.
And that point at about 151 in the transcript where Attorney Sisti was asking you questions where you're sharing, I don't think you were trying to lie to us. Is that after you had disclosed that you actually had seen and obtained a video of this scene?
I believe that was after we referenced the video. I'd have to see what page I talked to the... 1 second. Presumably saying it's near the end of the interview, or interrogation, rather, I would say yes.
Can you take a look at approximately 99, line 24, where it appears to be the first time you actually call him out and say, would it surprise you that you were actually moving towards him after he claimed that he wasn't?
Yeah, so I asked, would it surprise you if you had moved towards him? And he asked, would it surprise me? And I responded, yeah. And he goes, and then I go, or to your recollection, you were pretty stationary with your feet. And Mr. Levesque responds, I don't believe I did.
And at that point, when you say, would it surprise you that you were actually moving towards you, is it at that point about that you had had an opportunity to review the first video?
Yes, I would have had, let me see when the break was. Do you know what page that I stepped out of the room?
I do.
Just the context.
You know, I'm sorry, with our current technical shutdown, I was unable to print out that section, but when you refer to would it surprise you, how would you know whether he was walking forward or not?
Yeah, so I mean, that's an indicator that I likely had watched the video at that point, if I'm referencing that in that kind of language.
Attorney Sisti pointed out something at about page 90, whatever, that the defendant brought up cameras. But can you turn to page 66?
Yes.
And 30 pages earlier. Page 66, line 18. Is that you asking, do you have any cameras that can cover any of the interaction tonight?
Yes.
Is that you bringing up potential video footage of this evening in the first instance?
Yes.
Let's talk then about some of the details that came up here. The Attorney Sisti had asked, suggested, frankly, that Mr. Levesque didn't have any idea what was going on when the victim, Kyle, approached. Can I direct your attention to page 18, line 8?
Okay.
I think at one point you had started to share this information that Jason Levesque had acknowledged. Can you read what it is he said he had done just prior to Kyle coming out?
Yes, so Mr. Levesque says, I drive, started moving the snow. I had moved the snow into the front part of the driveway of my neighbor to where my neighbor's grass is, and I backed up. And I'd gotten out to put it in four-wheel drive. It's the old style manual hubs. You have to lock them in.
Okay. So he characterized where he had just put snow and that he was continuing this job of moving snow from his driveway by back pulling it into the street.
Correct.
We don't have any, again, I don't want to nickel and dime this, but we don't have any idea where he was going to put all the snow that came out from his driveway.
No.
And this, we talked about it, but this conditional threat, I want to be clear on this point. Can you had confirmed earlier that Jason Levesque stated this was, quote, in his own word, verbatim and exactly what was said. That's at page 36, line 18 to 20. Can you repeat that?
Yes, sir. So Mr. Levesque says, yeah, he said, if you put that fucking snow at the end of my fucking driveway, I'm going to fucking kill you and kill your fucking family.
Concerning, you revisited that, and did that ever change in terms of him predicating his threat with moving the snow again in front of his driveway or his house or his property?
To my understanding, the threats all the time were regarding the snow removal.
And at any point, did, I get, these words, and your family, at any point did Jason Levesque claim it concerned specifically, and I know that daughter's included in a family, did ever specifically mention his daughter as part of the threat.
Not that the threat was specific to his daughter, it was to your family. He did bring up, or we did discuss his daughter at one point during the interview, but the threat itself was your family.
And did Jason Levesque ever claim that Kyle focused his attention on Kira in the cab of that truck?
He did not.
Did he ever claim that Kyle Violette was even aware that Kira was in the cab of the truck?
I don't believe he brought that up, no.
This description of him being nose to nose and making this threat kind of in his face, and he was overwhelmed, is that the point that Jason Levesque shot Kyle Violette?
No. Kyle had walked away from Mr. Levesque prior to that.
And after he walked away, page 43, line 16, can you share with us how Mr. Levesque characterized the continuing, I guess, conversation?
Mr. Levesque says, I don't know if he repeated it again before he started walking off. And then for some reason, he stopped and turned around and said, you don't fucking believe me? And he came back at me again.
And his claim about how far Mr. Violette came, does he share that? Is that where he's saying he's within 3 to 5 feet from him?
Possibly at one part of the interview, not
Okay.
close temporarily to that statement.
The questions then about, accuracy. We had already talked on our first direct that he had claimed he shot him, didn't know whether he hit him the first time because he only flinched.
That's what he said, yes.
Okay. Did he appear, sort of overwhelmed by fatigue when he was making that statement to you? Or did you ask for details surrounding that event?
No, I asked for details for most of the interactions that he had with Kyle that night, so I would go into further detail. Once he made a statement, I would clarify, ask for more detail.
And likewise, when he made claims that he put 5 more rounds into Mr. Violette, and Mr. Violette merely turned and walked away, were you able to ask details that he was responsive, questions about details that he was responsive to?
Yes, and he told me in a gist that he had continued to walk away holding his abdomen.
Locked. Concerning, some of these questions, follow-up questions about details, did that include asking him to do a sketch?
Yes.
Your Honor may approach.
You can go in and spoke.
With the strike.
2728 are full exhibit.
I'm going to show you what's been now marked as a state's full exhibit, 27 and 28, and ask whether you can identify that.
So these look like copies of the drawings that I asked Mr. Levesque to draw when the first shot went off and then the second round of shots that went off.
And so you've labeled these first and second. Is that what you mean by first round of shot and second round of shots?
They're labeled first and second. That might be his handwriting. I might have asked him to label it.
That's what I mean.
Yes.
And so can you just, for the record, state to the jury where Mr. Levesque claimed he was standing, to describe it by other aspects of the drawing, during the second round, and where he claimed Kyle was standing?
Yeah, so based on the drawing, it looks like Mr. Levesque is towards the driver's side front, well, it's the side, but it's near the front tire on the driver's side. And then Mr. Violette is closer to 41. like halfway in the drawing there.
And, you know, the defense attorney, Mr. Attorney Sisti had asked you about this area where, Jason, after you said, hey, look, I've seen some video, maybe you're mistaken. Maybe there's some gray area here. Is it your recollection that any of those mistakes, that Kyle remained standing, that he didn't react to being shot the first time, any of those mistakes sort of favor a claim of self-defense?
I'm going to object.
I'll withdraw. Sir, those are my questions. I appreciate it.
I sure do, Judge, and I'd like to approach first.
Sure.
Chili no carne. That's a new one. I love it. And hey, Nancy, hello. Good afternoon. How was your vacation? Did you go anywhere nice? I'm hoping everything is okay with you. Thank you for joining in. We are following this case. We started after Stacy Rodriguez one, but it's been a little bit of a snooze fest. But I think we are coming to an end of the prosecution's case. I don't think defense is gonna have any case or small case, because the judge was saying that he was expecting to wrap it up tomorrow. So yeah, it's been. I am on the side of hung jury right now. To be fair and honest, for this trial, I still haven't heard 100%. Like, yes, he did. Like, there's plenty of evidence that he did repute the victim, but yeah, I just yeah. That's awesome. Ah, that is awesome. I'm sure you're very proud, Grandma. Oh, that is awesome. Did you go to the Space Needle? That's the only thing I know about Seattle. And Grey's Anatomy, but that's a fiction TV show. So yeah. Dallas Cowboys, Dallas, Texas. But that's nice. Oh, I'm glad that you had a very good time. We just also I'm keeping an eye on our new trial to like see how the sound is and everything, but oh wow. So I'm just trying to check on that new case as well. Oh wow. Oh, definitely need a rest day today. Just chill and rest. Put your feet up, and yeah, definitely a red eye. It's always hard. So I'm expecting that this trial finishes tomorrow, with the verdict watch and everything tomorrow. Well, nothing much, Stephanie. Nothing much interesting that does happen. A snooze fest. My thoughts is he did it. Like, yeah, there's plenty of evidence. but I don't think there is evidence to convict him on a charge of first degree attempted unaliving or second degree. So, I don't know. I think it's gonna be hung. It's been a snooze fest. I thought it was gonna be a lot spicy. They keep taking breaks. They keep breaking off early. They keep having problems. They keep yeah. He could have walked away. So it's just Oh yeah, Zizzy, Stephanie Zizzy called in, which was awesome. So it's been a snooze fest apart from the fact that Paula, Zizzy, and Pickles called in today, which was amazing. So we have a new thing that you guys can call in into the channel through StreamYard. I shared the link. You guys just click, come on with no camera. If you don't want to, you can have camera if you want to. It's up to you. But yeah, that's a new thing we started today. But apart from that, not much more.
Sir, the fact of the matter is that Jason brought up the subject matter of the video cameras early in your interview with him, right? I'll refer you to page 25.
Thank you. Yes.
Right, and that's why you knew to ask him about cameras, see page 66, right? Line 15.
Yes, I asked him about the outside cameras.
Yes, you asked him. You mentioned from the prior event from 2 months ago, there were cameras out there, right?
Yes.
Okay, so you didn't come up with this request out of thin air. He already gave up that he had video cameras much earlier on in this interview. Right?
Yes.
Now, would you agree with me that Jason was accurate when he claimed that Violette initiated the contact on April 4th?
He's the one that walked across the driveway yelling out to Jason, yes.
Okay, so that's a yes. And would you agree with me that Violette stuck his face into Jason's face?
I would agree with you that he got very close to him based on the video that I saw, yes.
Would you agree with me that Violette appeared to be agitated?
Yes.
Would you agree with me that Jason said that after the event, he parked the truck, stayed there, and waited for police response?
Yes.
Would you agree with me that he left the firearm and he left it safe on the dashboard of the truck?
I would agree with you that he left the firearm in the truck.
Now, he never told you that he was able to specifically count the number of rounds that came out of the firearm. It's just that the magazine was empty, right?
He told me at one point that he had 5+1 and that he emptied the magazine.
Right. So it's a matter of doing math, not specific recollection of each trigger pull, correct?
I don't recall if he ever specifically said. I'd have to look if there's a page that you're referencing that would be helpful.
I don't have a page.
Okay.
Now, you know Kara Violette was a witness too, right? You know his daughter was a witness.
Yes.
And she was interviewed, right?
Not by myself.
No. But do you know whether or not she was sleep deprived or anything like Jason was?
I do not.
Do you know what she claimed to hear?
Objection, Your Honor, calls for hearsay speculation.
I'm not asking for the answer. I'm asking whether or not he knows what she heard. Yes or no?
Objection to roll.
Any further?
And another sidebar. Sidebar 500. Oh no, I'm so sorry, Paula. We keep distracting you, huh? It's weird about the influences. I'm just taking a peek at the new trial and the sound at the moment that one of the attorneys is talking. Oh my days, is so good. It is so good, the sound.
You do understand that Kara is a witness as well, correct?
Yes.
And again, you never approached her and interviewed her?
Judge, same objection.
I'm just asking whether he did this. Thank you. And I looked at your entire transcript. Did you ask Jason if there were any other threats that night? Any other threats? Other than the ones that he had related?
I don't recall.
Did you ask him, instead of speculating about the snow, did you ask him where he was going to plow the snow?
He had brought up, as far as the initial where he moved snow, as far as he said he was going to back drag the driveway. I didn't ask him where that snow was going to go, no.
No, but wasn't that a big subject of contention, that the snow was going to go over to Violette's driveway?
That's the initial reason why Violette came out.
And that's a question you never even asked Jason, as to where he was going to plow the snow.
That doesn't necessarily change as far as
Sir,
what...
sir.
You can answer.
No, he can't. He's not being responsive.
I'm not arguing, I'm not arguing. Allow him to answer the question. So if the objection is overruled, you can answer the question.
Answer the question.
Can you ask the question?
Was, did you ever ask him where the snow was going to go, basically, correct?
Correct.
Yes, no question.
No.
Thank you.
Anything further?
Just very briefly.
Well, it got a little bit spicy there. They are not happy. The defense attorney, it's finally is not happy. Well, it was since when is happy. But sorry.
All right, I will allow some latitude, counsel, just, I understand, very short.
Thank you.
Reading direct.
You would ask for a page number concerning, whether Jason Levesque was aware of how many times he discharged the firearm. I'm going to ask you to look at page 54, line 16. Question.
So I asked him, okay, do you remember how many times the trigger was pulled? And he responded, yeah, 6 times.
Thank you.
Any specific questions directly to
I will go right to it, Judge. Did you ask him how he knew?
So I asked him after that, okay, so you fully emptied the clip at that point? And he nodded his head in affirmative. I can't answer that question. I don't know what was on his mind.
Thank you very much.
Thank you, Your Honor.
Appreciate it.
And I think the detective is running. Well, he's not running literally. He's literally walking like slowpoke, but he just wants to get out of there, and I don't blame him. I think the judge is gonna end here for the day, and we're still not gonna be finished with this case tomorrow. Oh,
Yeah, no worries. See you soon, Nancy. Thanks for popping in. Thank you, my friend. I'll see you very soon. Yeah. I think.
State, do you have any further witnesses to call?
Your Honor, based on this evidence, the state rests.
Okay. So ladies and gentlemen, if you recall back in my initial instructions when I explained to you how a trial was going to go, I explained to you that the state puts on their case first, and when the state is done presenting their evidence, they then rest. So the state has now rested. As I explained to you previously, the defense does not have to put on a case if they do not want to. It's the defense's decision as to whether they will present any evidence at all, because the burden rests on the state to prove the defendant guilty beyond a reasonable doubt, and the defendant doesn't have to prove anything. Given that it's 4:05 at this point, I think we're going to end for the evening. So we'll leave you in a bit of suspense, and then we'll see in the morning when we come back. That's when the defense will decide whether they are presenting a case or not. Again, as I explained, it's completely up to them. It's their choice. And then the case will proceed forward after that, as we explained. So, have a good evening. All of my prior instructions remain in place, which I've said to you multiple times. I'm going to say them again. Do not talk amongst yourself or with anyone else about this case. Do not do any independent research about this case. Do not view any media coverage about this case. With that, have a good night. Thank you for your attention. Your excused.
All rise, jury exiting.
Well, actually, I have some other things I have to attend to. I'm not sure we can start. I was about to suggest maybe we try to get the arguments in on what we dismissed earlier than that, but I don't think we can.
I think I brought up the added wrinkle that a medical point.
Yeah, so 10:30. We will begin with arguments and then move on to the defense case. Thank you. Very good. Thank you. Have a good night. Thank you. Research about this case. Do not view any media coverage about this case. With that.
1 second, guys. I was saying what he was. No, he's not on board. Case one is in jail. He's not on board. I just wanted to see it. What time did the judge say? Because I got confused.
Well, actually, I have some other things I have to attend to. I'm not sure we can start. I was about to suggest maybe we try to get the arguments in on what we dismissed earlier than that, but I don't think we can.
I think I brought up the added wrinkle that a medical point.
Yeah, so 10:30. We will begin with arguments and then.
Oh my days, 10:30. Are you absolutely joking me? Oh, this court is really getting to my nerves. Oh, if it wasn't for the fact of my perfectionist side, I would just drop this case and move on to the new one because I'm tired. 10:30. That's literally a waste of time. Literally, the other case, right? The one that we are waiting for, the North Dakota one, starts at 10 a.m. Eastern. So the new case will already be a half an hour ahead when this. Oh my days! I don't know how this court does this. It's absolutely insane. It's absolutely insane. And the thing is, we're gonna have the motion to dismiss. We're gonna have the quality about him testifying or not testifying. We're gonna have him. They say if they are presenting a case or not. So I am not seeing closings being tomorrow. It's
I am so frustrated right now about this, guys. I am absolutely done and over with, guys. Sorry, I'm really frustrated. Give me a second. I am absolutely beyond frustrated because this is joking with people's times. Not mine so much because I always have the option of just not doing it, and everything. But there's other people, the AKA the jury. mm, I am done with this case. What we can do is do an hour in the morning, come an hour early and do start the new trial, and it's just, oh yeah! What? Are you serious, Lois? Are you absolutely serious right now? I was gonna ask you earlier, but then I forgot, and then we start talking about something else. Well, wow. My days. That is late. That is absolutely ridiculous. My days. Uh, that's wow. Wow, that is absolutely insane. Um, I I'm gonna put. I'm trying to change the time on the stream for tomorrow because I've already had put one time, but I need to change it. That is absolutely crazy that he only shows up now. So and he's like, oh, yeah, the land of Mañana. I honestly am not seeing this case going to jury to deliberations tomorrow. I am not saying that. Not in a million years. By the pace that they move, there is no way. There is absolutely no way that this case is gonna go into the hands of the jury tomorrow. I'm not saying it. Who thinks I'm wrong? Um because I don't think it is going to. Absolutely do not think that it is going to the jury hands tomorrow. It's it is crazy. But actually, I don't know why I've already closed choose better the trials that we follow, guys. I'm really sorry about this. I definitely chose not a good one. Um so I doubt it too. I absolutely doubt it as well. Um So what? Hang on, sorry, just watching something. I want you two guys to give you a bit of a taste of our new trial, cause it sounds very good. Oh well, give you a taste of our new trial. They are on break. Lol. Hang on. Oh wow, this actually we can actually follow this. We can watch it because it's not that much. Hang on. So it's 20 minutes because they started with a motion outside of the presence of the juries. See you tomorrow. Stephanie, love you, thank you. So show you what I was watching in the background while they were like not talking currently. There you go. So this is the new trial.
Personal reasons, and I do not take any joy in doing this right now, Your Honor. This was hard for us to make decisions on how to do this last night, but this is such a serious case, we have no choice. In going through the report, there are incredibly disturbing details. There's discussion of deleting emails, deleting files. There's recommendations from the firm that went through this that the entire office needs training on Giglio, and I'm summarizing what I've seen, but it goes on to say that lying is part of the daily course of business at the Minot Police Department, on and on. And again, I'm summarizing because I don't want to go through the quotes, which I assume Your Honor has looked over here from that report. But it's an absolute bombshell. Detective Asham is not only the case agent in this case who's on the trial team and sitting through this, she was the lead investigator on this case after Detective Talbot left. And as this comes to light, I'm sitting here on my phone seeing that Rob Port has published this report independent of our filing of it based on a FOIA request he did at, I think, 12:09 today. It begs the question for me when the state knew about this, when Rob Port got this. I know there were redactions that were done. The fact that it's such a bombshell and it was disclosed to us yesterday, moments before trial. I actually disclosed to us, I know there was the phone call on Sunday saying there's some impeachment evidence regarding Miss Asham. Honestly, our arguments for dismissal, we believe, are completely valid on every front, all three arguments. This one we thought was going to be our weakest, and we now believe is absolutely our strongest, based on the incredible things we're reading in this report. And it's a thick report. I know it's 57 pages. It's top to bottom. It's incredible. There's accusations of rape. There's accusations of incredible things. And I know we attached it last night. I know we're moving and grooving, and I don't know how much Your Honor has had a chance to review it. But
I made that clear. I've read it all, so
okay.
we may continue.
I didn't hear you say it, Your Honor. I apologize. But first of all, it would have changed our entire jury selection process to talk to people about police misconduct, how they would judge officers, especially officers that are sitting here, if they lie, if they cheat, if they destroy evidence. Again, in reading this, Detective Asham is the one referenced in our Exhibit 1 with the email chain I have with Ms. Sorgan, that it sounds like it kept the CD in this evidence room or whatever they're calling it. It doesn't sound like it was in the normal course of the evidence file for the Ward County State's Attorney's Office. And then I flipped last night and I'm reading that she's texting about destroying emails and files. It's incredible, Your Honor. And I don't know, first of all, I know that the state in one of their prior arguments had talked about a trial by ambush from us based on one of their motions. I can't think of a bigger trial by ambush than what's going on right now. We're getting disclosures regarding the case agent and lead investigator in the case at 7:09 a.m. the morning of trial that blow up the entire police department, that blows up the credibility of their case agent and lead investigator. There is so much work and so much investigation this creates on our behalf that I believe this rises to the level of dismissal. Obviously, we've requested alternate relief in case the court doesn't believe that dismissal should go forward. I'm not going to get into my other arguments regarding the interview with probable cause and the Brady violation. I think they're incredibly important, but I don't want to take up too much of the court's time. I also let the court know in our brief that we did this last night after dinner between then and 1:30 a.m. We were as thorough as we could be. This thing could be 50 pages long, Your Honor. We sat in a hotel room all night putting this together and finally just decided to kill it at 1:30 in the morning. We could have gone until 5 a.m. It's a bombshell on proportions that I cannot describe. I had no idea this was going to happen when we were meeting yesterday. The primary basis for everything we discussed was the Hall interview. As I got into this, I was blown away. I've never seen anything like it in my career. It's the kind of stuff you read about happening in other states. As we speak, articles are being published based on FOIA requests that happened. I don't know when. And I'm just downloading and trying to digest this information. And it's appalling and incredible to me, Your Honor. And I asked that the court on all three motions dismiss this case. I ask if the court doesn't dismiss it, that it grants our alternative relief. But I will end by saying, Your Honor, we have done everything we can in this entire trial. We have done everything we can by the book. We have worked with the state's attorney's office, and we have been hit with discovery right before trial again and again and again, and this is the final blow. This is a sledgehammer. In November, we got information regarding newly investigated bug reports that weren't done prior to charging, right before trial. In February, we got hit with another discovery bomb when my brother was sitting there doing the hearing, when the court closed discovery, I believe, on March 4th. Then we get this interview on Friday. Now we get this investigative report that is an absolute bombshell, and I have never seen anything like it, at 7:09 a.m. on Monday, the week of trial, the day of trial. I have not been able to go through it in the depth I would like to. We were racing to get this done yesterday, and like I said, Your Honor, I'm absolutely appalled. I've seen nothing like this in my life in practicing law. I'm sitting here as we're doing jury selection, watching the news come down, front page, front page, front page, from Rob Port on this FOIA request. My guess is this report's about to go national, and it's not because of me. And I'm concerned about what other disclosures are out there. We got this because Rob Port did a FOIA request, and thank God he did it just in time. This is happening over and over again. It's becoming a course of practice, and it's absolutely blowing this case up. And Nicole's family has spent so much money and so much time on attorneys and travel, expert witnesses that are scheduled to come in this week. This is an absolute abortion of justice, Your Honor. And I don't like to get this way. I'm appalled. I've never seen anything like this. That's all I got.
All right, thank you very much, Mr. Sand.
Thank you.
Ms. Sorgan, do you wish to reply?
Your Honor, as set forth in the state's papers, I'm not going to reiterate what was put forth in our filings on there, but I will address what Mr. Sand has just indicated. First off, I don't even know who Rob Port is. And so he is not the reason that they received their report. We are. We provided it to them as soon as we got it. Now, Mr. Sand's probably going to take issue with that. This was sent after hours to myself and Mr. Nelson on Friday, after hours, as we were preparing to come here. Mr. Nelson got alerted to it while he was driving on the road on Sunday to come here, called Mr. Sand immediately after that. He called Mr. Sand before he called me. I found out about this after Mr. Sand did, Your Honor. Upon checking this, making sure that we could even get at the email with the Wi-Fi situation, it was then forwarded, which the earliest that could happen was Monday morning at 7 a.m. And my apologies for how that is late, but unfortunately there's no opportunity to have changed that, Your Honor. It was not in our hands until later in the afternoon on the 14th. And again, because of the email and preparing to come here and getting it all together, it got forwarded as expeditiously as I possibly could on that point, Your Honor. As to this February discovery bombshell, I think we established that at that February hearing. It was 2 copies of digital maps that were sent over as part of the Axon transfer with the information. The interview on Friday, I addressed that in our papers, Your Honor. I'm not going to go into that any further. That's information that was available to the defense, could have gotten to the defense had they bothered reviewing their discovery before that and determined that it was an empty file. Could have been done within due diligence, and I addressed that in our response to their allegations on Brady. As to the blowing up the credibility of our case agent, credibility is an issue of the jury, Your Honor. I don't think that this report blows up her credibility. Mr. Sand wants to cross-examine her on that. That's his option. He can do that. I've set forth when the state knew about this report. I can tell you when Mr. Nelson and myself knew about it, and that's exactly when. And I would like to reiterate, Your Honor, that Mr. Sand is arguing that this report implicates Sergeant Asham throughout. Please note, this is a report regarding Lieutenant McLeod. Sergeant Asham is mentioned in it tangentially with regards to a relationship with McLeod and inappropriate behavior on McLeod's part. Information that was contained therein that may pertain to Sergeant Asham, again, that's something that can be either cross-examined on or, as we set forth in our paper, if the court wishes to allow for a pretrial deposition under Camp Rood for the defense, that's permissible, and that's the remedy that's outlined by the North Dakota Supreme Court. The conclusions of that report, Your Honor, again, are in large part due to the behaviors of Lieutenant McLeod. I can't reiterate enough that this report is titled McLeod Complaint Report. It's not the Asham report, as the defense wants to put it in their papers. It is the McLeod report. Thank you.
All right, thank you very much. Time is 3 minutes after 3, and the court's going to go off the record. I'm going to take 12 minutes, and then I'll be back.
Well, well, well. The good thing of catching up on something is we can move up quick to, um, yeah, we can literally jump ahead and go to when the judge comes back. But I'm really loving it this, and I'm loving the audio too. I need to think. I need to talk to
All
you
right, we're
guys as
back on
well.
the record. The time is 17 minutes after 3 o'clock. I took a few more minutes than I told you I would, but it had nothing to do with what I was reviewing. It had to do with another issue. That issue is the court has dismissed, let me find him again here. Which one? Yeah, the court has dismissed juror 44, which is Mr. Eric, for a medical reason. I did that on my own motion. So, as to the motions before the court, Mr. Sand, I very much appreciate your intense argument with regard to the dynamics of this matter. And so I'm going to try and address these on the record. I will follow up my response with a written order that we will follow sometime either today or tomorrow. But this is where we're at. On the failure to disclose the Devon Hall interview, this was an interview that took place back on September 10th of 2008. It took place in Wolf Point, which is, I understand, a town in Montana. This was an interview of Mr. Devon Hall. Devon Hall was a person of interest with regard to this case. It's my understanding that this was a follow-up interview, that a previous interview was done with Mr. Hall while he was incarcerated in the Ward County Jail within 2 weeks of the crime in this case. He was, at that time, specifically a person of interest. He continued to be a person of interest throughout the investigation. It is my understanding that the follow-up interview that was done is the one that's of interest here, and that, if I understand the dynamics correctly, that the defense did have this interview in the sense that it was disclosed by the state, that the file that they disclosed was empty, as was the file that the state had. It then went from that emptiness, once it was discovered, to tracking it down, that it was being held somewhere else, in a more solid form than on some kind of digital platform. But it was disclosed back in May of 22, so May 16th of 2022, when it was originally disclosed. I would also note that in a review of the preliminary hearing that the court did, that Attorney Becker, who was part of the team that was representing Ms. Rice, did in his cross-examination of the state's witness for that hearing allude to a re-interview to the officer that took place in Wolf Point approximately about a year after the original interview, which took place again in the summer or early fall of 2007. That would fit the time frame of the interview in Wolf Point in September of 2008. So Mr. Becker did not specifically say that interview or gave a date and time, but he did make reference to the interview being over about a year later than the original interview. So I don't know if it's the same one or if there's a third one somewhere else. That part's not knowledgeable to me. But I do find that the state, or that the defense did know about it. The fact that neither the state nor the defense knew that the file that was shared was empty. But again, I find that the defendants or the defense could have obtained that knowledge of it being empty and obtaining the actual interview with reasonable diligence on their part. So that having been said, in finding that conclusion, that would be, I guess, item 2 of the Brady review as to any violation by the state. So on that point, the court will not dismiss this case, nor will there be a remedy for the defense in regard to their motion. As to the second part of their motion, failure to disclose the report that was received by the state based on the information that the court has, sometime late last week or over the weekend, this report was the bombshell, as Mr. Sand described it. And then again, he lists this as a Giglio violation, again, that being reference to a particular case. The criteria for that is the same as Brady. It's just that it's expanded it from the evidentiary portion to actual witnesses. That the disclosure of the information that could be used by either party for the purpose of impeaching a witness is now part of that Brady review or the same criteria. In regard to that, the court finds that under number 3 of the Brady review, there was no suppression by the state. Also found that whether or not that information would reasonably change the possible outcome or make a difference, the possibility of a different outcome, the court does not find those as being appropriate in this case. The court would, however, allude to the fact that because that report came late, again, having nothing to do with this trial per se or the people in it, other than, as Ms. Sorgan said, the tangential reference to Officer Asham, the court is inclined to give the state some time, if they wish to do so, to do a deposition of Officer Asham in preparation for her testimony and your ability to cross-examine that. As to count 3, this is the request in regard to there not being sufficient probable cause. Again, this would be with regard to Devon Hall. The court denies that motion aspect also based on the court having reviewed, again, the preliminary hearing information, having reviewed the actual September of 2008 interview of Mr. Hall. The court finds that the outcome of the probable cause hearing, the preliminary hearing, would not have been any different. The information that was shared at that preliminary hearing is not changed or modified or in any way would have affected the court's decision at that time based on the hearing of that September 2008 interview with Mr. Hall. As a matter of fact, the court's thought is that it did nothing in addition. All the information that was shared at the preliminary hearing was sufficient for the court to make its finding, and that additional interview would not have changed that one way or the other. Again, I want to make clear that the court is aware that the current report having been made was specific to a Lieutenant McLeod, who was part of the Minot Police Department. And I will go with Mr. Sand's position that the information in that report is horrible, for lack of a better term. It's disgraceful. It's scary. I get all of that. But again, I don't believe that it is directly causal to this particular case, and I didn't find any connections in the report that would bring it to that level. What I did find is, again, credibility of the possibility of a witness, specifically Officer Asham, if I keep saying that right, I apologize if I don't, But that will be for the purview of the jury. Accordingly, the court will give the state an opportunity to depose Officer Asham. She will make herself available, and the state is required to do that. She will be available from this point forward all the way until 1 o'clock tomorrow. The idea would be, I know you need preparation work to do a deposition. I know you have to somehow schedule a deposition, and I know you will want to perhaps articulate a review once you've done the deposition with regard to her testimony. My understanding is her testimony is not until sometime next week as a possibility, but again, it may also affect that deposition may affect the possibility of other material witnesses in regard who may be a part of the police department. Again,
Can I ask you some clarification?
no, not at this point. Again, I do not believe in my review of that report that you're going to find that information, but then again, that's not my job. So I'll leave that to the defense to do that if they wish. That having been said, the court is still at this time, based on my denial of your motions, going to go forward with the swearing in of the jury today, and we will do opening instructions and opening arguments, and we will take the first two witnesses today. At that point, we will not be in court tomorrow morning. We will start court again at 1 o'clock tomorrow afternoon. Now, Ms. Sorgan, do you have questions?
Yes, Your Honor. You had indicated twice the state could depose Ms. Asham. Did you mean the defense?
No, I meant that the state would make her available. If I said the state would depose her, I apologize. It would be the defense would have the opportunity to depose Officer Ashton.
Just double checking,
The state would
Your
make
Honor.
her available.
Yes, we will, Your Honor.
I apologize if I said that. Mr. Sand, other than the look on your face, anything else?
I'm just going to maintain my objections, Your Honor, and I appreciate the court's decision, but I have to maintain my objections. There's a lot more work that this report calls out than just a deposition of one person, and due process is being violated for my client. That's all I have, Your Honor.
Okay. And I do appreciate that, Mr. Sand. And again, that will be your position. It's not the position of the court at this time. All right. Ms. Sorgan, anything else for this hearing?
No, Your Honor.
Mr. Sand?
No, sir.
The time is 3:30. I'm going to call the jury back in 5 minutes at 3:35. We will swear the jury in. We will then do instructions and opening statements.
Yes, Your Honor.
We'll be in recess for 5 minutes.
All right, so I think that was a very good taste of our new trial, and we're gonna leave it at that. I've already made a point that we are on opening statements, so that is actually gonna even help us. So, well, we could. Hi, Sandra. Oh, hello, my friend. How are you? Nice to see you. Sorry that we already kind of almost leaving. I know it's getting a little bit. I still don't know. I want to do both together on a slice and see both. The thing is, because there is this one, there is no this one, no tomorrow. What we can do, right? What we can do is we start the stream earlier at 9 a.m. Eastern, or just before 9 a.m. Eastern. Watch the. It's okay. It's absolutely fine, my friend. So thank you very much for popping in. I really appreciate no matter what. So I was gonna say is what we can do is we can start an hour earlier than the other court. Start at 9 a.m. around 9 a.m. Eastern. Watch the opening statements and the whatever we can until 20 past 10 Eastern, right? Watch this trial, talk about a little bit, and then before we start do Jason, and then when Jason goes on the deliberations, we jump back on it. Does that work? Because then we would not be too far away, and at least we would have something, and we can kind of do both. What do you guys think? Yes? No? Maybe? Yeah, sounds like a plan. Awesome. I need to
Yeah, it's of course, and I know exactly. You guys are absolutely fantastic. You support me a lot, and I really, really appreciate that. So we'll do that. I will need to fix the thumbnail for tomorrow, but I'll do that tomorrow morning when I get in. So I know the time. I need to change the time for the stream, at least that, so you guys know. Let me just do that, change the time. We'll do that. I've got exactly where we left off, and I will change the thumbnail and all the technical stuff that I need to do. I change tomorrow, so we'll start about 10 to 9 a.m. on Eastern, and then we do the recap, watched statements, and what we can do up until the fact. Awesome. That's an awesome plan. The time is changed for tomorrow, so we'll do that. I think we'll leave it for here today. It's been an awesome, incredible day yet again. It's gonna be great, and I'll see you tomorrow morning at 9 a.m. Eastern. And have a great evening, morning, wherever you are. Thank you very much for your support, and have an awesome day, guys.
And I'm a real-time crime professional.